Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And good morning. Welcome to Justice Served TV. Michael Bryant here. That's right. Do not attempt to adjust your sets. Linda, Kenney, Baden, and I doing a little bit of a switcheroo. She'll be along at some point. So good to have you. I hope you had a great weekend. Took a little time to relax, refresh, do something kind of fun. Hopefully the weather cooperated where you are. Not so nice here in the Northeast, but that doesn't really matter much because I'm going to complain now because I've been working all weekend. I got a massive deadline coming up in the next few days. So I've been working, crazy hours, nonstop. In fact, when we're listening to testimony, I might actually be working on these cases because they've got to be filed in the next few days. And by the way, when I'm talking about the Karen Read case, I start sprinkling in details about other cases, please ignore those things. Otherwise, I'll be breaching attorney-client confidentiality. But my mind will tend to be muddled. So that's my sad tale. It's a problem I'm lucky to have. I'll put it that way. So speaking of problems, on Friday when I was on the road somewhere just outside of Pittsburgh, and we had our Sidebahhh that night, one of the things I mentioned was, and I phrased it this way, after Dr. Wolfe testified, yes, great guy, wonderful, one of the ARCCA witnesses who was originally independent in the Karen Read case, determining there was no collision, and then was retained by the defense after the first trial, which was disclosed and, as you know, led to major issues and an attempt by the Commonwealth to get these witnesses excluded. At the end of Friday and Wolfe's testimony, I'm not so sure I wouldn't have minded his testimony being excluded as the defense. And here's why. I couched it that night as the defense did not have as good a day today, meaning Friday, as they should have. And now, after reflection over the weekend and clearing the cobwebs, I think it was not good. I think, and I'll give you the reasons for it. I think the defense now, through this expert, has answered some questions for this jury that may have been answered prior in favor of the defense that now may be answered in favor of the prosecution. And I'm talking about things like the glass being tossed at a tail light. And I'm talking about this thing being broken by contact with an arm at various speeds, as Rescue Randy, suffered the fate many times as they backed their exemplar Lexus into his arm at various speeds. And that thing broke. I didn't think, having broken one like this with a hammer like this, I really didn't think that at the speeds we were talking about, 24 miles an hour, give or take, that a human arm would break that lens. Well, the jury now sees that it's possible. Let me talk about the glass first, because I've seen a number of comments when we talked about it on Friday that that experiment was done when the FBI had hired the ARCCA boys, and they were trying to, suss out what it was that happened as an FBI investigator. I don't care why it was done, when it was done, how it was done. The fact is, the jury now sees maybe an alternative theory about the interaction between Karen Read, Officer John O'Keefe, the car, the glass. They now know it's possible that if John O'Keefe was upset, he took from the center console Karen Read's glass that she brought from the bar. If he was upset, they were having some fight, maybe she starts to drive off without him, and he's thinking that's really wasn't the plan. He chucks that glass at the car at 37 miles an hour, which is that's almost underhanded. You don't know how easy it is to throw something heavy like a glass like that 37 miles an hour. It doesn't take much. And we saw what it does to the glass and the tail light. So now the jury has kind of an alternative theory about what might have happened. What if he got upset? What if he chucked that glass at the taillight, breaking the taillight? She then, in response, backs into him and hits his arm. The rest is history. Does it answer all of the questions? No, it does not. But it lays out an alternative theory, and it answers a question or two that may not have been answered before. And, having talked to juries after the fact, whether it be in the trial I've tried or one I've covered, the things they latch onto, the things they focus on, the things that they find are more important will shock you. And it depends on who in that jury latches onto a nugget of information like this. If it's one of the sheep, it doesn't matter. They're going to go along with whatever the alphas ultimately tell them to do. But if it is an alpha that's going to be arguing a particular point or fact or theory, it can be very important. It could lead to a hung jury, of course, but it could also lead to persuading folks that something, answering the questions of guilt or not guilty, pushes in the favor of the Commonwealth. It's so dangerous. So I think my take now is from, boy, the defense could have had a better day than they did, to if there is no concern in the Karen camp, there should be. Because what they heard on Friday, this jury heard and got to think about all the weekend was, number one, maybe there was an alternative theory with the whole glass, and that was part of an altercation. Number two, an arm at whatever poundage, and we'll get into that discussion over the pounds. I see the fan is spinning, by the way, so obviously we're tracking that. As soon as it's time, we will jump in. And we'll pick up today, if you've forgotten, we'll pick up with Dr. Wolfe with his continued examination. And it is expected that he is going to be followed by Dr. Rentschler. And the distinction between the two testimonies, remember, they're both ARCCA experts. Rentschler is more the expert on the biomechanical. That's going to go right to the heart of how those injuries to the arm could or could not have been caused by the attack of the taillight. So that's going to be key. And you notice Friday how Dr. Wolfe strayed away from that stuff. Whenever they got toward a question of that sort, it was like, that's not my thing. Dr. Rentschler will talk about that. Important for two reasons. Number one, okay, we got an expert with a very specific subspecialty. Okay, and number two, it keeps the Commonwealth from saying, Your Honor, that's a cumulative. We had Dr. Wolfe talk about that when he was on the stand on Friday. So they can't do that. So that should be, not that the objection won't be made, but it should not be sustained. I get dirt all over the counter here from, remember I did the test of driving around with this light strapped to the back of my SUV just to see if it would pick up road grime, dirt stuff, because the subject tail light is pristine. This one not so pristine anymore, and every time I move it around, I'm getting all kinds of dirt and crap on my desk. Excuse me. Clean up on aisle 4. So anyway, and I want to do something with this light here in a few minutes, or a break if we don't have a chance before they get started. So back to my original premise. So you've got the glass thing, you got the breaking of the taillight with the arm. Remember that Brennan made this huge deal out of the weight of the arm that was used, either the Rescue Randy arm or the composite arm, whatever they get these dummy arms to use. There was a back and forth with Dr. Wolfe in which Dr. Wolfe almost, he agreed with Brennan, saying that the weight of John O'Keefe's arm would have been, I think it was 11.8 pounds. Now, I don't know where that number comes from, but it was presented by Brennan to Dr. Wolfe, and Dr. Wolfe agreed. So now you got that number hanging out there, 11.8 pounds for the arm. We also know that the dummy arm was about 2 pounds lighter than that. In fact, 9.2, 9.4, something like that. And the question from Brennan, and the point he continued to make over and over, is that the weight does matter, doesn't it? Doesn't it, doctor? Weight matters. And he's suggesting that all of your calculations are a little wacky because you've used an arm that does not represent the weight of John O'Keefe's arm. And if you had done that, there would have been more damage at the speeds that you did the testing, and also that the speed itself may be questioned because there's a correlation between the weight of the arm and the speed, which I think is BS. I think that is an attempt to take what may be a valid point and twist it to the point that it's absurd without foundation. Here's what I mean by that. Brennan is saying, well, the weight on the arm being lighter than the actual arm by 26% means that any speed used in any test should actually be 26% slower. So if you did your test at 24 miles an hour, that's really only 17 miles an hour, 26% lower, because the arm weight is 26% lower than the actual arm weight. That is such an amazing mix of potential fact and fiction that I'm impressed just by the audacity to even attempt it. But will the jury buy that? Are they going to say, wow, 24 was this key time because that was the Commonwealth's theory that it was 24.2 miles an hour that carried back the SUV into John O'Keefe's body/arm. And now the defense is attempting to kind of work around that, kind of mislead us because they did 24 miles an hour, but the arm weight was lower, meaning it was really more like 17. If you don't think a jury member could go down that rabbit hole, you are crazy. A jury member can. A jury member or two or three can. And again, if they're the right jury members, or maybe the wrong jury members, depending on how you look at it, that could be powerful, a powerful argument that may kind of twist reality, in my opinion, and it may create some need to as we used to say, suspend disbelief, right? Like, how could that possibly equate to that number speed-wise? Doesn't matter if you're kind of going with the theory. So those are the issues to me that lead me to believe at the end of the weekend of thinking over Dr. Wolfe's testimony, the care and read camp should have concerns. So coming in today, remember, Alan Jackson began his redirect, and he's trying to clean up some of the mess. And he talked about the weight of the arm, and he got Wolfe to say to this jury, it's irrelevant. That difference between what we believe somehow was the weight of Officer John O'Keefe's arm, 11.8, and what the weight of the dummy arm was, 9 point something, doesn't matter. At those speeds, the impact, the location, you're still going to get some sort of representative damage to that taillight. Okay. I'm not so sure, A, it worked, or B, it matters because of the bigger picture, which I mentioned right off the top, which is we now know, at least according to these experiments, that the arm, even being struck in and of itself, extended, could break the tail light. And I just think that before this testimony was a huge question that the Commonwealth did not have the expertise to prove, at least up to this point in their case. Remember, case in chief's over, but they have a rebuttal case, and they could have brought it into that mix. Now, if I'm the Commonwealth, I'm hands off of that thing, or arms off, perhaps is a better way to put it, because the defense expert has already told this jury what I needed to tell them. An arm can break the tail light. So Rentschler's got a lot of weight on his shoulders here to convince this jury that even if the tail light did break as a result of contact between the SUV and the arm, that the damage, the injuries caused, those claw-like marks, could not possibly have been caused. Remember, and this is a very good time to go back to the opening statements, and maybe we should do this in the next couple of days as we're getting ready for closings, and we'll talk about scheduling in just a sec. But you go back and you listen to the opening statements, and you start saying, okay, yep, they proved that, or at least they addressed that. I'm not so sure in the defense opening statement where the key focus was no collision, no collision, no collision, no collision. I'm not so sure that that rings true in light of their own expert's testimony. So we definitely should go through. And remember, the openings were limited, basically, give or take, to an hour. So not horrible time waste to go through them and see if we can tick off the points either side made, didn't make, still have to make because of the scheduling. Here's the scheduling as we understand it. Wait, there's a comment. Let me check my glasses here. They can speak to other doctor this weekend, correct? He hasn't testified. The other doctor, meaning Dr. Rentschler, I'm assuming, they could. It would be subject to, a question of cross-examination, like, when did you last speak to the defense? Well, this weekend. We were hanging out by the pool, or whatever it may be. And sometimes that's helpful. Sometimes it's not. Remember, Dr. Rentschler is not supposed to have listened to any testimony from Dr. Wolfe. So it doesn't look good, I'll put it that way, if the defense team has a last-minute confab with the next expert. It just looks like maybe they're trying to massage his testimony to match what has come before. So can they? Sure. It's going to be subject to cross-examination and some sort of criticism, that is for sure. So scheduling. The judge last week told the jury, we talked about doing a half a day on Thursday, but now we're moving along quickly enough that I'm going to ask you to think about over the weekend whether You can do it full day on Thursday. If you could just think about that over the weekend. So that's one of the things we should learn this morning is whether or not the jury is available for all day Thursday. They left Friday, I think it was at 3:45. They had to bail because one of the jurors had an appointment of some sort. And that's the way it should be. The court should be deferential to the jury schedules. They're the ones putting up with all of this, right? And serving honorably to get this done and hopefully get to a just result. But, people have lives. And, when you're asked to be on a jury that's going to be 6, 8, 10 weeks, things are going to come along. So I do appreciate that the court is trying to be deferential to those needs of the jury members. So we'll see if the jury can help out the judge. Because here's what I expect is going to happen. We've been talking about this, Linda and I talked about it over the weekend. We think closings could be Thursday, meaning the case would go, remember, they're only going to be limited to an hour-ish, right? Like they were the first time. I remember Adam Lally got cut off. He wasn't even done. So you could tell he's going through his notes, And then the judge, Mr. Lally, are you about done? And he's like, skips to the back page of his notes. If you have a time limit, just a little tip here, practice a few times, make sure you're within the time limit, give yourself some leeway there, because nothing looks worse, makes you feel more uncomfortable, ends up giving the jury a bad impression than having to jump over stuff that probably was important or you wouldn't have it in there, right? Just because you got to get to the end and you got to wrap up with whatever your punchy line might be. And as I recall, his wrap up was not very punchy. So, but then Lally's not a punchy kind of dude. And who, okay, raise your hand. Who misses Lally just a little bit? Okay. So they could get the case Thursday afternoon, evening. That's possible. I'll be going up whenever that happens. I'd hate to see them do closings Friday and get the case Friday, only because I just, no matter how the thing goes, I don't like to see a Friday verdict in any case. I really don't. It's a real thing. The push, the motivation to get done before a weekend, it's a real thing. And I don't like it. I think a jury needs time to, kind of sit back, think about it, and hopefully do the right thing. Last time, they got the case on a Tuesday. And so they went Tuesday, Wednesday, Thursday. And guess what happened on Friday? Mistrial. So they at that point had already, of course, advised the judge, we're hung up, can't do a thing. And she gave him the dynamite charge, went back in, went at it again. And then, of course, that's when all hell broke loose with did they come to a unanimous decision on any of the counts? Well, since the court did not instruct them, and I can't wait to see if she does this time, that they could be unanimous on different counts and not have to be unanimous on all of them to return a verdict. You could have a partial verdict. And if you believe the affidavits that were filed after the first trial was ended in a mistrial, there was a not guilty on count 1, second-degree murder, and there was a not guilty on count 3, which was leaving the scene. But they were hung on count 2, which is the manslaughter DUI connected charge. It could have very easily been cleared up, not just before the deliberations began with an instruction that says, members of the jury, please be aware you don't have to come to a unanimous agreement on all charges. If you come to a unanimous agreement on any of the charges, advise the court, blah, blah, blah. That could have been done after the first hung jury note. Judge, we're all hung up. We don't know what to do. She gives the dynamite charge. She could also have said at that time, understand that you can have a unanimous verdict on any of the charges without having unanimous verdict on all charges. Just, advise the court what, if any, charges you have come to a unanimous decision on. So 2 opportunities to fix that. I don't know if she's relying on, well, in Massachusetts, we don't do that because we're backwards and weird. But she didn't do it. I hope there is some fix to that. She may think that the legislature has to change that and make a specific instruction. Would that be a good idea? Yeah, it'd be a great idea. A lot of states have that. But it is not required. The judge can make that notice to the jury, either as a formal instruction, as a follow-up. It could be done, but it wasn't, and I'm just not sure. I'm not sure if they're going to fix that or not. So that's where those things stand. Let's see what else I had to talk to you about before we get back into this thing. Oh, let me talk about, since we do have, I should say this, watch this, Linda Kenney Baden. Make sure you like, share, subscribe, hit the howdy button. Is there a howdy button? I don't know. Anyway, see, do all of those things. We're on the verge of 15,000. And you know what happens after that? We start trying to get on the verge of 16, 17, 18, 19, 20,000. But if you, if you know, friends and family, have them hit the subscribe button so we can hit the 15,000 and then continue on with our angst to get more. So here's the tail light. And by the way, did you know a human arm could break this tail light if hit with the proper speed, angle? Yeah, that's what I hear. So here's something that came out, and we talked about it. I think Diz did a great job of cutting a little mini snip from our Friday show where we talked with Stephen Prohl about, and he's of course our in-house crash daddy, accident reconstructionist for 30 years, cop before that, and we talked about the lens, obviously, and this part inside. See this? It's hard to tell what it looks like, but it has ridges. Can you see those ridges? You hear that? That's the diffuser. And sorry, I got an itchy nose. That's the diffuser. Does that mean I'm going to get money? Oh, no, that's an itchy palm. That's the diffuser. That inside that plastic piece. So you got plastic lens, then you got plastic piece here, the diffuser. Then inside that you have the LEDs. The LEDs inside determine the color of the lights. The lens is, it's almost like it was done so many years ago when cars first came out and we needed brake lights, that the lens determined what color, because you'd have just a white bulb behind it. So white bulb, red light, you're going to get a red brake light. Not so much anymore. You could actually, it wouldn't work, wouldn't look so good. We'd go, what the hell? Why isn't there a red brake light? You could actually have this thing white all the time, and it would shine red if the brake lights went on, and it would shine white if the reverse lights were one of these LED panels. But I think in part because everybody equates red tail light to brake lights, that we've maintained that. So my point is that these little ridges here, in some of the testing that was done, in fact, I think it was most of the testing, there was a little bit of damage to these diffusers. Now this is, again, it's a little bit thinner plastic, polycarbonate, than the main part of the lens, but still, it's still pretty rigid stuff. Uh-oh, looks like something happened. Something be happening in court. You're gonna have to save this for later, but I'm gonna do some more damage on this light. I want to get a sense of what it takes to damage to the diffuser. Diz, do we want to go in there? Yes, we do. Let's do it.
Hi, good morning. So I just saw a transcript that was placed here on maybe referenced this morning, and there's a motion to limit Dr. Rentschler that I just got that I'm not prepared for. So that we'll do later today, okay? All right. So the Commonwealth's motion to call witnesses in rebuttal. I've read everything. Ms. Little, I appreciate you getting your opposition to me. I think I had it by Saturday morning, so I appreciate it. I read all the cases on it. Does the defense want to be heard any further on this?
Yes, briefly.
Okay.
With regard to Dr. Crosby and Ms. Coup, as the sort
Speak into a microphone. Speak into a microphone.
With regard to Dr. Crosby and Ms. Coup, the Commonwealth has been on notice that the defendant intends to present a defense regarding the arm injuries, that this was caused by a dog bite. They have been on notice of that, not just for months, but for years. That was presented at the first trial. The Commonwealth does not have a right to rebut information that they have been on notice of from the start of the case. So their decision to wait for rebuttal to call these two witnesses is improper, and we're asking the court to exclude their testimony.
All right.
As it relates to Dr. Welcher, the scope of his testimony, our request is that that be limited to very specific information, specifically responding to the new testing that ARCCA has done. As the court knows, the Commonwealth has proposed a number of new testing ideas as well as information that is greatly outside the scope of what ARCCA intends to testify to. And so we're asking that the court limit their testimony from engaging in new testing that has nothing to do with what ARCCA has testified about at this trial. With regard to Dr. Welcher's testimony, the court has made very, very strong rulings that Dr. Wolfe as well as Dr. Rentschler are not allowed to speak to the credibility of Dr. Welcher himself. And so some of the information that the Commonwealth proposes is to directly attack the testimony of Dr. Wolfe and Dr. Rentschler. And under the court's rulings, we're asking that the court limit that scope as well.
And I told you I would.
Thank you.
All right.
That's all,
Brennan.
Your Honor.
Thank you. Mr. Brennan, do you want to be heard?
Regarding DNA evidence, evidence cannot be rebutted until it is introduced because the defense has a number of potential ideas of areas of testimony. It does not compel the Commonwealth to try to anticipate or deflect attacks, especially if they're meritless. And so the issue of dogs and dog DNA does not become relevant until the defense calls a so-called dog expert. They raise the issue, it's proper grounds for rebuttal. There are three witnesses, Ms. Hartnett, UC Davis, and Dr. Crosby. If Dr. Lope-Sada is precluded from testifying about dog bites, we would not call Dr. Crosby as a witness. However, regardless of what Dr. Lope-Sada says, we would ask to call Ms. Hartnett and to call the witness from UC Davis. It is an issue that directly affects the assessment of Dr. Russell, the very expert they chose to call in their case in chief, and so we can now, from my perspective, properly rebut it. The second issue regarding Dr. Welcher, limited to the new information you will see from the testimony or have heard. Most of the testimony is new, but we understand it's limited. We don't expect Dr. Welcher to have a direct comment on the credibility of any witnesses, but he will address the tests, how he believes would be the proper procedure, and there'll be a number of issues that have been raised on direct examination, but he will not in any way have a comment on the credibility of the defense experts.
All right. So the case law supports me allowing this motion. I'm allowing the Commonwealth's motion. So the motion for rebuttal witnesses is allowed. Mr. Brennan has said he will not call Dr. Crosby, depending on the testimony that comes in. So, all right, Jim, I'm just going to give you this.
Thank you.
All right, so the motion regarding the testimony of Dr. Lope-Sada. So the Commonwealth is moving specifically to exclude, there's a motion to exclude irrelevant photographs. We'll deal with that after the main motion to exclude certain testimony. So if we start on page 7 of the report, that's where you want me to start, Mr. Brennan?
Your Honor?
Okay, page 7 of your report. I have some questions. So, Mr. Jackson, Dr. Lope-Sada cannot opine about the investigation of the case, the law enforcement investigation. She does that throughout her report. So she can't opine to that, but when we get to page 7, what do you say is out, Mr. Brennan? I mean, I've gone through it, I know what I think, but it's the Commonwealth's motion.
I think that her opinion about no object being present to cause a pattern injury is appropriate.
And where are you, on page 7, the first paragraph?
Yes, photographs and descriptions of the site. It is the,
All right, I might have a different page 7. So my page 7, okay. Okay, yep.
Dr. Lope-Sada proposed opinion that photographs and description of the site where Mr. O'Keefe body was found, so show no object capable of producing a pattern injury, I think is appropriate. His body was found on flat, grassy ground, probably frozen and covered with a minimal amount of snow. I agree is appropriate. It is the next paragraph where it begins in the middle of the sentence. It is logical to conclude that Mr. O'Keefe was injured elsewhere and his body was moved to the front lawn. There is no basis in fact for that. It's an improper opinion.
Yeah.
We left the argument.
So I told you that on Friday, Mr. Jackson.
We're not seeking that.
Great, okay, so that's out. And Mr. Jackson, again, the medical examiner erred in her diagnosis of hypothermia. Again, that's the improper critiquing of the expert. She can say that it wasn't hypothermia, obviously. Okay, so same with the first sentence of the next paragraph, the Wisniewski spots were misidentified. Great, all right, so we can probably do this much quicker then. All right. All right, so page 8 is fine. So now we go to page 10. So this is the dog bites. So if you want to pick it up at, what does the Commonwealth say about this?
At this point, there's no basis provided that she has training expertise, methodology to provide an opinion regarding the dog bite.
What's the offer of proof on this, Mr. Jackson?
It will be more extensive when I establish the foundation testimony. Basically, she's not only done autopsies involving dog bites, the wound pattern recognition related to the source of those dog bites. She's also taught classes on wound pattern recognition, source of coming up with diagnoses concerning the source of specific pattern wounds. She has a methodology that she uses. Medical school classes, I didn't mention, the courses.
What does she teach? Is this in her CV? Because I didn't see it.
It will be in her foundation that I will lay in front of the jury.
All right.
I won't see any opinion unless and until the foundation is properly laid, but she has extensive experience, not only with, specifically with autopsies that she's conducted herself, but supervising autopsies of others that deal with pattern recognition, the methodology involved with pattern recognition.
How about dog bites?
Dog bites specifically, 5 autopsies. I believe she will indicate that she's done 5 autopsies as they relate to dog bites.
Okay.
A medical school class specifically on the issue of wound pattern recognition, which that class includes dog bite recognition.
All right, so we'll need a short voir dire of her on this before she testifies.
Because the court doesn't believe that I can lay the foundation in front of the jury and just forego a voir dire. I won't ask any ultimate question until we go to sidebar, but I think we can short circuit that.
Well, she's very specific about the dog bites here. So if she's seen 5 autopsies with dog bites, I'm not inclined to give it to you, okay? Seen only 5 in her 40 years or whatever.
It's not that she's only seen 5, she's performed 5 autopsies.
Okay, so that's why we need a voir dire. So we need a very short voir dire.
She's also been qualified on the issue of dog bite wound pattern recognition in federal court as well.
Okay.
So she has a plethora of foundations.
Has that been provided to the Commonwealth in advance of today?
I don't know.
None of it has. So here's the difficulty, whether it's a voir dire or it's in front of a jury, I have absolutely no ability to research and cross-examine her on dog bites. She can say she had 1 case or 50 cases, that she testified in state or federal court, or she took a class. I can't verify it, I can't contradict it. I have no ability to prepare for this witness about her basis, methodology, and experience in dog bites. What I have is her showing a couple pictures that she pulled from a book, and then she has some Google or Shutterstock research in her report. And so the idea that she has a history or basis is going to be uncontested, because there's nothing I can do to contest it, and that's not appropriate. I should be able to research, get transcripts, vet, and be able to approach the witness on whether or not she actually has the reliability and education and experience. I can't do that if we call her an asset for the jury or a guardian.
Brother, if we want to compare apples to apples, Dr. Wolfe, Wolfe, was allowed to testify, to specifically testify to the wound pattern, or his interpretation of wound pattern recognitions back then. That was nowhere in his report. That was objected to by the defense. Mr. Alessi went to sidebar, strenuously objected, said this is nowhere in the reports, we didn't have any notice of this, and the court said, overruled, he's allowed to testify to the pattern of recognition, at least in his mind, you can cross-examine him on. There is no requirement that the Commonwealth have every single case that Dr. Lope-Sada has ever dealt with, dealing with.
No, we had an expert on dog bites who I allowed to testify as to dog bites based on, we had a whole, as you know, it was Mr. Leslie, I think 3 days with Dr. Russell on the voir dire. This is new to me. I'm going to have a short voir dire on to what she can testify to.
I have no problem with voir dire, I just wanted to short circuit it, but I have
So,
to entertain that.
all right, so let's go on to page 17.
Commonwealth has an objection to the third line, Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. She is not qualified as a reconstructionist or biomechanical engineer. She has tried in other courts and been rejected. She does not have the experience, the background, or the ability to do that improperly.
What do you say, Mr. Jackson?
Your Honor, I believe she does, as a medical examiner, have the experience, and it's the qualification, it's the specific job of, and the qualification of a medical examiner to opine on pattern injuries. If the foundation is laid, especially as it relates to motor vehicle accidents, and now we're not talking about dog bites, which are a more defined subset of her overall experience. Now we're talking about motor vehicle incidents and accidents that she has specifically seen thousands of.
Okay.
Thousands, multiple thousands of.
So-
If she does have the qualification to say, if the proper foundation is laid, that the wound pattern that I see on Mr. O'Keefe's arm is inconsistent with anything that I've seen in terms of a motor vehicle accident. I don't know if she can say-
Let's just find out how many motor vehicle accident autopsies she's done during that voir dire. What I have a question about is tail lights are typically made of durable polycarbonate or acrylic plastic. I would keep that out. I'd be inclined to allow in the injuries on his right arm do not correspond to injuries that could have been produced by plastic pieces impacting his arm. But let's hear about
That's
that.
appropriate. I wouldn't ask about polycarbonate. I have no intention of asking about that.
And also, the last sentence, I think it's okay, and we'll see with voir dire. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes, assuming she has experience with autopsies of motor vehicle accidents. But I would keep out the part as would be expected from pieces of shattered tail light. Was there more on that?
I object to that because this is now yet another witness that is coming in under the guise of some type of specialty, but really for accident reconstruction.
All right, so let's see what she says on voir dire regarding her experience with accident victims. I think she gets more into the accident reconstruction on the next page that I don't think is proper.
Which I am not seeking to introduce.
All right, so that whole first paragraph on the next page, you're not seeking to introduce?
Yeah, just one point.
Yeah.
But at least the first, we're starting with the first sentence, yes, we would be seeking to introduce that. Pedestrian injuries produced by contact with motor vehicle include a component tissue crushing force as the car profile protrusions connect. That's basic. I believe that she does have the qualifications to opine about that. That's pretty standard, and that should be admitted.
She has absolutely no experience in accident reconstruction or the injuries. She is not a biomechanical, biomedical engineer. They have one, and he's going to testify to it.
Yeah, I have that as out, Mr. Jackson.
The reason that I believe that it's appropriate is because you don't have to be a biomechanical engineer to understand when you see, for instance, a known pedestrian accident, what are the results, especially if you've seen hundreds or maybe even thousands, what are the results that you typically see in the wound patterns, for instance, crushing forces, broken bones, fractured bones, crushed soft tissue, things of that nature, internal bleeding. That's the province of medical exam.
Okay.
That's exactly what they are trained to identify and to opine on.
Okay?
I
So,
wouldn't get into things like, for instance, what she doesn't have the experience to do is say, when a car is involved in a rollover collision, these are the mechanical forces that are exerted on the body during a rollover, and the G forces that are subject, that the body is subject to in a rollover, things of that nature. When a car is impacted head-on by another car, there are a number of G forces that are put upon the body, etc. Those are biomechanical issues, have nothing to do with her expertise, and I wouldn't be seeking anything like that. But once the body is removed from the car, and then it's on the autopsy table, that's where her expertise begins to fly. if you
Okay.
will. She can talk about, and I believe she has the experience and the qualifications to talk about, what the body suffers at the hands of a vehicle, pedestrian, incident, or accident.
okay. So the first two sentences are out. The third sentence, she can testify that Mr. O'Keefe had no bruising on his arms or torso. And she can testify, and she cannot say that would have resulted from the impact with the SUV rear profile. She can say Mr. O'Keefe did not have bruises on his legs. She cannot say from bumper contact, but she can say as shown by dissection of leg tissue and muscle at autopsy. And she can't testify to anything else in that paragraph.
Your Honor, is the court ruling that she cannot say anything about the human body contacting a motor vehicle? That sounds like what the court's saying.
No.
I think that's too narrow a ruling.
It is. You can put this in, what I said you could put in, can come in, and the rest cannot. We
For
could,
instance, and just for point of clarification, if I ask her, would you expect, I'm just gonna make it a hypothetical, would you expect if his legs were contacted by a moving vehicle, would you expect to see bruise or contusion?
what do you say about that?
I don't object, one, it's leading. Secondly,
Well, I'm not asking the question.
Secondly, this is asking to have Dr. Lope-Sada do accident reconstruction. She's not assessing a wound. I'd ask you to consider the case of Commonwealth versus Tompkins Appeals Court. I think we provided at 105 Mass App 1124, 2025 case. And a similar attempt was made to try to use Dr. Lope-Sada as a biomechanical accident reconstructionist. The trial judge did not credit her proffer and found that she failed to meet the requisite criteria pursuant to Daubert Lanigan. And so recently it's been found by at least another court that she's not competent to do this. Because she's a medical examiner, does not allow her to come in and start endorsing or vouching for the ARCCA witnesses. They already have witnesses to do that. And so not only on page 18, going back to page 17, about the pattern injuries don't correspond to injuries to a light, she would only know that if she had the training experience.
I'm sorry, where,
You said on page 17 you would allow Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. That's not her role as a medical examiner. That is the role of a reconstruction or a biomechanical engineer. And she clearly is not competent, at least as cited by the appeals court, to have that type of opinion. And so there's one thing to assess wounds, there's another to try to correlate or draw a distinction between the wounds in a car collision. It is essentially giving an opinion to the jury, he didn't get hit by a car. That is the core fundamental theory of the defense. This is simply trying to bootstrap another witness to give that opinion. That's improper.
all right, sure.
Mr. Brennan's going to cite the Tompkins case. He needs to cite the Tompkins case. That dealt with a situation in which the witness was called, and she was asked by the lawyers, specifically in that case, the people that called her, the lawyers that called her, to opine about blood-stain pattern recognition, blood spatter evidence on the driver's seat versus the passenger seat, and what her opinion was about who actually was driving the vehicle. It was a rollover collision in which people were ejected from the car. She was then asked to opine about bloodstain patterns in the driver's seat and whether that was more or less consistent with the blood, the originator of the blood, one particular individual, was he more likely in the driver's seat or the passenger seat at the time of the bleeding, and was it before or after the rollover? Very, very different set of facts. And of course, that is a biomechanical engineer's province. And the court was correct in saying I'm not going to credit her testimony on that issue, but that's what she was asked. She opined on it, and the court said, I'm not going to credit her testimony.
All right, so
To do this type of analysis and wound pattern recognition, which is what she's being asked to do.
So let's see with her voir dire this morning.
Okay.
She actually was allowed to testify about blood spatter. It is the reconstruction testimony that she was not allowed to testify.
I read the Superior Court judge's decision. I have not read the appeals court rescript, so I need to do that. I'd like to get going, but there are photographs of inside the garage. You intend to put this in through Dr. Lope-Sada?
No, not
Through whom?
if I could just have.
Yeah, can I give this? With regard to these photos, well, ultimately, the Lope-Sada will be shown them, correct? But they'll be introduced through our investigator who took the photos. We intend to call that investigator after Dr. Wolfe testifies.
And what will that investigator say? These are photographs.
So he will testify to two subject areas. One would be he took measurements from the street to the various entrances to 34 Fairview. I just have to testify about what those measurements were. And then where he took several photographs, we have pared them down to, I think, 3 or 4, just of one establishing shot showing the garage from the street, and then a couple of photos showing the side entrance to the garage, the pedestrian entrance to the garage, and also showing the interior of the garage, including a step and a
For what purpose?
for-
How are they relevant?
I'm sorry?
How are they relevant?
So the defense is presenting a Baden defense in this case. We are alleging that the police did not do a thorough investigation. They did not really investigate anyone other than Karen Reed. The Commonwealth's own evidence, including the testimony of Ian Griffin, is consistent with John O'Keefe after what they claim to be the trigger event in Dr. Welch's initial report. John O'Keefe walking in a westerly direction, which would be from Fairview Road to the house, taking approximately 36 steps over a distance of 25.4 meters, which is approximately 84 feet. That is consistent with him entering the house. It's consistent with him entering the garage. The police did not take photos of the garage. They didn't investigate, is there a hard surface in the garage? Is there a ridge-like surface in the garage? And these are, photos are introduced on that own issue to say that there was evidence in the house. If the police only went in there, they would have seen that. And that may have sent them in a different direction. So it's relevant for that purpose.
Do you want to weigh in on this?
These are not only relevant and not material, it's misleading. They are not seeking to have measurements from the flagpole to the door. They're trying to seek measurements from the driveway to the door. There is no evidence whatsoever John O'Keefe was ever on, near, or anywhere by the driveway. The evidence is that he was at the flagpole. While the data showed there was a turn westward, it didn't show movement westward. It did not. There was a measurement from the flagpole to the garage door. That is something that I think would be appropriate. From the driveway, totally irrelevant. There's no evidence, no witness, no substantive evidence in this case that John O'Keefe went in the house, went near the house, was dropped off. They're relying simply on the fact that there were 37 steps. They have no idea what direction or where. What they want to do to argue this is to show inside the garage and then posit a theory that somehow John O'Keefe was killed in the garage, it was colder than it was in the regular house. That would account for the temperature on the battery. They have no evidence to support that. You can't use Baden as a panacea. You can't just say Baden, they should have done what we want them to do. It is what is reasonable. The police went into the house. They spoke to the occupants of the house. There was no evidence that Mr. O'Keefe went into the garage. You might as well take a photograph of anybody else's garage in America and put it up in front of the jury. So this is going to create a mistaken, baseless argument that this evidence somehow shows that Mr. O'Keefe was A, in the garage, and B, he was injured in the garage. That's why they want to show it to Dr. Lope-Sada. Couldn't some of these angles have caused the injury? Total speculation, no relevance at all, and it is just prone for an opportunity to mislead this jury. This should not come in.
If I may respond in 4 ways. First of all, Mr. Brennan just informed this court that there was no evidence of the movement of the phone. I'd like to quote his own witness. At 12:25:30, the device's bearing shifts to a westerly direction, as location records also show the device moving west from the roadside toward the house. So that was false. Secondly, with regard to, we should be measuring from the flagpole, our theory is not that he entered the house from the area of the flagpole. Our theory is that he was placed at that flagpole, and as Mr. Brennan correctly points out, there's no evidence that they introduced as to where he was on the road prior to walking into the house in that westerly direction. Our theory is as good as his. He cannot prove anything to contradict our theory. The third thing is that Brian Nagel and Heather Maxey saw Karen Reed in her vehicle alone. The passenger seat was illuminated and empty. John O'Keefe was nowhere in the area of that vehicle. He was not in that vehicle. There's only one other place that he could be, and that is in the house. So finally, the fourth point, Your Honor, this court has continually always done, as the court should, a 403 analysis. The probative value we have established through their own witnesses. They called all these witnesses, and they established the foundation for the admission of these photos. There is no unfair prejudice. I would argue that any time there's exculpatory evidence or a case that advances the defense theory, that's by definition going to prejudice the Commonwealth's case. This is not unfair prejudice. He is allowed, Mr. Brennan is allowed to cross-examine this witness and to make whatever arguments he wants to make about the likelihood of the garage being involved or not. But he does not and should not get the benefit of the fact that his investigation, the police investigation, didn't do what we just did. And this evidence should be admitted.
The argument is purely rhetorical. There's not one fact he offers. The witnesses that saw the car saw it in front of them. Nobody ever got out. A light on doesn't mean that he wasn't near the car because they didn't see him in the front seat. So there is no evidence that Mr. O'Keefe went anywhere near the house, on the breezeway, in the door. It is speculative, it is baseless. They want to take that baseless argument and then bootstrap it to Dr. Lope-Sada to further speculate that something in the garage that could have caused the injury. That is not Baden. That is not a due process right. That's not 403. It's empty. It's no factual predicate whatsoever.
Okay, so,
The only other thing, just to put a cap on this, the location data circles, again, Mr. Brennan's own evidence, he introduced it, puts John O'Keefe in the house.
all right, so I'm going to allow you to do the measurements. These photos will mark for identification. The photos are not admissible. So, all right, Chrissy, can you just mark those, please? All right, let's bring the jury over. We will do, Mr. Jackson, how long will you be with Dr. Wolfe?
Probably 20 minutes.
All right, and depending
Yes.
on that. All right, so during the morning recess, we'll do the voir dire of Dr. Lope-Sada. All right, bring him on over, please.
Oh, brother. That's my legal opinion. Okay, so all kinds of motions flying about. Let me go backwards first because that's how my brain works. So the photos will not be allowed to help the witness, Dr. Posada, apparently, testify about some of the distances that should have been covered. And also there's an investigator coming in. I don't know the name of the investigator, but there's going to be an investigator testifying that supports the Baden defense, which is basically that the cops screwed up. Cops did a crap job. I don't know that anybody will dispute that, but I'm not sure the jury has it pounded into their heads significantly enough to realize how important it is. So Brennan is saying the Baden defense is not a panacea. It is not a catch-all for everything they want to bring in. So he's using that argument to suggest that some of the testimony and evidence that the defense wants to bring in should be excluded. And the judge really gutted a lot of this. There's an important question let me hit this while it's on topic here. Blessed in Texas, thank you so much. How is it judges allow witnesses to testify only on certain things Where in the rules does it allow for this? For example, New York, as you may not be familiar with Massachusetts unless you are, discuss this, please. The judge can always limit or exclude testimony of any witness, expert, lay witness, anybody, always. The question becomes, on appeal, if an appeal takes place, was it appropriate? Was there the right basis for excluding that testimony? In this case, she's excluded some weird, bits and pieces of different testimony. Let me see, there's a couple of notes here I made about what can and can't be talked about. Again, the photos not being allowed. They can be used as demonstrative, but not allowed. And these are photos that are of areas that the foundation has been laid by many different witnesses. That to me was a mistake. Those should come in. Is that a game changer? Is that going to win the day for the defense on appeal? No, probably not. Probably going to be harmless in light of everything else. Interesting, the testimony she's limiting on the bruising. I've seen a number of comments on this. As I heard it, and this is a perfect example of how people may hear things differently, she said the doctor can mention the lack of bruising to the lower extremities, to the lower part of the body. She can't relate it to the car. She can't say that the bumper would have caused that bruising. She can't say that the car in a motor vehicle accident would have caused the bruising that she sees missing. So she's forcing the jury to kind of fill in that blank. I think that's a mistake as well. Why can't this woman, who's clearly going to be qualified as an expert in accident injuries, motor vehicle accident injuries, not reconstruction? And Alan Jackson said he's not going to get into reconstruction with this person. He's going to talk about her expertise in dealing with wounds caused by motor vehicle accidents. And so she can testify the lack of bruising, because if somebody was in fact hit by the bumper, hit by the back of a SUV, she would expect to see certain injuries. The judge is not going to let her do that. He's going to let her say that I don't see any bruising. I don't see, and compared to the autopsy, remember she's going to say the autopsy showed with tissue sample testing that there was no bruising. So she's going to testify about the lack of bruising, but the judge will not let her testify to the cause or lack of cause in her experience that a motor vehicle accident would have done to these body parts. I think that's wrong as well. Again, so you file your appeal, you note that as an error by the court, and then the appellate court gets to look at all of these different things. And I'm telling you, in this case, here's the thickness of the brief. It's this thick, okay? It's a foot and a half thick. You're going to have so many things that in and of themselves, stand alone, may be considered errors, but harmless error, which leads to no remedy. But when there are so many, you have the cumulative impact of a reversible error. And it happens. And I see, if there were to be a conviction, that's the scenario I see here. I don't see standalone reversible error, although there have been some we've talked about, like the DNA issue, which rose again today. That one may be reversible in and of itself. But I see so many others that might separately be harmless error, could become reversible in the cumulative. So, of course, obviously, the Karen Reed team hopes that never becomes an issue. There's a question about Dr. Lope-Sada getting into DNA. Commonwealth says that, the defense says they raised it. Remember the whole DNA issue when they moved for a mistrial with prejudice? That related to the DNA brought up only by Brennan, only on cross-examination of Dr. Russell when he was asking about finding DNA in the arm wounds. And so the DNA issue has arisen. And the question that's going to come up during voir dire, isn't it interesting? The voir dire is going to take place, but only for defense witnesses. Have you noticed that? Dr. Crosby can just basically send in here's my certificate I got from mailing in 2 Post Toasties box tops and 25 cents. That's fine, qualified, but everybody else knows. So we're going to have a voir dire of Dr. Posada during the morning break. And I guarantee you, all of the things that has gotten Bev's pearls twisted into a knot ain't coming in. So to circle back to Blessed in Texas' original question, yeah, it's up to the judge, and then on appeal, we learn whether it was harmless or reversible error. Okay, hear ye. Let's get into court.
Hear your Kenneth, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Okay. morning again, council. Good morning, jurors. So we appreciate your patience. We were in here trying to streamline things, so we got a lot of work done this morning, so thank you. I do have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday? Everyone said no or shook their heads. Okay, thank you. Can we have Dr. Wolfe, please?
Mr. Armand, you're still under oath.
All right, good morning.
Good morning.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Dr. Wolfe, thank you for joining us again this morning. I'd like to draw your attention to a picture. May I approach, John?
Yes.
I'm going to show you. Do you remember seeing that photograph?
Yes,
You were shown this photograph last week, is that right?
correct,
By Mr. Brennan, correct?
correct.
Do you recognize the photo as the same photo that you were shown last week?
Yes,
Under questioning by Mr. Brennan?
yes.
And what does that appear to be a photo of, just generally?
It appears to be a photo from of the test dummy from the 29 mile per hour impact test.
Does that appear to be a true and accurate photograph of the condition of the dummy following that 29 mile an hour crash test?
Yes,
With the court's permission, I'd like to enter this as next in order, please. If you could hand that to the court reporter.
Exhibit 218.
Permission to present that, Your Honor?
Yes.
Is this the photograph?
yes.
Dr. Wolfe, first of all, what caused the damage? Well, let's start with the most basics. Which arm is this, left or right?
This is the left arm.
What position was, you called this dummy Rescue Randy, is that right?
Correct,
What
yes.
position generally was Rescue Randy in upon impact during this test?
He was oriented such that the right side of his body and his right arm would be contacted by the vehicle.
What caused the defects in the and the damage to the sweatshirt as we see it here?
That was due to the interaction from the Rescue Randy sliding on the pavement surface to his position of final rest.
Is that sometimes called road rash?
Yes,
Did you see any road rash in any other place on Rescue Randy in this photograph?
doesn't appear so in this photograph, no.
Can we highlight the face? What about there?
Sorry, I thought you were talking specific to the clothing. Yes, as I mentioned on Friday, there were signs of road rash to the body of the dummy itself on the face and on the torso and arms.
Can we zoom in on the sleeve a little bit? Do you see any staining on the sleeve as well as the defects, the holes and the tears?
Yes.
What is that staining from?
Again, just from that sliding contact with the pavement, so it's just likely debris and kind of a film from the pavement surface being deposited onto the material.
With regard to John O'Keefe's sweatshirt that you reviewed photographs of, did you see any other defects other than the right arm and the fact that it was cut off of him medically?
No.
Any other indication or any indication whatsoever of anything that you see consistent with road rash?
No.
Okay, let's go back to the full frame. There's a second image I'd like you to take a look at. If we could have the lights for just a second. Do you recognize what's depicted in that photograph?
Yes.
How do you recognize it?
It is the backside of the test dummy from the 29 mile per hour full-on impact test.
Which arm is featured in that photograph?
That would be the right arm.
Move that into evidence as next in order, Your Honor, with the court's permission.
Okay. Exhibit 219?
Permission to display.
Yes.
Does that appear to be the right arm of Rescue Randy as he's face down?
Yes.
Is that following the impact?
Yes.
Do you see any? Were you shown this photograph by Mr. Brennan on cross-examination?
No, I was not.
Can we highlight the right sleeve just a little bit, please? Do you see that defect in the sleeve?
Yes.
Do you also see some artifacts above that defect, above and to the left?
Yes.
Can you tell what those are?
They appear to be fragments from the back window of the test vehicle when it shattered.
Does there appear to be any additional, let's go back to the full frame. Does there appear to be any additional defects on that particular sleeve?
There appears to be some material transfer likely from the pavement and also some road rash.
Does that appear to be transfer from the pavement?
I think that might be a shard of glass from the back window.
What was the condition of the back window after this test?
It was completely shattered.
The defect that we're looking at, that large gash, was that from road rash sliding on the pavement?
Yes.
If we can go back to the full frame, please. I'd like to show you an additional photograph. Do you recognize what's depicted in that photograph?
Yes.
What is it?
It is the front side of the test dummy from the 29 mile per hour full-on impact test.
Does that appear to be a true and accurate depiction of the condition of Rescue Randy in that sweatshirt after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph, Your Honor, is next in order.
Okay. Exhibit 220?
Permission to display.
Yes.
Can you describe what we're looking at in this photograph?
This is mainly showing the upper body of the test dummy from the 29 mile an hour impact test, showing the road rash to the front side of the body.
Were you shown this photograph on cross-examination?
No.
What caused the holes in the bodice of the shirt? In other words, the part that covers the chest and the torso.
After the impact, the dummy was projected and sliding on the pavement surface. So again, this is consistent with the front side of the body sliding, making sliding contact with the pavement, creating those abrasions and holes. And again, that asphalt material transfer that you see on the front.
Can you go up back to the full frame, please? Do you see additional road rash? Take a look at his right arm. You see additional road rash on Rescue Randy?
Yes,
on both the fabric and the arm itself?
correct.
Go back to full frame. And can you see his face as well in this photograph?
Yes,
Are those the chin and nose defects that you saw?
yes.
Are the defects in the shirt that you see here consistent with the condition of the shirt of John O'Keefe as you saw it in the photographs?
It is inconsistent.
May I approach, Your Honor?
Yes.
Another photo that I'd like to show you. Do you recognize, do you recognize what's depicted in that photograph?
Yes.
What is that? We can take this down.
It is the rest position of the test dummy after the 29 mile per hour impact test.
Were you shown this on Friday?
No.
Is that a true and accurate depiction of the condition of Rescue Randy just from a different angle after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph.
Okay. Exhibit 221.
Permission to display that photograph, Your Honor?
Yes.
Is this an overview of the entire body of Rescue Randy after that impact?
Yes.
Take a look at his torso, the exposed portion of his torso. Do you see road rash on his exposed torso?
Yes.
Do you also see that the road rash that you earlier described on the bodice of the shirt, the front of the shirt?
Yes.
And what about, let's go back to the full frame. Is there also road rash on his jeans?
Yes.
If we could go back to full frame. Have you ever heard a phrase, knocked out of your shoes?
Yes.
Where are the dummy's shoes?
They are still on his feet.
And this is at an impact of 29 miles per hour, correct?
Watch the form of the question. Mr.
Sure.
Jackson.
What was the, tell us one more time, what was the speed of this impact?
This was a full on 29 mile per hour impact.
We can take that down. May I approach?
Yes.
Take a look at that photograph and tell me if you recognize what's depicted in it.
Yes.
What is that?
It is the back of the test Lexus after the 29 mile per hour impact test.
Is that a true and accurate depiction of the condition of that Lexus following that 29 mile an hour impact?
Yes, and I should be more specific. It's post the 29 mile per hour impact with the test dummy, not just the arm.
Understood. Thank you. The collision that caused the damage to Rescue Randy that we've just been looking at.
Correct, yes.
Okay. Move for the admission of that photograph, Your Honor.
Okay. Exhibit 222.
Permission to display that?
Yes.
Is this the the photograph that we were just talking about?
Yes,
And this is the condition of the vehicle after that rearward impact with Rescue Randy, correct?
correct.
Did the subject vehicle photographs that you looked at, were those consistent or inconsistent with this photograph?
Those photographs were inconsistent compared to the test.
Was there anything consistent about the shirt that you were shown on Friday, the left sleeve that you were shown on Friday with John O'Keefe's actual sweatshirt?
Was any of that consistent with?
Correct. Was that consistent or inconsistent, now that you've seen all the photographs, with the condition of the shirt that John O'Keefe was wearing on January 29th?
The test clothing was inconsistent compared to that of Mr. John O'Keefe's.
Thank you. You were asked on cross-examination several times about the weight of the hybrid 3 arm. Do you recall that series of questions?
Yes,
You were asked how much lighter the hybrid 3 arm was than the static estimate arm, correct?
correct.
I want to make sure we're clear about this. The hybrid 3 arm is the physical arm that you attached to the ATD and did testing with, correct?
Correct.
The statistical estimate arm is something in the ether, right? It doesn't exist.
Sustained.
How would you describe a statistical estimate arm?
It's probably from taking a sample of the population and getting an average and a high and a low.
Okay. Is that a physical arm? You touch and feel?
No.
Okay. Do you have any information based on everything that you've reviewed at all about the actual weight of John O'Keefe's right arm?
Nothing in terms of a weighed measurement of the arm, no.
Okay. What was the percentage that Mr. Brennan gave you in terms of how much lighter the hybrid 3 arm was than the statistical estimate arm that he gave you?
From what I recall, I think the percentage was 26%.
Did you calculate that yourself, or did you take Mr. Brennan's word for it?
I believe I took his word for it.
Do you recall what the weight of the hybrid 3 arm was exactly?
9.38 pounds.
What is the difference, if you can calculate, what is the difference between what was the statistical estimate arm, the number that Mr. Brennan gave you?
I think I heard him say 11.8, but I also think he said at one point 11.6. So I'm not sure of the final number he landed on.
Does
Sustained. Ask the question. Stop striking the end.
does 11.86 sound right?
Yes,
Okay. Let's use 11.86. Do you have a calculator with you?
I do.
With the court's permission, could Dr. Wolfe use a calculator if he needs to?
Yes.
Thank you. What's the difference between 11.86 and 9.38? Just in raw numbers?
You're looking at just the difference between those two?
Subtract
Okay.
9.38.
Yep. 2.48.
Does that mean there's a 2.48 pound differential between the statistical estimate arm, the heavier arm, and the 9.38 arm from the hybrid 3?
Yes, that's the difference in pounds.
All right. How would you calculate how much lighter? What's the proper way to calculate how much lighter in terms of percentage the 9.38 arm is?
You would want to do a percent difference calculation.
Divide 2.48 by 11.86?
Sustained. Watch the form, Mr. Jackson.
How would you tell the jurors how you would calculate that percentage difference?
You would subtract the 11.86 minus the 9.38, and then you would divide by the sum of those two and divide by 2, the average of them.
Can you do that calculation?
Yes. Okay.
And what's the number?
23%.
Not 26%?
Objection.
Sustained.
Is 23% smaller or larger than 26%?
Objection.
Sustained. Let's move on from that, Mr. Jackson.
What is the number that you get if you were to divide 2.48 by 11.86?
.21.
In
1%.
was the lighter by that calculation than the 11.86 estimate arm?
Yes.
On cross-examination, Mr. Brennan asked you several questions related to kinetic energy formula, correct?
Correct.
You referenced that. Did you reference that formula in some of your answers?
Yes.
May I approach?
Yes.
All right, I'm back. As I said, I'm trying to do some work during their testimony, so taking my notes, working on my my filings. Anyway, very important information that Alan Jackson's trying to clarify. Remember, we talked about the arm and the weight, and where those numbers come from. Obviously, Hank Brennan pulled them out of his ass, and he's using some sort of statistical average for the weight of a human arm for a man at or about the size of Officer John O'Keefe. Well, that, of course, is stupid, as I mentioned before. He hasn't gotten yet to how you extrapolate that and turn that into a reduction in the speed of the collisions. But anyway, and I did the math myself, and I think Dr. Wolfe got it wrong, and then Alan Jackson tried to help him. He said, okay, if you have 11.8 is the statistical average, 11.86, that Hank Brennan offered up and lied about, and you have 9.3 as the weight you used on the Rescue Randy dummy, that's a 2.48 pound difference. I get 21%. And he said 23, and then Alan Jackson tried to correct him to 21. I got 21. I deal with percentages a lot, and it's pretty simple. But the bottom line is, Hank, he lied. You know, he said it was 26%, and then he used that to extrapolate and suggest that the weight, the speed of the vehicle was therefore 26% lower than what was used in the testing. What a lying sack this guy is. Nobody's that bad at math if they're going to be pounding away at that number. And the judge tries to save him by cutting Jackson off at the knees, saying, let's move on. Let's move on. When he's trying to ask the witness, Dr. Wolfe, well, isn't that 21 or 23%? Isn't that less than the 26% that Mr. Brennan told you? Of course it is. And the judge is trying to save Brennan from himself by keeping this jury from being, reminded that he lied about that fact, which he relied on so heavily to discredit the testing done by this doctor. You just can't minimize how important that exchange is and was.
Yes. You're looking at something that's been identified, a document that's been identified as 3 X's, XXX. Do you recognize that? Oh, you're not looking at it. Sorry.
Not yet.
You see it now.
Yes.
Do you recognize what that is?
It is the formula for kinetic energy.
With that, Your Honor, may we display the formula? We don't have to cut the lights. I think it'll be very obvious.
Yes.
Can we bring the lights back up and see if that's visible? Can you still see that, Dr. Wolfe?
Yes.
Your Honor, is that okay?
Yes.
Great. You said this is the formula for kinetic energy, correct?
Correct.
You were asked a series of questions about whether the weight differential in the hybrid 3 arm
would make a significant or material difference in your testing as it pertains to the velocity of the vehicle that you were testing? You remember those questions?
So watch the form again, ask a different question.
Just foundationally, were you asked about weight differential of the hybrid 3-arm?
Yes.
Were you also asked about whether it would make a material difference to the testing if you didn't adjust for the velocity?
Sustained.
What were you asked in terms of, what was the question that was posed to you about the weight of the hybrid 3-arm versus the velocity of the testing?
That there would somehow be an influence on, I think, wanting to make a reduction to the velocity of the vehicle.
Does that make mathematical sense to you?
Sustained is to that one.
Would that have a material difference? With the weight of the arm at 2.48 pounds, would that have a material difference in the testing that you were doing?
No.
Why is that?
Well, to start, that's one of the reasons why we went above and beyond the 24 miles per hour to impart significantly more kinetic energy to the arm. So if you look at that equation, it's a quadratic equation because you're squaring the velocity. So if you double the velocity, you quadruple the amount of kinetic energy. So you get a significant increase in small changes in speed because of that speed differential.
Did you do a test with just the hybrid arm contacting the tail light at 24 miles per hour?
Yes.
Did you also do a test with that hybrid 3-arm contacting the vehicle at 29 miles per hour?
Yes.
I'd like to talk about those two tests. Okay? Can you explain to the jurors what they're looking at? I want to start with going from left to right. What does the E sub K mean in that formula?
So that stands for kinetic energy, which is the amount of energy that an object has when it's in motion and has a velocity to it.
What is the 1/2 on the other side of the equal sign?
Just a constant.
And what does the M, as in Mary, stand for?
So that would be the mass, in this case, the mass of the arm.
And what's the V, as in Victor?
That would be the velocity of the arm as it's accelerated.
Why is there an exponent at the top of the V?
Because you're squaring that. So you're basically multiplying the velocity times itself. So it would be velocity times velocity.
Is this a formula that's traditionally used in accident reconstruction?
Yes, it's very common.
Is it sort of one of the foundational formulas? When did you learn this formula?
Probably back in high school physics.
I'm going to ask you, if you wouldn't mind, to walk the jurors through a calculation dealing with the 24-mile-an-hour test using the 11.86 pound statistical arm as an assumption of the weight of the arm.
Okay.
You
Your Honor,
understand?
may I have a pen and paper to write?
May I approach you, Your Honor?
Yes.
I have a pad here too, if whatever's easiest.
Okay, whatever's easiest. If you assume the mass of 11.86, that's the statistical arm weight, and you assume the V for velocity is 24 in miles per hour. I don't care about the units, doctor. Just assume 11.86 and 24. Can you calculate this quadratic equation?
Yes.
What do you get? I want to do it step by step. What's the result of squaring 24?
So again, you're not concerned about the units.
I do not want to talk about units.
Just okay.
If you mention the word joules, my head will explode.
That's I didn't know if you wanted Newton meters, foot pounds. Okay.
Stop it.
So
Immediately.
just 24 squared
Correct.
is 576.
Do you always, in this calculation, do you always use the exponent first? Do you always do the square first?
Sustain.
What's the first thing that you do in solving for this equation?
You would want to square the velocity, but it's ultimately all going to be multiplied. But yes, you would square the velocity, multiply by itself.
What's the next step after you get 576?
Again, assuming we're not concerned about units, you would multiply by the 11.86.
Can you do that for me and tell me the answer?
How many decimal places do you want? Just nearest whole number?
2.
Okay. 6,831.36.
What's the next step once you get that number?
You would multiply by 1/2 or 0.5.
Can you do that for us, please?
That'd be 3,415.68.
What does that represent in terms of the energy into the taillight? I realize that we're not dealing with the proper units, but does that represent anything as it relates to the energy that's imparted on the taillight?
That would be the energy to the arm
Okay,
that's being transferred.
understood. 3,415.68, is that right?
Correct.
And that was at what mile per hour?
24.
Let's move to a different equation.
Okay.
Now I'd like you to presume different numbers.
I don't know what the question is.
Can you do the same calculation using the 9.38 pound arm that you actually used in your testing for the mass?
Yes.
And can you use the velocity of the actual test you did of 29 miles per hour?
Okay. And same thing, not worried about units?
Correct.
Okay.
What's the first thing you do in solving that equation?
So if you square the 29 miles per hour, you will get 841.
What's the next thing you do?
You multiply by 9.38,
What's the number?
7,888.58.
And what's the next thing you do in the equation?
You multiply by 1/2 or 0.5,
And what's that final number?
3,944.29.
That would be the number or the amount of energy imparted on the arm at 29. Is that right? 29 miles per hour?
So ask it differently.
Sure. What is that 3,944.29 number? What does that mean in terms of the kinetic energy?
That would be the kinetic energy that the arm has if it were moving at 29 miles per hour and weighed 9.38 pounds.
One final calculation. What is the percentage difference between 39, 44, 29 and the other test that we just did, or the other calculation, 34, 15, 68?
So in terms of a percent difference, again, when you're subtracting the two and then dividing by the sum divided by 2, so that's basically the average of the sum, it is 14% difference.
Which of the two tests, the two energy equations that you just did, which represents the higher kinetic energy imparted to the arm? The 24 mile an hour test, that's the hypothetical, or the actual test at 29 miles an hour? Which one?
The 29 mile per hour speed with the arm weight of 9.38.
What does that mean, Dr. Wolfe, in terms of the testing that you did with the lighter arm, 9.38 pound arm, at the 29 mile an hour test, as it compares to the hypothetical 24 mile an hour test?
It would be more force and more energy in the 29 mile per hour impact test.
Even though you used a lighter arm?
Objection.
Sustained.
And what was your opinion and conclusion as it pertained to the subject taillight using the 29-mile-an-hour test? What was your opinion and conclusion as it pertains to the subject taillight? Was that consistent or inconsistent with the damage that you saw on the 29-mile-an-hour test?
It was inconsistent.
Thank you, Your Honor. That's all I have.
Hey all, I'm here with Michael Bryant. Just to let you know, been watching, been listening, had to get some work out. I'm annoyed, I will tell you, at the objections. I'm annoyed at the voir dire of Dr. Lope-Sada. I'm annoyed at a lot of things that happened that I just went to. But we'll talk about it, I guess, when we get to a break. Michael Bryant may go away.
May I, Your Honor?
He has some stuff to do. Let's listen
morning,
to
Doctor.
Hank.
Good morning.
Ready now.
Doctor, did
Right
you
here
have a
behind
chance to
us if
speak
you
to
can.
anybody from the defense this weekend?
Not over the weekend, no.
After you left here Friday?
On Friday, I let them know that I was returning back home, and then I let them know last night that I had arrived, yes.
Did you receive any new information or have any conversation before you came in today?
No.
Now, when we asked you about weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Do you remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Do you remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
I don't know. Remember you answered Attorney Jackson and you said, I don't know where that came from.
Right, referring to, I don't know what source you pulled that 11.8 from.
And so you were suggesting that that is just a number pulled out of thin air, right? Was that a surprising estimate, 11.8 to you?
I don't know that it was surprising. I don't know what your source is for it.
Well, when you engage in accident reconstruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
I'm not usually doing that part of the analysis, no.
So when you're relying on body weight and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the number's just on the thin air. If you're doing a study and you have to figure out damage to an arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
So you just make it up out of thin air. You have to find a resource, a reliable, vetted resource. True?
I would agree.
And that's what you do.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that the 216-pound, 6'1" man would have an arm that weighs 9.38 pounds? Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective. My specific question is,
So it's sustained. Ask the question again.
I'll ask you again, Doctor. Tell us where you got the 9.38 pound value from when considering a 6'1", 216 pound man. Where did you get that from so you could be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you just a very simple question. Dumb it down for me if you can, okay, Doctor? Where did you get the source to legitimize using a 9.38 pound arm for a person that's 6'1", 216 pounds? Where did your source to say that arm is validated to use for that size man? Where is that?
Again, it's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, in our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Is that your answer?
Yes.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile, isn't that fair to say?
Correct.
And there is, in fact, a 95 percentile crash test dummy, isn't there?
There is, yes.
Yeah. You chose the 50th percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less. True?
Correct.
The truth is, you have absolutely no study, no paper, no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference or study you can offer us right now, do you?
I don't agree with that, because again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head, and to calculate the force, he adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
So you have one paper, one study. I know the answer to this, but let me ask. You have one paper, one study to support that it is appropriate to use the 50th percentile 9.38 arm for a person who is 6'1", 216 pounds. I won't ask you again, but if you can answer this once for me. Do you have one paper, one study?
So I'll take out the commentary. Can you answer that? Or answer that question, please?
Sorry, can you repeat the question?
You have one paper. Give me a name, an author. One paper, one study that supports using a 9.38 arm, 50th percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and is 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
You talked about, however, would you come up with the number 11.8? Like it was something that is curious or foreign to you, right?
Objection.
Sustained.
Are you confused how the number 11.8 would come up?
Objection.
I'm going to allow that.
I'm not confused, I don't know your source for it.
When you do studies, would you agree that the head has a similar weight to the arm and that the weight of an arm would be about 5.48% of a person's body weight?
I'm sure that there's various studies out there that talk about that could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer, you're the expert. When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case, dating back to last year, It's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment of the evidence, and you're relying on other people's math? Is that what you're telling us?
I don't agree with that because, as I've mentioned numerous times, Dr. Rentschler and I worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about statistically vetted, that it's 5.48% of the total body weight? Would you agree with that?
It sounds about right, but again, I
Okay.
don't have the percentage off
So
the top
if
of
you
my head.
take 5.48% of a 171-pound man, which is the crash test dummy you were using, the 50 percentile, what do you get?
You said 5.48%?
Yeah,
Just over 9 pounds,
okay. Close to 9.38?
9.37.
Okay, now when you have 216 pounds, 5.48%,
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now, you said you had some confusion where I'd get that number from, this 11.8. Do you remember that?
Yes.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11, is that the first time you heard of it from anybody, 11 pounds? Is that a new number to you?
I don't understand your question.
Well, you're saying that when Attorney Jackson asked you, where did Brennan get those numbers from? You said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8
Yeah.
or 11?
11.
As I just mentioned, last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony, 11 pounds. Your prior testimony, right?
Yes,
You testified before under oath in this case, didn't you?
correct.
And when you testified under oath, and you were giving a general estimate about the pounds of Mr. O'Keefe's arm, based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath.
Yes.
Right. You can't delete something that's under oath, right?
Sustained.
And so when you feigned confusion on Friday about this 11 pounds,
Sustained.
so when you answered questions last Friday about wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds before yourself, haven't you?
Yes, but again, I don't know where you got that 11.8 from, so.
Well, we just did the math, didn't we?
Yes,
Okay. And you used a calculator to help you, didn't you?
I did,
Your
yes.
calculator works?
Yes,
Okay. You said you wouldn't calculate the difference, but you did. And so what you just went through this exercise is you divided that difference, that 2.48 pound difference, right?
correct.
And then you divided it by 11.86. Divide 2.48 by, from the 9.38.
Okay,
What percentage do you get?
26.
Would you agree with this statement about whether the arm and body weight, comparing the weight of the head to the arm, would you agree that the head and arm are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight? So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so I,
Didn't ask you. I'm asking if you would agree with that.
can you repeat the question, please?
So ask the question.
Does the arm weigh the same as the head? Or the arm does weigh the same as the head, almost identical because your arm, just one of the arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. Would you agree with that?
I haven't done the calculation, but if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object if it gets hit center mass, that's going to be even greater force because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
Objection. Source.
I'm going to allow the question.
Do you agree with that?
Yes, and I think I described that a little bit earlier, is you would increase the mass, you multiply it by the acceleration, that's going to increase your force. Force is equal to mass times acceleration.
Right. So mass has a direct correlation to force. You agree?
Correct.
So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree with that, wouldn't you?
Correct, more force on the arm, yes.
Right. So weight matters, doesn't it, sir?
Yes.
Force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change the weight, same speed, it changes the amount of force.
Correct, yes.
Yeah. Okay. When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints.
No.
You didn't explain it to the jury that there's a difference in weight matters.
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you explain to the jury about the difference in force when there's a change in weight? When you did all your PowerPoint and calculations, did you break it down for them?
Well, I think it was certainly stated. I mean, I know that we went over Newton's second law, force is equal to mass times acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the speeds, did you explain to us that there's a difference when you change the mass so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate the force for the speed of test so it looked like the collision had to happen at a faster speed to cause a certain amount of damage? Were you doing that intentionally?
No.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have created the opposite illusion, right? You used a weight that was lighter than Mr. O'Keefe's estimated arm.
Right, because again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with Mr. O'Keefe's sweatshirt and his arm, and you gave some opinions about what you would expect for damage to his arm. When I asked you on Friday whether you had any support, any vetted journals, learned treatise, any support whatsoever about whether you should use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
Putting aside the fact that you have absolutely no professional studies or journals to support that you should be using a crash test dummy's arm for these type of tests, are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and a person's body? Are you aware whether that exists?
I'm not aware of those studies, no.
As a inquisitive engineer, wouldn't you want to know if there was legitimate studies in your work, in your profession, that suggests or states that you should not be using crash test dummies to determine injury to the arm as far as lacerations? Would you want to know that?
I think, again, you're getting confused between my role and Dr. Rentschler. Can I finish, please?
No, objection.
Okay, so, no comment, Mr. Brennan. Answer the question, please.
I wasn't addressing the lacerations or the abrasions to the arm, sir.
You had photographs and you were opining that you would have expected or you would not expect there to be abrasions or cuts on that clothing in your test A and B, didn't you?
There were no holes or cuts in the material, no.
I understand, but you offered opinions. Didn't you offer to the jury an opinion that the abrasions on Mr. O'Keefe's arm were inconsistent with your tests in A and B?
The cuts and the holes are inconsistent.
Sir, when you are assessing cuts and holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
I would agree with that.
And so if there was literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the tail light.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes.
You push a human arm, it's like an indent. You can push in, can't you?
Yes.
And that property of pushing in, if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard. Isn't it?
I don't know that I agree with that.
Well, do you disagree with that?
Well, the hybrid arm is of vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure. Human arm, softer than the hybrid, yes?
Yes.
When you push it, you can push in, much different than the hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
Which creates an easier, tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human, it pushes different than the crash test dummy, would you agree that a crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm? Would you agree?
I don't think I would agree with that, no.
When you used the crash test dummy in test A and B, that was the 5'9" dummy?
Yes.
When you considered tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt?
Don't know if I recall the exact size, but I think one of them might have been an extra large.
And then you bought a second one that was medium. So when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large. You used a medium sweatshirt, yes?
Yes.
Because it was a smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in test A and B, did you?
I don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolfe? And while she's pulling that up, is there a difference between, see that's how that's blue? You see that's medium?
Yes.
So the blue ones you use to test A and B, correct?
Correct.
the smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Correct.
And then when you used Randy and brought him into the scene, you used the extra large, the gray one.
Correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new.
Correct.
The extra large you put on Randy was new.
Correct.
Did you consider the wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
The wear and tear?
Yes, the wear and tear.
No.
Did you ever consider the differences between a brand new sweatshirt and one that had been worn?
No.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes more easily. Did you do any type of analysis on that whatsoever?
No, I don't allow that.
Any type of analysis whatsoever on the age or whether it's stretched the same, anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Okay. Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
No.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis and offered an opinion in front of a jury on this?
Specific to impacting an arm with a taillight, yes.
Before you decided to come in and give an opinion, did you take any study or look at any journals on fabrics?
No.
Did you consider any of the variables that one would want to consider regarding fabrics before you came in and gave this opinion?
No.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you have never done before, and that you did absolutely no study on fabrics or any of other people's analysis on fabrics in cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. Again, we worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yeah?
Correct.
You're the one testifying, giving opinions to this jury, yes?
Yes.
You're the one asking them to rely on your experience and training, true?
Correct.
You're the one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion, putting aside Dr. Welcher or Dr. Rentschler. You have responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
Well, when wouldn't you? When would not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes,
Every single time?
and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
Right. But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in this subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
You wrote a report back on February 12, 2024.
Correct.
In February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair. Do you remember writing in a report, it is significant to note that the injuries have been classified as abrasions and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis?
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection sustained.
I'll move on.
The objection sustained.
Did you agree with that?
Sustained.
Did you write or endorse these injuries would not result from impact with a non-damaged tail lamp cover and the amount of force required to fracture the tail light cover?
So I'm going to see you in Sidebahhh.
Well, I'm waiting for Michael Bryant to pop on. I know he's listening too. This is, shall we say, nonsense. This is nasty. This is ridiculous questioning. She is even fondling sustaining objections on Hank Brennan's questioning. Okay, here, because he's made it clear it's a joint report. He does, Rentschler is going to be the biomechanical engineer. He's the accident reconstructionist. Hi, all. Yes, hello, everyone. Hello, everyone. I was listening this morning as I was working on something that had to be out on a matter, and I know Michael Bryant had taken over. But this is this morning's questioning. It was also ridiculous. Where are we? The defense entered into crime scene photographs of the garage at the Albert House, which they probably got through the investigation, right? That's what you do. You get discovery. And then you give all of your discovery to your experts, including your medical examiner, if you want to have them opine on whether or not an injury, for instance, in the garage or something in the garage that could have caused the injury. The judge is refusing to allow the defense investigator to put those in. And I think it's ridiculous. So what do they have to do? Call a cop? You should be able to put those in. That's exactly what should be happening. So everyone can rely on what the state has provided. They provided things to you. By the way, I see that we have some starred questionings to making account. Objections on the floor. Hank still talks. Yes, he does. He keeps talking and talking and talking and making his nasty self known. Now, he must have a feeling the jury likes it. I don't know. I think it's absolutely ridiculous. Okay. Making account member for 1 month. I just did that. Thank you very much. Blessed in Texas. Oh, Linda, you look lovely. Please discuss this badgering of the witness. How would a normal judge handle this? Yes, I think that this has gone beyond. Even she is now is feeling the badgering. Look, let's talk about a number of things. This supposedly discrepancy in weight. No one cut off John O'Keefe's arm at the autopsy and weighed it. Okay, you can use an average, but here, remember, Dr. Wolfe is rebutting Dr. Welcher. Dr. Welcher used the 50% average. He used the median. He used the mean, right, to make his testing. So what Rentschler and Wolfe did, or basically Wolfe, is take the same mean that Dr. Welcher used, because they're here at this location now to rebut Welcher's testimony. So Hank Brennan's making a big deal that they didn't take a study that says a 6'2" man would have an arm weight of 11 or 12 pounds as opposed to Rescue Randy, who is the normal crash test dummy they use, which has an arm weight of 9 point something pounds. And how you adjust for that is you increase the velocity. So what they did to adjust for that is not only do the testing at lower weights, at the lower weight at 24% speed, they also then did it at 29% speed, which would account for the differential of the weight. It's very clear to me, and I really didn't do anything in physics with college or anything. And so that's what's going on here. So that's why we had those weight issues, which don't really matter, because again, everything is a possible adjustment, or what you think somebody's arm weighs. I mean, but because you don't cut the arm off at autopsy and weigh the arm of somebody. That seems to be the answer. And I wish somebody would just say that. I wish, stop being so generally, Dr. Wolfe, and just say that. Maybe you can ask that of get that question in of your forensic pathologist. And then we also learned that there's a motion to exclude Andrew Rentschler. I have not read the motion, so I really can't talk to you about it yet. I will read it. I'll try to read it as we go back to testimony. And then, and I think Michael Bryant is reading it for us. And then we have the whole idea that we have to have this voir dire on Dr. Lope-Sada, a medical examiner. Now, look, she had five dog bite cases with deaths. Now, people generally don't die of dog bites. That's why medical examiners don't get so many of those cases. But I talked to you about a case in Canada, a famous case that caused a commission in Canada to be put together with a 600-page report about 20 years ago of a Dr. Smith who misidentified a dog bite as a stab wound and put an innocent woman in jail. And the Canada Commission, the Canada forensic pathologists all got together naturally and said, look, forensic pathologists know dog bites. They know to identify dog bites. This guy was just an idiot, all right? And he didn't have any expertise. He was overstating his expertise. He was overstating and misidentifying these wounds. He's basically a stupid ass forensic pathologist, okay? Let's call it like it is. And Canada was smart enough to say, look, medical examiners know a dog bite from a stab wound, and they have to know it because they can't put people in jail for stabbing their child, which is what Dr. Smith did when indeed a dog committed the actions. But so medical examiners usually see dog bites of people that die. Dr. Russell sees dog bites of everybody, but it's not wrong to have a medical examiner opine whether some injury is a dog bite because they're supposed to know the difference between that and other injuries. And here, she won't even allow she's considering not allowing Dr. Lope-Sada to talk about pattern injuries that a medical examiner sees all the time. She's allowing all these other people who don't have that expertise to talk about it in the prosecution's case, but when you get a real expert, they can't talk about it. I find this outrageous. I find it reversible error if this happens, if Karen Read gets convicted. Now, you may think that Karen Read's guilty or not, but Karen Read deserves a fair trial on fair rules of evidence, all right? And this is what's driving everybody crazy because they see this happening, this whole idea of corruption happening around them. They live in this area where they've seen the Sandra Birchmore case, which my husband broke open for the civil attorneys and said Sandra Birchmore was not a suicide, but was a homicide. And they saw that the cover-up of the police officer who was having a relationship with her and grooming her since she was 12 years old and then got her pregnant and then killed her because his wife was also pregnant he killed her the same day that his wife went into labor and was giving birth to their baby. So they see that there's this cover-up of all police actions. They live in that community where this has happened. They know there's a problem with it. That's why people are getting voted out of office. And there I see Michael Bryant. And so now we're getting this badgering by Hank Brennan on Dr. Wolfe, who's telling you, yes, we did a joint report. I did this aspect because we're responding to Welcher. All right. Jackson's got to make that even clearer on his redirect. He's responding to Welcher and using the same statistics. He's using the same percentage. He's using the same median that Welcher used. And all Welcher did, believe it or not, was do that little blue thing, the blue man group. I mean, for this judge to not allow some of the testimony that she's not going to allow after she allowed the bullshit testimony, that's a legal term, from the prosecution is wrong, is reversible error, but the problem is somebody has to go to jail for there to get reversible error review by an appellate court. All right, I can see you're all upset, you're all annoyed. Why don't we go into court? Let's listen to what happened after this sidebar. I'm going to go behind the 2B but I'm right here.
You were asked questions about impact with the taillight. And in fact, in one of your answers to me today, you talked about after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't there?
Correct.
And so while or plastic that shatters from a taillight might not impale clothes of the skin, would you agree if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy and the taillight?
Well, the arm, as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off? Would you agree with that?
At some point, they will separate, yes.
At some point, but before the at some point. What I'm asking is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained?
Sorry, can you repeat the question?
Yes. Would you agree that if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters, if the dummy wasn't restrained and moved regularly, it would extend the contact between that shattered taillight and the dummy's arm? Would you agree with that?
It would move with the vehicle until it got pushed out of the way, just move to the side,
And
yes.
so what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Dragged? I don't know
so
if
when
I
say
understand.
drag, push. How about we use the word push? Pushed by the broken taillight. Could that happen?
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your question.
Well, no. You said it moved the vehicle. Sometimes it moves even faster, suggesting space between the broken taillight and the arm. That's what you're suggesting, right?
Correct.
So it can move with, it can move faster. Can it ever move slower and the vehicle pushes and drags against the arm?
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand, but before it moves out of the way, could it be pushed by that broken taillight? That's the simple question I'm asking you. Could it be pushed by the broken taillight?
Just moving adjacent with the taillight, just moving along. Yes.
Would you agree with this? If you have an arm struck at 25 miles per hour, significant more damage to the that taillight shatters, hits and moves forward into arms, parts of taillight pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken taillight can, in fact, push the arm? Would you agree with that?
Generally, I guess, again, it would move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of the taillight if the taillight broke, correct?
Just moving at a common velocity.
The operative word here is push. And so do you like to agree with me or you could disagree with me? Can the broken taillight push the arm so it contacts and provides force against it? Could that happen?
Yes.
When you were showing those photographs today regarding Test F, now you use Randy in Test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16 pounds less than Mr. O'Keefe, yes?
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle.
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear. He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate, studied crash test dummy, is he?
I don't agree with that because, again, we use that type of dummy in all different types of tests.
There's an H395M PED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did the test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
That is one way, yes.
Right. So that way you don't have to put the dummy on a forklift, and then it creates a different scenario than real life, correct?
That could be one way that you could do it, yes.
It doesn't impede any roll or drag when the dummy's hit. That's one reason you would do that rather than a forklift, yes?
Correct.
Also, it might show some throw, which could lead to other type of damage like holes in clothes, yes?
Correct.
But you didn't use the magnet, you used a forklift.
Because again, the purpose of the test was to evaluate, we talked a lot about those time frames, right? That 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that, 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet, you used a forklift, right?
Correct.
And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you?
We didn't expect him to?
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Oh, I certainly expected that.
So you expected a throw with that?
Yes.
Okay. And the street has hard concrete and it has a lot of irregularities to it, doesn't it?
It's asphalt, yes.
Yeah. In the photos that you were shown today on redirect examination, did the defense show them to you during your direct examination? Any of those?
No.
Ms. Gilman, can you pull up that last exhibit with Randy on the ground? I think it's exhibit 221. Okay. And so this is Randy, right, doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
Appears to be a fragment of the taillight.
Can you zoom out? Could you go back an exhibit to the one before? Could you zoom in? Did you see any taillight fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please? Can you tell from here?
Yes.
In finding taillight fragments on the clothes after a collision, that's not unique, is it?
Unique? No,
Yeah.
it's possible.
Well, according to this, it's probable, yes?
In this test, that did occur, yes.
Could we have exhibit 201D, please? Do you know what this is, doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards found in Mr. O'Keefe's clothing?
Objection.
Sustained.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No, sir.
Can you take that down, please? When you did your analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I don't know if it was on the concrete, it might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please, Cindy?
Objection.
Sustained.
Did you talked about cuts and injuries. Did you,
Sustained. It sounds like it's beyond the scope.
very well. When you did test D, did you say the peak acceleration was 780 Gs?
Your Honor, may I refer to my notes?
Yes.
Page 11 of your report.
I think I lost an exhibit. Okay.
Is that what you described it as?
For test D,
Yes.
the acceleration of, we talking about the hand?
Yes.
780 Gs, yes.
780 Gs. Okay. When you did your comparison before you gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Objection.
Beyond the scope, Mr. Baden.
A few more questions, Dr. Wolfe. You showed us holes in Randy's sweatshirt from test F. You remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
Sorry, can you repeat the question?
Yes. When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the,
May I approach and retrieve the exhibit, Your Honor?
Yes.
Excuse me, sir. Did you ever look at the back of the sweatshirt to see if there was any holes to the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. Do you see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here, 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 here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry, can you?
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken taillight shards in his clothing, did you?
No.
I have no further questions.
Yeah, just a moment, Your Honor. Very good.
All right, so we're getting a little bit of help here from the rest of the team to Alan Jackson as to where he goes on the redirect. It's going to be very limited by the judge. Let's listen.
Mr. Brennan, give me one name, very dramatically, of someone.
The objection sustained.
You were asked to give me one name to support using a 50 percentile hybrid 3 in testing forces on a 216-pound man. Do you remember that question?
Yes.
How about the name Judson Welcher? How about that name?
So the objection sustained.
Did Judson Welcher use a 50 percentile hybrid in his drop test?
So that's sustained as to form.
What did Judson Welcher use in his drop test?
A hybrid 3 50th percentile male, the same that we use in our testing.
You were also asked whether or not using that hybrid 3 arm with the same speed would have an effect on the force equation, on the force calculation, correct?
Correct.
And you agreed it might have a small effect on the force calculation, correct?
So sustained as to form.
This is just foundational, Your Honor.
Sustained as to form.
How did you answer that question?
I'm sorry, can you repeat the question?
Sure. Let me ask it this way. In the 29-mile-an-hour test with the hybrid 3 arm, were you going faster than 24 miles an hour?
Yes.
And what was the calculation again on the increased force that would be exerted on the taillight, on the arm area of the taillight? 14%?
Yes.
So sustained.
How much, what was the percentage that you calculated? The increase?
14%.
And did you find damage, even with the increase of 14%, did you find damage on that exemplar taillight consistent with the extensive damage on the subject SUV?
I'll allow it.
No.
Can we have 201D put up one more time? Mr. Brennan just asked you if you made note of these little red pieces, correct?
Correct.
Do you have any idea the size of those pieces? As you sit here.
Not without a scale of some sort, no.
So as you sit here, do you have any idea what the size of those pieces are?
I couldn't tell you as I sit here today, no.
No idea if they're a foot long?
So the objection sustained.
You were asked, when shown this picture, if you accounted for this in terms of damage to the garment, the sweatshirt, right?
Correct.
What if I told you those were,
Objection.
So the objection's sustained. He said he doesn't know the sizes. That's the end of that, Mr. Jackson.
I realize he said he doesn't know, he was asked questions, Your Honor.
That's the end of that, Mr. Jackson.
Do you have the, Mr. Wolfe, do you have the picture of the tin? The TIN, tin, the little round tin? Do you see that tin?
Yes.
Are you aware that all those pieces are inside that tin?
Objection.
Sustained. And jurors disregard that.
Did you ever see this tin in your analysis?
I do recall seeing, yes, in the evidence photographs of all the fragments, yes.
In your experience, are very large pieces or very small pieces put in little tins, about 2 inches wide?
Sustained.
You were asked a question about the arm being pushed by the taillight. Asked a bunch of questions about that, right?
Correct.
You indicated, what did you say in terms of the contact by a vehicle pushing an arm?
It's going to move with the vehicle until it separates.
Okay. In your testing, how long did it take the hybrid 3 arm to get up to speed of the vehicle in the 24-mile-an-hour test?
About 10 milliseconds.
I'm sorry, say that again, about
10 milliseconds.
10 milliseconds, correct?
Correct.
So when you say the arm is being pushed, it's being hit, correct?
Objection.
The objection sustained and it's struck.
In every one of your tests, every single one of your tests, did any taillight fragment tear a hole in the sleeve of the shirt that you were testing?
No, there was no holes, punctures, fraying, nothing to the material.
Was there ever a defect in that garment in any of that testing other than the road rash that we saw in the 29-mile-an-hour direct impact?
That the only test that showed the holes and the abrasions was that full-on hit where the body was sliding on the ground. There was no test where the taillight caused any type of punctures, holes, or fraying to the material.
And in that test, what happened to the back of the license, the test license?
Destroyed.
You heard I have follow-up questions.
Okay, go ahead.
All right. So AJ opened up with what I said. I don't know. Maybe they're listening to me, or maybe I've just tried a few cases in my life with exactly what I said he should ask. Make sure the jury understands that he's rebutting Welcher's testimony and that Welcher used the 50% median average dummy. All right. Oh, by the way, we had Stephen Plord on 3 times on our show, including the other night. If you want, you should really watch it when he has some time, because he talked about Rescue Randy. He talked about the other crash test dummies that you'll see, when you see these auto accidents that the NTSB does and all that, and the National Highway Safety Administration, I should say. They're $100,000 because they have sensors embedded in them. No one uses them because you have to use 3 or 4 of them if you're going to do a test, and you can replicate what the question is that you're trying to answer without using them, with using the way ARCCA did, and that's why the feds were very happy with it. You're not going to spend $400,000 on crash test dummies, which you're going to every single time you did a speed test. Maybe that was $500,000 because I did 5 speed tests. Use those with the sensors that are embedded, because you don't need to, and no one does it. All right, it's not the protocol. Welcher used his arm, okay, rolling against the back of the taillight. I don't know if the jury is putting 2 and 2 together, or that they're falling for this cross-examination here. that Hank is doing, or I should, that Hank did, that Hank Brennan did. I mean, as I told you, he is stylistically a very good attorney, very good defense attorney, that he's using those skills as a prosecutor when he should be seeking justice. But I'm so happy that Alan Jackson led off with that point. Now, I wonder what the jury's reaction was to that. All right, let's go back into court and listen to this.
On redirect, you again talked about
obviously
the
Alan
impact
Jackson lost
between
that,
an
and so now
arm
we've got Hank Brennan on
and the broken taillight.
Recross.
Correct, yes.
And I had asked you on cross-examination or recross-examination whether that broken taillight could push the arm, which of course would create force or friction, yes?
Well, once it's moving at a common velocity, I'm just not understanding your question then.
If it's not a common velocity, if the broken taillight is,
Ask the question.
if the broken taillight is pushing the arm, which would mean the broken taillight is going at a faster speed than the arm. If it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, let me ask you this. Would you agree with this? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. Do you agree with that?
Objection, I'd like the source.
No,
Dr. Rentschler, do you agree with that?
Objection.
so I'm going to allow it, strike the source.
Do you agree with that?
I'm sorry, can you repeat?
I can. If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, specifically if there's a taillight that shatters, so you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. Would you agree with that?
Objection.
I'm going to allow it.
In reference to the greater damage, are we talking about damage to the arm?
Do you agree with that phrase?
The best way I can characterize is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way.
Objection.
Do you agree with that?
I'm going to allow it.
No, you need to approach. I need to approach.
All right, what you have here is Hank Brennan trying to get his theory in, and this is not recross. The doctor has said, I don't agree with that a number of times. Hank Brennan only wants to say, well, he was pushing. The doctor say, no, it's moving with the taillight. There's no such thing as pushing, because I'm glad AJ is objecting. I don't care whether or not the judge now even overrules or overrules it, because I think the jury is getting the feeling that this is simply unfair, okay? Because, yeah, she's always allowing it. I'm going to allow it. I'm going to allow it, except when it's a defense and they have real evidence, and then she doesn't allow it, all right? Which really is starting to annoy me, because I want to hear the answers to real questions, and I want Hank Brennan to stop the badgering. He wants to push the push theory that somehow this is pushing in so that he can get the taillight fragments embedded in the arm and causing damage, right? That's what Hank Brennan is trying to do. That's not what Dr. Wolfe is saying. And that's probably not what Dr. Rentschler said. They're saying the arm is always moving with the taillight. And then when it separates because of the speed, because of the velocity, then he falls, he gets road rash, and they're not the same injuries that you saw on John O'Keefe, no matter how hard they're doing it. So this tells me Hank Brennan is really worried about those injuries. He's really worried about those patterns. And that's why he's making all the objections, by the way, this morning to Dr. Lope-Sada's testimony, okay? Because he doesn't want including the fact that she was going to say apparently that something in the garage would have caused that imprint that was on the back of the head. And so, and she's trying to cut the defense off at the knees here, okay? My feeling is that when judges, when they appear to be so biased, the jury at some point gets it. Usually they love their judges, but at some point gets it, because they want to hear the truth. They want to hear the truth, not what Hank Brennan's truth is, not what the Commonwealth truth is. They want to hear the defense truth. They want to hear the truth.
Okay.
All right, let's go in. Obviously, AJ lost the objection. Let's go in.
Would you agree if you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that?
Again, my area of expertise is not injuries to the arm, so whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
When you do a demonstration, isn't this exactly what you see? Could you play E again for me? Isn't this exactly what you see? Play that, please. And now, stop, please. If Randy is not restrained by a forklift, he is going to move with the car, correct?
Well, if it's just the arm, his arm's going to get accelerated and move, and then his body will be there still.
And that broken taillight, if Randy is not restrained on a forklift, is going to be pushed, like this says, by the arm, by the broken taillight, isn't it?
It's going to move with the arm.
Thank you.
All right, so jurors, we're going to take a morning recess. We'll see you in about 20 minutes.
Okay, a morning recess.
Right this way.
I thought they were going to do Dr. Lope-Sada's voir dire during the recess, but I think she just said 10 minutes for the morning recess. So what is she planning to give them a longer lunch, an hour lunch, and do Dr. Lope-Sada's voir dire then before Dr. Rentschler? Because she also has to rule on the motion to exclude Dr. Rentschler's testimony. And I hope Michael Bryant is reading that motion, because I haven't had time to. Hello, Michael Bryant, if you're hearing this somewhere out there and all. He was nice enough actually to take my morning shift, as you know, for the first hour and a half when I had to deal with some issues dealing with the case. So we're
not going to do
listen.
the voir dire right now of Dr. Lope-Sada because everybody needs a break. What we'll do is we'll take the 20-minute recess. Who's doing the direct to Dr. Lope-Sada? Is that you, Mr. Jackson?
Yes.
All right. So what I would ask you to do is not do anything on your direct examination with Dr. Lope-Sada that involves the mention of dog bites or the evidence regarding motor vehicle experience, because we still need to have the voir dire. But I don't want the jury sitting out there any longer than need be, at least until the luncheon break. So without that, how long will it take you? Can you use the hour?
Thank you for the credentials, but Your Honor, half of her credentials are the fact that she's an expert in dog bites and an expert in motor vehicles. I give her education, training, background. But
Okay, is that all in her resume?
it's all in her. It's all going to be in her direct examination.
No, my question is it in her resume? Has the Commonwealth received notice regarding the dog bite stuff?
The Commonwealth has received the same resume that the court has received. I don't know specifically what her resume says about dog bites. I don't think it says the word dog bites anywhere in her resume. No.
We have absolutely no notice.
But the courses that reference dog bites are.
No medical examiner puts in, I've done
Say that
5
again.
dog bite cases, 20 motor vehicle cases. This is ridiculous. She knows that.
Dog bite
Come on.
recognition and pattern recognition. They're listed in the resume.
All right. We'll see you at 12.
All right, so what she just did there is said she's not going to do the voir dire. I gather Dr. Lope-Sada is on next, and Rentschler is going to follow Dr. Lope-Sada. That's what I'm gathering, okay? Since she just asked if Jackson does the voir dire of Dr. Lope-Sada, not the voir dire, if he does the testimony, don't mention anything about dog bites or motor vehicle accidents. That is ridiculous, all right? This is absolutely ridiculous. I have to tell you. All right. Because you don't, as a, I want to go call my husband and say, honey, on your CV, which I've seen over for your 50 years of experience, do you put in how many dog bite cases you're on? Do you put in how many motor vehicle accidents you're on? No, that's usually done during the voir dire. So now she's going to rule what? A discovery violation because you didn't give notice about how qualified your expert is when you've had her report talking about dog bites and motor vehicle accidents since before the trial began. That's why that there was no issue of her compliance with Rule 14. And so now this is what we're dealing with. I find this totally ridiculous. I don't know about you all, but I find it totally unfair. Okay. I find it totally ridiculous. I find it totally unfair. And I guess she also has to read the motion on Dr. Rentschler, which I still haven't read either, because that was just filed to exclude Dr. Rentschler's testimony, which Hank Brennan wanted to do little picks and parts of this. No, this is not lunch break. This is actually just their morning break going to 12. And I guess they're going to have a very small, they'll probably do some direct of Dr. Lope-Sada. And I don't know. Does the fact that she has experience in dog bites and motor vehicle accidents not be able to mention when he does her qualifications, which you normally do first? So I mean that has to be clear. This is so ridiculous, in my opinion. At this point, this is so ridiculous. And oh, by the way, you can't use discovery you received of photographs from the state, which tells you they're actually actual, to have your experts look at them. Even if the prosecution didn't rely on them, that should be irrelevant. That's the point. If the prosecution didn't rely on their own evidence that they had in there, okay, that is the whole point. All right. I am beside myself with this. All right. I am actually beside myself with this. And by the way, good for Dr. Wolfe. Okay. Yes, he actually didn't take the bait. He sat there like a gentleman. He answered all the questions. And I think that I don't know what the social media keyboard warriors are out there saying for the the anti-Karen Reed. We on this channel are pro-Constitution. We're pro having the prosecution prove their case beyond a reasonable doubt, right? That's what we're about. We're pro that, all right? And that's what we want. That's what Michael Bryant and I have said we want for all this time. Pro-prosecution. So let me see some of your comments. By the way, everybody, thank you for being here. If you are coming in from X Twitter, please hit the subscribe and the like, if you would, here, because we are a YouTube streaming channel that we are simultaneously streaming on X and Twitter. But we'd ask you to go to our YouTube page, very simple, and hit the like and subscribe on that, and we'll put I'll put the actual link to our YouTube page in the comments here, so you can see that. Yes, we're just pro whatever the prosecution, if they can prove their case beyond a reasonable doubt, so be it. That's what we've said from day one. But this whole idea that you have to actually, you have to deal with this Hank Brennan, and you let him go far afield, right? You let him go all over the place. You let him question everywhere. And then when the defense wants to just put in their case, and I'm glad Alan Jackson was doing what he was doing. I don't know what the jurors are feeling. I don't know what their testimony is. I mean, I've seen problems. I've seen issues with regard to just this whole testing at the beginning. They said, well, and you could come to this conclusion. Well, no one believed that the taillight could fracture from hitting an arm until the test of Dr. Wolfe that he brought up, the defense brought up to rebut Welcher. All right, because Welcher didn't have that. Welcher just had the blue man touching the taillight. And that's true. I mean, so if you have a jury that just wants to say that, that's true. That could be a problem for the defense, because some jurors could just say, as I've said, Occam's razor. Well, now we know this, the taillight could have fractured by hitting an arm at 24 miles an hour, but you still have to have that collision. See, that's what the defense is right from the beginning. This is what I said for the first trial. If you don't have an impact, it doesn't matter. All of it doesn't matter whether there could be a taillight fracture or not. If you don't have that impact, okay, all right, then it does not matter, all right? And it's the impact that counts. That's why Dr. Lope-Sada is so important. That's why the medical examiner for the state was so important. That's why the prosecution went around their own medical examiner, because she said no indication of impact, all right? And this is why the FBI also felt no indication of impact. They did not they agreed with ARCCA, all right? That's why and think about this. The defense cooperated, wanted the FBI investigation. Why would you want an FBI investigation unless you believe that your client was innocent, unless you believe there was no impact? And what they're trying to show here from all of this testing, and we're giving you everything, ladies and gentlemen. We did the testing that Dr. Welcher should have done. We're going to show you that you can break the taillight, but you're not going to have those injuries. And it doesn't matter whether the arm is 9 pounds or 12 pounds. It simply doesn't matter, because the arm is going to go with the car. And so all you do is that you increase, if you want to say there should be a difference, that's why you increase the car rate to 29 miles per hour from 24, because it accounts for the more mass. It gets you more as if there was more mass, all right? It's very simple. It's simple physics. It's simple math, okay? And in fact, this is the group that did it, okay? This is the one that did it. And Dr. Wolfe is the reconstructionist. And Dr. Rentschler is going to talk about the impact injuries and why the impact injuries aren't the same. All right. Because we all seen those arm wounds. They did not come from in my opinion, since I'm now a lay expert on the jury, they didn't come from that taillight fracturing. That taillight, even if you did see it, was all over the place, right? And yes, was there one taillight where the dummy was moving? Where I hate to call him a dummy, Rescue Randy. You know, you've given your life so many times for people to save you. You're not really a dummy. You're Randy. You're Rescue Randy. Even as I said, Stephen Plord talked about Rescue Randy. Everyone uses Rescue Randy. Everyone uses Rescue Randy, and they call him a crash test dummy, even if he doesn't have the sensors embedded in him for the crash test. Okay, because no one goes out, if you're doing these tests, and buying the $100,000 sensor dummy unless you're doing it to see what the impact of car accidents is for the National Highway and Safety Transportation, to see what happens to cars, to see whether they have to survive an impact and all that type of stuff. Well, let me hold on a second. Since I am in since I'm dressed today in all Justice Served TV, let me take my Massachusetts Dunkin' Donuts drink. Sorry about that, guys. Rescue Randy, yes, everyone loves Rescue Randy. Right. But that was one piece that traveled with him, one little piece. It wasn't 47 pieces of the taillight. And it wasn't from the area that that Karen Reed's taillight was cracked that Officer Barrow saw. That we saw those diffusers light up when she was put on, when the car was put on the tow truck. So I hope you all know what I'm talking about, because I'm using all the facts from all the trials that we have discussed here. Okay, I'm using all the facts from the trial that we have discussed with this. So, you know, Hank Brennan wants to use the issue of push, because he wants to say, well, the arm was pushed in, and therefore it got pushed in to get it got pushed in to get the taillight fractures. The taillight fractures didn't go all the way up this arm. There's no possible way. There's no possible way, okay? There's no way you could actually move that arm to get those taillight fractures, okay? And they're not, the pattern is not from it. The pattern is from either claw marks or a dog bite or something else, okay? All right. It's Micah has this. Well, I can't use Micah. Can you just repost that without the last part? Let me see if I can read it. Once that piece is broken, it's not being accelerated anymore. It's not possible for it to catch up to John O'Keefe's arm. That is true. Okay. Yeah, you have a little bit of an extra there that I can't post on here. Well, I could, but we do have our 16-year-old Skyhopper T16 Media. All right. So I want to be a little respectful of her. Okay, there you go. Once that piece is broken, it's not being accelerated anymore. It's not possible for it to catch up to it. You're absolutely right. And that's why it falls there. But John O'Keefe keeps going. The Rescue Randy keeps going. And then he has road rash from being hit on the asphalt, right? And I still don't understand what I assume in closing, the prosecution is going to have like a video of how this actually happened, how they believe it happened, because and that video has to have, and maybe you can help me on this. Do we have testimony in there that Higgy's Jeep with the big snowplow was parked, okay, there? Do we have that testimony? Did that come in? Did that clear for the jury? All right. I can't even remember. And I think that's important, because how is her car backing up? How's it going 87 feet total in terms of the reversing, even though it only reverses afterwards 23 feet forward, 23 feet forward, and then for a total of 87 feet. How does that happen? Okay. With that O'Keefe's, with Higgy's Jeep being there. How does that happen? All right. Why is John O'Keefe on the other side, of the flagpole, if that's the way it happened? Okay. Come on. It doesn't make any sense. So you have all this. I don't know. Is the jury going to do, again, is the jury just going to do Occam's razor and say, well, she could have hit him? I had somebody here this morning who believed that, well, she could have hit him, but that's not I explained, that's not the burden of proof, coulda, woulda, shoulda. That's not the burden of proof. The burden of proof is, did the prosecution prove beyond a reasonable doubt? I think the murder is ridiculous. Certainly that's an overcharge, right? Certainly that's an absolute overcharge, that murder. And I think the third part is also ridiculous. So the danger to Karen Reed is the second charge, the manslaughter charge. You hit him accidentally, you didn't mean to, and he died. Okay, it's like it's really a recklessness, right? It's Michael. Don't be sorry. I've used that word in my rants sometimes too, as you know, and all. Joey Kane, by the way, gifted one Justice Served TV membership. Joey Kane gifted one Justice Served TV membership. Okay. Yes, thank you, Joey Kane. And I'm told that Jen McCabe, it was so long ago, wasn't it? Did absolutely say that Higgins' Jeep with the snowplow was parked in front. But it's hard to remember, and what I worry about the jury not remembering all this, especially since if it looks like we're going to have closings on Thursday, which seems to be a possibility, although after Hank Brennan went so long today and we have to have a voir dire on Lope-Sada, it may be a lesser possibility than it was when we started the morning today. Could the jury remember in 1 hour that they're giving? Can the defense get into everything in 1 hour? Okay, is that possible? Right? Could that be? I mean, there's so much to go over here that this closing would have to be tight, clear, and also have to show how, and it has to concentrate on the no collision. Now, the other thing that the defense, I'm going to ask you about, Alan Jackson said in his opening that you will have no doubt by the time you go your deliberations that John O'Keefe entered the house. He didn't say that he was going to show you witnesses. I don't think they were going to say that he entered the house, although we don't have Higgy, who said somebody 6'2", dark hair, entered the house. We don't have that, okay? We don't have another witness who said it at the first trial. What we do have is we have the round circle from Mr. Wiffleball, Ian Whiffen, who withheld that from the jury, that showed that John O'Keefe's phone, when he takes those 80 steps, could have been in the house. All right. He tried to conceal that. And so I think what the defense is going to go for in their closing is that, look, all right, the prosecution has concealed from you, doesn't want to have evidence, is hidden from you. They didn't call Proctor. They didn't call Higgins. They didn't call Brian Albert. They didn't call all of these people. They're the ones you would expect to call them on their case. They didn't call them, right? They're hiding them from you, ladies and gentlemen of the jury, right? And we brought you the truth. We weren't afraid of bringing you ARCCA. They were hired initially by an agency, a third-party agency. It's very clear it's not an insurance company. If the jury's smart, they're going to put together that McCabe lied to an outside agency. That was very important. That Kerry Roberts had to come clean to an outside agency, which she never did before, that her testimony before the grand jury was untrue, was simply untrue. They're going to remember Officer Never Say Dever, I guess she's Never Say Dever because it's Dever, saying FBI how many times? 13 times. So if they're smart, they're going to put together, even if This doctor can't say, Wolfe and Rentschler can't say they were initially hired by the FBI. I think that in of itself is a wrong ruling, because I think that gives them credibility on how they got into their case and their first findings, that they were to determine whether or not there was an impact between John O'Keefe and the car. The one thing I would have done if I were Jackson, I would have reminded the jury of that of his beginning of his testimony, where he said that, in case they have forgotten. All right, especially since Alan Jackson opened with no collision, no collision, no collision, and they came to the conclusion that John O'Keefe did not impact with the car, that there was no impact. So I think Alan Jackson missed an opportunity there at the end to do that, because I think Hank did open the door with his pushing. So, you could have said, with the question that Mr. Brennan asked you on pushing, did that affect your initial opinion in any way that you gave to the third party agency that hired you, that John O'Keefe never impacted that car? I think that's the question I would have asked. I think that's the question Alan Jackson could have asked. That was a missed opportunity, but he did ask the one that I suggested he asked. You're here to rebut Welcher, right? You're using the 50% because that's what Judson Welcher used, all right? And again, we don't at autopsy cut the arms off people and weigh them. And matter of fact, I've learned through my many years at being a prosecutor and going to a few autopsies and being a defense attorney, that many times the body weight is an estimate, by the way, or it's taken off their driver's license, that the body is not actually weighed, even when it should be. One of the things you didn't ask Dr. Let's see, it was the medical examiner for the state, whether or not there was an actual weight, or whether the weight was estimated, or the weight was taken off the driver's license. And I've learned that is something that is very common, and that should have been a question asked of that doctor, just because then we would have it. Sometimes they'll say yes because they're supposed to weigh the body, and they just don't, because they do an estimation, and they also will usually have some type of identification, like a license or whatever. And yes, I think that your arm weight would depend. Remember that even that 220 6'2" is an estimation of an arm weight. It's not actual, because everybody's arm is going to weigh different. So you use these approximations. But even if you're using Rescue Randy, whose arm only weighs, or the arm that they used, which was basically the same arm as they were doing from Rescue Randy, only weighs 9 point something pounds. If you think that the weight is important, you do exactly what ARCCA did, is then you increase the speed, and you're going to get more of the mass. Okay, but I've told you that before. If the jury doesn't get that by now, that means they don't want to get that. All right, but somebody says manslaughter can still come with large jail time. That's why you have to win these cases. Because that's right. Look at how many people have been exonerated after spending 25, 30, 35, 40, 45 years in jail. Okay. All right. It's important to win the case. It's important really to win the case and to get a not guilty. Here, if indeed let's assume the jury does not guilty on two of the charges, as they apparently did in the first case, but we couldn't go back and find out, and the jury hangs on one of the charges, I have no doubt that the Commonwealth will try Karen Reed again. There's one case that somebody was tried, and I don't remember the name of it offhand, but you can Google it, 5 times, and it went up on appeal. And I think after 3 times, the courts ruled that still wasn't cruel and unusual, but after 4 times, not cruel and unusual, but you can't try for the 5th time. So I have no doubt that at this point, this is a thing with the Commonwealth. They want to convict her. That's why they hired Hank Brennan, right? That's why they didn't go with Lowley. They didn't think he had the chops to convict Karen Reed. They didn't think he had the chops to do what Hank Brennan's doing. Okay, let me just put this. This is where I'm sorry, I missed it. You go by so fast sometimes. NC Highway Patrol retired. I know you've been on our chat before, and I've mentioned you, but I want to mention to you again because we had the Stephen Plord, who was on the California Highway Patrol reconstruction, as you know, for a number of years, almost 45 years. All right, doing this. All right, I cannot believe anyone who's watched this case can look at all the evidence and think she's guilty. A lot of us feel the same way. But I'm telling you the dangers, because here on this network, we tell you the dangers. The danger is somebody's going to say, well, ARCCA came in and did this test, and now we know that taillight can fracture, and therefore I'm not so worried about that anymore. ARCCA came in and did this test, and we know this taillight, and we say it again, can fracture, all right? And so, yeah, so now it can fracture. We know she was drunk. You know, oh, but there's that fan. Because they have through when Whiffen testified, they had through his testimony. Remember, he's a cell phone guy from Sidebahhh, who did a software to take off the search from Jen McCabe that occurred at the 2 o'clock in the morning hour, right? Of House Long to Die in the Cold, right? But he testified that Axiom still had it on their program, that Axiom had that search. So to me, it looked like Sidebahhh to me, it looked like what happened is that Sidebahhh became an advocate for the prosecutors by rewriting their software to take off that search, right? They rewrote their software to take off that search. But through both of the experts they had, even the woman whose name I can't remember who came on, they still both agreed that Axiom, using the Axiom software, it showed the search. So I think the defense decided they didn't need Richard Green to come on and talk about the search, right? And then that's the 22740, yes. I think I just said in the 2 o'clock hour because I'm trying to go through everything really quickly. I don't think they decided they don't need it because they're going to say, hey, the other software company they didn't bring in, who didn't need to rewrite their software to help to become an advocate, shows that search exists, and they agree that that's a great software company. As a matter of fact, one of them was directors of that software company. That was the woman. She was director of Axiom. All right, so they didn't need that. Now let's talk about the trigger event. All right, the defense, I think, disputed the trigger event. It seemed to me a lot more in the first trial. That trigger event, the 3-point turn, really was when the car, and we saw it was put on the tow truck. I think they're going to say that. They're going to say that just that the defense trigger event. Oops, I'm buffering again. I think I'm off again. I can't tell whether I'm on. There, I'm back on again. Okay. The trigger event's another issue that I think they have enough in the record to dispute with regard to that trigger event actually occurring when the car is put on the tow truck. You saw the 3-point turn and all, right? I'm fine now. Yeah, I kind of see when I go off and all. At some point, I will have to take a 5-minute break, by the way, but we'll wait until we see what happens when they get back on after, I guess, putting Dr. Lope-Sada on is what I assume is going to happen. So the defense, I think, has enough in the record to do that. But what they're saying, it doesn't really matter. You see, you don't want to dispute a lot of these things if you say there's no collision. If you're going with what I thought they should have gone with the first trial, no collision, no collision, no collision, and these clearly aren't, these wounds here aren't caused by a car, then you go with that, and then you go with the burden of proof beyond a reasonable doubt. And you go with the Baden defense that, look, we don't really know what happened. We don't know what happened in the house. It would certainly be better if we had that garage picture, right? That Judge Bev just denied. I'm calling her Judge Bev now. I was calling Judge Kenney, but I'm going to go along with you, Judge Bev. We're past that stage because that is so unfair, right? That you've denied the defense the ability to have an expert to say this prosecution and this investigation was so bad when your whole defense is the Baden defense. And you can say within the Baden defense that you don't need that third-party culprit now. You don't need that, well, there's a whole conspiracy, because the jury didn't like that the first time out. They didn't really buy that. That we don't know what happened in that house, okay? We don't know what happened in that house, right? But something happened. And if we had a better police investigation, maybe we'd know what happened in that house. And somehow John O'Keefe's body got to that front lawn, not that tree where he shouldn't have been. And it wasn't there. It wasn't there when the snowplow driver came out. It wasn't there when people left the house. A lot of people didn't see him, but all of a sudden it gets there. Okay, all of a sudden it gets there, right? And something happened in that house. Now, apparently, Dr. Lope-Sada was going to say there was something in that garage that he could have fallen on. This is what I'm thinking, in my opinion, that caused that that there's like a little J impact there. That caused an impact and it caused an impression and a pattern that was actually a hit of some sort, or falling back on something that had an edge to it. All right, and all. And quite frankly, I'd see a very easy way to explain that. He and Higgy got into it, right? They're taking it out. The dog, Chloe, is in the garage. Chloe then attacks. John O'Keefe, in my opinion, could easily, you have in the record that he had an 85% occluded widowmaker, coronary artery, and he could have had a heart attack with all that. And then people say it doesn't have to be everybody. Oh my God, now what do we do? You know, we are cops. We know that if there's a body here, we're going to get charged with something. We're going to get charged with something because he just died here. All right. And then all you need is one or two people involved and the body ends up on the lawn. That's all you need. And the prosecution, I think the defense was going to go there and they were going to possibly argue. You could have had all these possibilities, but we don't know which possibility is because there wasn't a good investigation. We don't know what really happened because there wasn't a good investigation, ladies and gentlemen of the jury. Yes, the J hook is what I'm talking about, that little J imprint. And I think there may have been something in those garage pictures that showed a little J that they wanted to talk about. All right. And I think that's the issue. I think it has to do with more in the garage, Paul B, than all, because AJ made a point of mentioning the garage so many times during questioning. You knew he was mentioning for a reason. And the reason had to be Dr. Lope-Sada with some kind of imprint that was in the garage, that was a raised surface in the garage that she sees in that garage. Okay. And so you can't have the police expert testify. You can't have the garage imprint photo, which comes from the police. It comes from them. It comes from the prosecution. I've had this argument with cases and the judges have let it in. Judge, it's valid. It's self-validating when it comes from the prosecution. If they give it to me in discovery as coming from Investigator X, I can call, you want me to call Investigator X and say this is a true and copy photo that you took? I can do that. But usually prosecutions say, no, you don't need to do that. We gave it to you in discovery and you can use it. All right? This I have never seen.
So I'm told counsel wanted to see me.
Okay.
Has arisen,
Let's listen.
Cross-examination or recross-examination of the last witness, and Mr. Alessi would like to address the court in detail about that.
All right, so the last witness was your witness? Is there a reason?
This is a separate issue. I'm asking Mr. Alessi to address the court on this.
We should be going back into
What do you
court.
want to tell me, Mr. Leslie?
We should be going back into court. I don't know if you can hear this.
A moment, Your Honor. I need to put on evidence gloves.
Can we go back into court? Thank you, Rain McBrand. New member, YouTube member. Thank you so very, very much. Really appreciate it. We're trying to buffer it for it.
Your Honor,
all right.
The defense moves for a mistrial with prejudice
Are
based
you all
upon
hearing this?
intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, Hoodie, in this regards, questioning and representations and questioning by Mr. Brennan, and need to do, Your Honor, is to have two documents marked as exhibits, and then I am going to use Exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
Things. What are these things
like to have
you want to have marked? How about what are these documents you want to have marked?
What I would like to have marked, the first document, and I want to get the specific title. These two documents are from the criminalist file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. Friday.
And may I see that, please? Okay.
That is the back of the hoodie, Your Honor. And if I could, please have the next marked in order exhibit for identification.
Exhibit ZZZ for the identification.
Just give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes on the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay. I can't tell entirely from ZZZ, but if that's your argument, why, for identification appears to support that.
Your Honor, may I have the exhibits marked for identification back for my argument?
Okay.
She's being so
Thank you,
dismissive.
Your
Well,
Honor.
if that's
Thank you,
your
Madam
argument.
Clerk.
Hank just misrepresented to the previous witness that the holes in the back of the sweatshirt were not caused by any accident. Okay. Let's listen to Bob Alessi.
Your Honor, what we just saw is Attorney Brennan question Dr. Wolfe with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is the, what happened was Attorney Brennan held up the casing with a hoodie sweatshirt, went to the back of the hoodie
Wearing
sweatshirt.
gloves.
First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor. The
Okay.
first time I realized that line
Okay.
of question was going to be asked was when Mr. Brennan pulled the casing.
Yeah, and he
Okay.
doesn't have to be aware of it if somebody, just because something's up at the
Go
witness
ahead,
stand.
Mr. Leslie.
Thank you, Your Honor. So, to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing, without notice, shows it to Dr. Wolfe, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now?
All right, by the way, in Massachusetts,
It would help me if
it's
you held it
very
up for me
common
now.
to put the evidence
Absolutely,
Mr.
in
Leslie.
a plastic or some
here
kind of
is
acrylic. They did that in Hernandez
The
too.
back
Okay,
of the hoodie.
okay. All right, thank you.
It's very obvious that these are cutting holes cut by the criminalist. And I'm going to get to back to this in a moment. But I would like to do it, and certainly entertain any of Your Honor's questions, but in a logical order.
Sure, so I'm not, what about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay.
We're worried about the jurors at lunch yet, instead of the important oral argument for mistrial here. All right?
All right, thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up, we have no idea that this was going to happen, goes up, confronts the witness, Dr. Wolfe, shows the back of the hoodie sweatshirt, to my knowledge, the first time the back has been referenced of the hoodie sweatshirt, shows Dr. Wolfe, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour. and damage to the hoodie, etc. So what then happens is Dr. Wolfe is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that? Does
Yes,
that do
Your
the
Honor.
back?
What
Okay.
we have is two documents to show that.
Right, so the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in
Yes.
a discovery? Let me get the date, Your Honor.
Sure.
If they're in discovery and they have them and they're bait stamp, it doesn't matter
Notice
what
of
date.
discovery, May 2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence. Not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolfe. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-2184. Analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor. And I can conduct my argument from right here if that helps, Your Honor.
I just want to see, point out to me where it says, where it shows the back.
This is the back. So you can see the back of the hoodie.
Yes, he does. I love the way he argues, because this would be me. Look at him, right up there with the judge and showing her, okay? She's trying to find a way to already to deny this mistrial by saying Alan Jackson didn't object, okay? That's what she's going to do, okay? And that would be absolutely wrong.
Thank you.
And I'm
So Mr. Wesley, stay here.
Because it's the prosecution who's not supposed to manipulate, be a snake, be a skunk, all right? Or the stank, or what did he call it? Oh my gosh. We're losing our stream sometimes. Please stay with us. If we do, we'll be right back to it.
Can I get the
They're labeled cuttings.
Pardon me?
They're labeled cuttings.
Right, but if I can, Your Honor, I want to clarify this. Yes, are you willing to, let me just make sure I get.
Mr. Jackson, it says exterior front, what Mr. Alessi was pointing me to.
Well, yes, it may have printed the wrong page. I can do it, but Mr. Wolfe, can you print the back? And then, Your Honor, are you comfortable using the computer at the back? Because I think we just had the wrong one.
We need to mark it, though.
Understood. We will. He's printing it right now.
We don't want to lose this, even if it's a little pixelated. We'll try to find a better stream after, but I don't want to take the time to lose this right now. So please stay with us.
We printed. We wanted to have the front and the back show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
Okay.
It's the streaming software, is that what it is, this? Okay. I think if it goes out, I'm not sure I go out with it. That's the only thing. So you guys let me know. Because this is a big deal. You may not think so, and she may not think so, and she's going to probably deny because she denies everything. But this is a big deal because this is the second intentional allegation of misconduct that's been alleged. That if he's asking questions of Dr. Wolfe, saying that, what about the holes in the back, all right? I can hear Judge Beverly Canoni saying, well, you know, he could have said no, you know, he said they weren't caused by the car accident. I think he actually said it's a possibility because he didn't know what kind of holes he was talking about, just holes here. But they were cuttings from the criminalist.
All right, so go ahead with your argument.
Yeah, go ahead.
So, Your Honor, what is being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminals.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And
Oh,
here
so no
is
mistrial, but
the
she may let him
reason
tell him
for the
Hank was a
motion
liar.
for a mistrial with prejudice.
He knows it's a big deal.
On its own, to do this, and you put together all of the parts of what just occurred. You start with the fact that
Oh.
If I could, Your Honor, now that I have it yet marked so I can then refer to it.
All right.
Thank you.
Can we print?
I'm sorry about this happening, but this is a big deal, okay? But she clearly going to allow the criminalist to come in or allow the defense to give the whole story. She should also give a jury charge that you should hold this against the prosecution, that they were wrong, they were misled by the prosecution, that the jury was misled. She won't give that charge, I guess, if she lets Alessi and them deal with it. But this is simply, and she knows this is trouble. All right, that's why she said, I'm inclined to allow you to do that, to tell the whole truth about that these are cuttings. All right? She knows that this is a big deal, this misrepresentation, okay? With prejudice means, by the way, if it gets dismissed, the prosecution cannot bring the case again. That's it. Done, 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 okay? Yeah. You're right. If the defense did this, NC Highway Patrol retired, she'd have a conniption. She'd move to disbar them. She'd move to pull the Prague Vici. She'd move to all sorts of stuff. This is a big deal. Hank Brennan went obviously too far, right? Because he knew that Dr. Wolfe's testimony was trouble. Instead, he should have just concentrated on the tail light broke, the tail light broke, the tail light broke. But he didn't because he can't. He just can't not show himself.
Madam Court Reporter, the chain of custody document for these, and ask that he mark as the next exhibit in order.
Okay.
And then with Your Honor's permission, I would have Madam Court Reporter hand them both up to Your Honor so
Sure.
Your Honor can see what I'm referencing.
Thank you.
Yeah, where's the grave concern about this? I have grave concerns, right?
Exhibit BBB for ID.
And all of a sudden, Hank Brendan's worried about chain of custody, right? Oh, I want to mark the chain of custody for these issues. Now he's worried about chain of custody. I'm sorry, I'm probably talking over them. I'm talking over when I think it's something that you don't really.
Do you
I
need
can
this, Mr.
explain
Lassie?
as to the
I
importance.
do not need either of them, Your Honor, and I have the extra copies as well. Okay, so Your Honor, I now have enough copies for Your Honor and for the Commonwealth.
Oh, thank you.
So if I could have one set, that would be great. Yeah, thank you.
I still do not have ZZZ. All right. Thank you. Okay, go ahead, Mr. Lassie.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have Exhibit 88, which is the hoodie. So, what Mr. Brennan did, and I'm now pulling Exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolfe, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminal list, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right,
and
so let's move along from
Right,
that.
that's right, and I'm going
Let's
to
make
come
your
back
argument.
to this.
Make your argument with it being a joint. being
Why
joined
is this
together.
occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolfe, the ARCCA expert, to try to make it seem like Dr. Wolfe didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolfe on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the
Make
case.
the joint thing with the DNA because
We
it's a joint
have
mistrial for both.
irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Ms. Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
Tell them, Alessi.
All right, thank you.
Oh,
Mr.
thank you.
Brennan.
All right. He He knew what he was doing, and it's important because it's on with the DNA.
Your
That's
Honor,
an
my
important
brief
argument.
review of the review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
Oh, he made a mistake, another one.
And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court
Told
should
you it's a
instruct the
big
jury
deal.
that during Mr. Brennan's cross-examination, he asked Dr. Wolfe about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury they are to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
He knew. Is that what the upshot? He knew. Is that the
So-
upshot and he got caught? Or is it
I'm
just
not
another
going
mistake?
to allow the mistrial motion.
Oh,
Mr. Alessi.
surprise.
What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z,
The
A,
defense
and
should
B.
offer an instruction. They should prepare
Four of
the
each letters. I'm
instruction.
going to put all these into evidence. They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolfe, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this.
Defense should
I
write the
instruct you,
instruction.
you are
Tell them
not
you want to write the
permitted to
instruction.
draw any inference that these could have come from the events of January 29th, 2022. I instruct
not
you
right.
further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can
Not
I
to
see those,
instruct
please?
any inference. That shouldn't be there. You should say, those holes
It's
were not
unclear for
made.
me. Do you have a better idea, Mr. Alessi, what day these were done? Is it all of those
Alessi,
3 days?
tell
Now
her
I see
you
a
want
fourth
to
day.
make you want to give the instruction. Tell her you want to
5/11,
submit a
no, I'm
draft
sorry,
instruction.
5/11,
Alessi,
5/12.
tell her.
5/11/2022, 5/12/2023, and 6/18/2023. Those are the 3 dates.
Your Honor, Honorable May 18th, when the defense filed a motion to test. So those are, that's the probative date.
So May 18th?
Yes, that's
Okay.
and that's 20.
I don't have the availability to tweet right now because I'm on the
All right.
air. But the defense needs to submit a draft
That's what
instruction.
I'm going to do. Is there anything further you want me to
Yes,
include in the
I
instruction?
want-
You're right
yes,
to say
yes, go
regarding
ahead.
the mistrial.
Go
I
ahead.
disagree with you on that.
Your Honor, I'm not going to go any more into the argument, but I appreciate the opportunity to provide perhaps some further instructions for Your Honor.
So I'll hear you. Go ahead.
So the first, Your Honor, is with regard to two things. One, I would like the opportunity to have the hoodie sweatshirt held up, because that's what
Okay.
happened.
Yes. Yes.
These holes in the
Yes.
back.
Yes.
Thank you. So that's number one as part of the stipulation, and then.
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree, not a stipulation, but just as Your Honor said, with regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that rock wasn't present, on or about the time of event.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolfe about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes
No, they're
were a
not. Those
result
holes did not come from, not the drawing the inference, the holes did not come
of
from.
the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in.
Wait, if you're not going to listen to what I've
It's what
already
I
said.
said, Mr. Alessi.
Your Honor, we'd like to submit the instructions.
Okay. All right, so it's what I said, Mr. Alessi. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, you should conclude that these holes were not present in the hoodie sweatshirt?
Thank you.
They were caused by the criminalist.
So I can just leave that all out then and just say, Mr. Brennan asked Dr. Wolfe about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring them in, please.
Wait, this is a big deal in a mistrial, and she won't give them time to submit a
Judge,
draft
just as a
instruction.
housekeeping matter, the sweatshirt's been taken out of the plastic sheet, and it might need to be remarked. The plastic sheeting was marked, but if we're going to put it into a bag or something like that, we might need to have it marked. But we don't need to do that right this second.
May I approach Mr. McDermott with exhibit
Yes.
88?
Thank you.
They have a right to object that her instruction is not far enough. And she's saying, this is what I'm going to say, bring the jury in. She's absolutely showing bias here because she knows she has to do something because this is a big deal.
All right, thank you. Oh, sorry.
And I just tweeted about the Vents needs to submit a draft instruction. Anyhow, no matter what she has said, that whole inference
Mr.
thing was
Alessi, you're
wrong.
simply going to stand and hold the sweatshirt, right?
Oh my God, now she's telling them how they have to do it. These holes were caused by the criminals. He made it seem like Dr. Wolfe was incompetent, demeaned. He made it seem like the holes could be caused by an accident. Hank Brennan then gets up and says, it appears I made a mistake.
Honor begins to read. Is that consistent with Your Honor's expectation?
No, I want you to hold it up with the back.
Would you like me to start?
You do that first, and then I'll give the instruction.
Thank you, Your Honor.
She's even,
All right, so
she's
Mr.
even
Alessi, why don't you
telegraphing
just-
she's
where are you
angry
going to
that
stand?
she has to do this, in my
Where are you
opinion.
going to stand?
I would suggest, Your Honor, right about here.
All right? So you can stand there, you can hold it up, then I'm going to ask you to put it down, and then I'll give the instruction.
And then I will return it to Mr. McDermott or the court officer.
Yes,
Thank you.
court officer.
Bear with me a moment, Your Honor. I'm going to be put on the record.
All right, then we will take the luncheon recess. When we come back, we'll have the voir dire. Or actually, is Dr. Lope-Sada here?
She's here, but she's not next. We're gonna call,
This is a big deal. And then she wouldn't allow them to make the argument
just the
that this is a
measurements?
conjunction with the DNA that he introduced that had never been introduced by anybody. She said, I already ruled on that. But it's a new motion. It can be a new mistrial motion for both. It's called the cumulative, it's cumulative. Now we're asking for a mistrial based on the cumulative misconduct. Make the motion, Alessi.
Well, I say it, and I'm going to tell her what they are, so.
He should be able to make that motion about it being cumulative with the DNA as a cumulative misconduct. She cut him off at the pass on that. I think there may be enough in there that he was trying to do it, but it's wrong, all right? Is lunch here? How long is this going to take? This is going to take as long as it should take. This is my client's rights here. This is the Constitution. This is Brennan now. Remember, he had a mistake about telling her about how he didn't get the discovery from the defense. That was a mistake. Then there was another mistake with Yannetti, about Yannetti doing something on the air. And oops, now I'm off the air. I don't think you can hear me right now. I think I am now off.
Session.
All right.
Am I off the air?
Jurors, I appreciate your patience. Mr. Lessie, why don't you
Yeah,
hold
I'm
the
back
exhibit
on.
up for the jurors, please?
And now we have a third mistake from Alessi. Let's listen. Not Alessi, Brennan, sorry.
All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolfe.
He's walking around. He's not just holding it there. He's showing everybody.
Okay.
Good for you, Mr.
Thank
Alessi.
you. Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So.
Wait.
I
And
know your lunches are here,
and Hank
but I
Brennan,
think we'll, Mr.
and Hank Brennan
Yannetti,
just
your next
asked
witness,
questions
please.
about Dr. Wolfe. Wait. Sidebar. Go to ask for a sidebar. Thank you. Ask for a sidebar. During the course of Dr. from Hank. Now I'm muted. The host has unmuted. It doesn't go far enough. She's got to say, during the course of Dr. Wolfe's cross-examination, you heard questions from the prosecutor suggesting that the holes were made by the accident, and it did not. Alessi, go further. I'm sorry.
Good
I think
afternoon.
that was wrong. I think that needed to be a
Go
longer
ahead, Mr.
instruction.
Yannetti, whenever you're ready.
Thank you. Good afternoon, sir. In a good loud voice, would you please state your name and spell your last name?
Sure. My name is John Tedeman. It's Tedeman.
Do you work, sir?
I do.
What do you do for work?
I am a private investigator.
Do you work for someone else, or do you have your own firm?
I have my own firm.
What is the name?
Forum Investigations.
And that's F-O-R-U-M?
Correct.
I'd like to ask you a little bit about your education and work history. You're from this area?
Yes, Boston
Where-
proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School.
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University.
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location, sorry.
I started out in Los Angeles, and then I was back in Boston.
And what years were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did you leave in 2008?
I went to law school.
Where?
Suffolk.
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker.
And what type of law did you practice?
Mostly real estate law.
When did you start Forum Investigations?
In April of 2024.
Are you still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
All right. How did you become involved in this case?
I was contacted by somebody from your office last Tuesday, I believe, the 3rd.
Okay. And was it explained to you why you were brought in at this late juncture?
Yes, it was explained that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
And what were you asked to do?
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did you agree to do that?
Yes.
When did you go?
On June 3rd. I believe I arrived about 5:30 at 34 Fairview.
Okay, and when you say June 3rd, we are talking about last week,
Yes,
correct?
last week, yes.
Whom did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
All right, and it was not the Albert family, correct?
It was not.
Did that individual give you permission to enter onto the property?
He did.
What did you bring with you?
I brought an iPhone as a camera, and I brought a wheeled measuring device.
All right, can you describe what a wheeled measuring device is?
Yeah, it's like a handle with two wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
And if we could, Mr. Wolfe, could we display the photo of the front of 34 Fairview that's already in evidence with the court's permission?
Yes.
And what exhibit number is that, Mr. Wolfe? 46? Do you see exhibit 46 on the screen, sir?
I do.
Do you recognize that?
I do.
What do you recognize that to be?
That is 34 Fairview Road in Canton.
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence on the front, from the front of the house?
I did.
Could you describe those for the jury?
Yes, on the left side center of the building, there's what I would call the front door, up those 4 steps, I guess. Then if you were to look farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows. And then if you can see the little red line, that is a side door that goes into the garage. Yes, right there.
It's been highlighted there?
Yes.
Okay. And then there are obviously the 2 garage doors.
Then the 2 garage car doors, yes.
4 cars to enter. Okay.
Yes.
We can take that down, Mr. Wolfe, and put the lights on. May I approach the witness, Your Honor?
Yes.
So I've placed a photograph in front of you. Can you identify that for the jury?
Yes, that appears to be a photograph that I took of the side front door, the secondary front door, the garage door, and the 2 car doors to the garage.
Okay. Particularly with regard to the side pedestrian entrance into the garage, the red door that you identified in the previous exhibit. Does that photograph fairly and accurately represent the layout of the house in terms of the outside and the entrances that you've previously testified to?
Yes, it does.
I would offer that, Your Honor.
All right, can I see those, please, sir?
Okay, now let me see. She wants to see what his, she interjected, well, could I see those, please, sir? She wants to see his photographs, which obviously have been turned over to the prosecution. It looks like he's a substitute witness for all of this that was done once before by a previous investigator who now has a health issue, which probably everyone agrees to, because these, he's testifying. So he's testifying as a substitute on something, just as if somebody in the lab got sick and testified. So we'll see. But you said the garage is important. I'm telling you, the garage is important. I've been telling you that from day one when I kept hearing Alan Jackson talking about garage and interspersing garage, because he uses words purposely, okay, here. So obviously, I think there was something on the floor or in the garage that was there. The homeowner allowed them to come in there. That probably is part of the house. That had that impression that Dr. Lope-Sada needs to say that was a pattern impression, okay, and whether or not there's measurements or not. And maybe Chloe was in the garage, but there's what this is going to the alternative theory. Now, this was a big deal this morning that the judge just passed through the jury, by the way, in terms of that mistrial motion where Hank Brennan had a mistake for the 3rd time. Can you imagine if the defense had done this, okay, and misrepresented a piece of evidence the way he did? And then when she gives the charge, usually what this happens is when the judge says, I'm going to give a curative charge, the judge writes it up, he gives it to both parties, they get their input, or you give your curative instruction, you write it up, and then everyone goes through it right there and then. You don't have to worry about lunch. This is a big deal, motion for mistrial, that there's been a big problem. The prosecutor's misrepresented something bigly, okay? And then so what she does is take out that you're not to draw any inference from it, which is ridiculous. Of course you're supposed to draw an inference. You're supposed to draw an inference that the prosecution was trying to mislead the jury. But putting that aside, since the judge probably wouldn't say that, you at least say, this is also important, ladies and gentlemen, because Mr. Brennan, the prosecutor of the Commonwealth, asked questions of Dr. Wolfe that were about this whole, whether it could be caused by the car accident at the time, knowing, and the prosecution had in its possession documentation that showed that it could not have been. And she had to allude to Dr. Wolfe, because now the defense has to do it when? In closing, all right? So it truly is, I see the word coming past me, pathetic. It truly is pathetic that we don't take the time. She knew she had to give a charge. She knew she had to do something, because if not, this was a mistrial. And again, I'm objecting to the fact, you, Judge Cannoni, you are supposed to be the person that when you lecture at the Harvard Trial Advocacy Workshop next year, the person that people look up to, the judge that people look up to, that the young students who are law students had to learn their ethics from, and people look up to. You interrupted Bob Alessi when he's trying to say, I also want to say this is on the heels of last week's motion for a mistrial with regard to the prosecution bringing in DNA that had not been brought into this trial, and there had been no predicate for it, which of course she had rejected. She wouldn't allow him to make the joint motion for the mistrial on the basis of joint misconduct. So he still has this misconduct. Hank Brennan clearly knew when he got up there and he said, I was mistaken. Well, you were mistaken, Mr. Brennan, when you said the defense did not give you discovery leading to this whole issue of her concern, her grave concern, and then you said, oh, I was mistaken. You were mistaken when you said Yannetti had given an interview in violation of the gag order, which was absolutely incorrect. You were mistaken on both of those occasions. You had to know the truth on both those occasions, in my opinion. You're smart. I've given you credit for being a very smart attorney. I've given you credit for being a good attorney. But a good attorney does not mislead the court 3 times when especially when you're a prosecutor. That's 3 fingers, not 1. I know you're used to me being a little spicy sometimes, okay? When you are a prosecutor, you have a duty to tell the truth to the jury. You should even have a duty. You should be the one to stand up and say, I was mistaken, I'm sorry, okay? You should be, Dr. Wolfe should be brought in, he should be apologized to you, okay? You should apologize to him. But that jury instruction did not go far enough by just saying the holes were caused by criminals. It should have said, the Commonwealth suggested to you that the holes were caused by the accident. Ladies and gentlemen, I'm instructing you now to disregard that. That was not true. Anything that you took, any inference you took about Dr. Wolfe's testimony or his credibility should be disregarded if you do it based on his questioning or his answers about those holes, because they were caused by the Commonwealth. Mr. Brennan was in possession of the 2 documents, 2 exhibits that we have marked that showed that, and then gone from there. That should have been a real strong instruction, not just this little.
Okay,
the
Mr. Wolfe,
jury
whenever
just
you're
passed
ready,
by.
if you can display that portion.
Yes, that was a rant. Thank you for liking my rant. Yes, my rants are actually just the way I feel about a trial, being an attorney.
Do you see what has been?
So I'm going to ask you to take that down. Folks, we're going to take the luncheon break at this point, okay?
What? She just looked at the pictures. Oh, and now she's going to have grave concerns about a photograph being put in front of the jury by the defense with regard to a photograph that this private investigator took. Now you watch. She's going to have grave concerns when we come back. Oh, we were just at Sidebahhh. She's going to have more concerns about that than the mistrial that she should have given the last 2 times. The fact that she had to give an instruction, the fact that Hank Brennan absolutely lied to the jury when he suggested those holes. He was mistaken, he says. So let's give him the benefit of this doubt. Let's honor him and give him the benefit of this doubt, okay? But it clearly was a lie, his mistake, okay? His mistake was a lie to the jury. And
All
now
right.
we're going to have
So we'll
concerns like what?
fix that during the luncheon break, Ms. Gianetti, to what I said. All right. So can we get Dr. Lope-Sada in here? We'll do a very brief voir dire of her.
Side. Dr. Lope-Sada has to come in after 40 years of experience and talk about her, that she has a history autopsying people with dog bites and motor vehicle accidents. And then she's going to be concerned that it's not on her resume, as she calls it, or her CV as a forensic pathologist. Like you're going to put that on your CV as anyone. Like I'm going to put on my CV, oh, I try a case again with a dog bite, or I tried a case with this. You don't put that on your CV. Your CV, your resume is not for that. Your CV, you can put big cases on. You can put cases on that you've done. You can put high-profile cases on, but it's not for, Linda Kenney Baden. I tried a case involving a car accident. I tried 2 cases involving cars. I tried a case involving this. I tried a case involving that. I mean, that's not what you do on a CV, especially if you are a professional, okay? Maybe if she's been a judge so long, she's forgotten what a CV looks like.
Going to step up, face the clerk, and raise your
All right, this is Dr. Lope-Sada, who now has to go through a voir dire about this, about her CV.
The truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. Good afternoon, Doctor.
Good afternoon, Your Honor.
We're going to do a brief voir dire, okay?
No problem.
Thank you. All right, Mr. Jackson, foundation on just those 2 points, please. Sure.
I may be the one that doesn't get asked to go back to Harvard after my rant, by the way, just so you know. I'm not a judge.
Expediting, does the court wish for me to go through the foundation of the doctor's education, training, and background and experience, which is going to take a minute?
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence, those 2 areas. And if there is support or methodology in Dr. Lope-Sada's resume to point.
So now she's got to have a methodology on whether or not
Okay.
she can
And
testify
I expect
as
this whole
to
voir dire should take no more than 15 minutes.
motor vehicle
I'll do my
accidents
best,
as
Your
a
Honor.
forensic pathologist.
Doctor,
Or
could you
whether
please
that's
state your name for the
biomechanical
record, spell your
engineering.
last
This is
name into the
ridiculous.
record, please.
Yes, Dr. Elizabeth Lope-Sada. That's spelled L-A-P-O-S-A-T-A.
Dr. Lope-Sada, what do you do for a living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. Lope-Sada, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions. Where did you get your medical degree?
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had those board certifications?
Like 35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that for the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Many.
Have any of those dealt with motor vehicle and pedestrian incidents?
Many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint.
Hundreds, over 500 at least.
Do you have a significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main job or duty performed by a medical examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation.
Okay.
Do it as briefly as you can, with being as succinct as you can.
Certainly, to determine cause of manner and death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of things that might have happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong? What else could this be? So you have to make what in medicine is called a differential diagnosis and then see what the facts support.
Did you employ a differential diagnosis in this case?
Yes, I did.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, that we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as a expert forensic and anatomical pathologist in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
I want to talk for a specific for a second about a specific area of interest for the court. Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arm? I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
Without telling me what your opinion was, were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist could say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes.
Are you familiar with some or most of those publications?
Absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school,
at the
medical school?
medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
When was the last time you taught a course in pattern recognition?
Let's see, last month.
do any of the courses that you've either taken, well, let's take them one at a time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds?
Courses that I've taken?
That you have taken?
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks. They appear continually in our medical and scientific journals.
Is that an important skill set to develop, wound pattern recognition as it pertains to animals as a forensic pathologist?
Absolutely.
Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically?
Oh, yes, they do.
In the course or courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds?
Yes, I have.
When was the last time you did that?
Let's see, it would be in the course in the medical school. Would have been several years ago.
Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds?
Yes.
So you've seen them in person?
Yes, I have.
Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites?
Yes.
When was that?
The last one I can recall was a federal case involving questions of a police dog.
Did you engage, in that case, did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw?
Yes.
Did the court qualify you to speak on that issue in court?
Yes.
Did you in fact testify in furtherance of your opinions and conclusions in that case?
I did.
I want to turn for a second to motor vehicle accidents or motor vehicle incidents. Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents?
Yes.
How many times would you say you've performed an autopsy on those issues?
Hundreds, maybe even 1,000.
Is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology?
Yes, it is, unfortunately.
Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents?
Yes.
And what methodology do you employ in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents?
Mm-hmm. Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at hospital records, the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at photographs of that or see it in person.
Is that part of the normal methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
Do you also look at the other side of that handshake? In other words, look at the body of the individual that was, in your case, killed, the decedent, in order to marry the two and determine whether the manner of death had something to do with the motor vehicle, a motor vehicle impact?
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced certain injuries on the body.
I'm going to take them one at a time. With regard to animal wounds or dog bites, were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite or claw marks?
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes.
Is it to a reasonable degree of scientific certainty?
Yes, it is.
Is it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regard to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm?
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
And without telling me what that scientific conclusion is at this point, did you employ the same methodology that you've explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you've described for the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Your Honor, is there any area that I have not covered to the court's satisfaction consumption?
So I'll let Mr. Brennan ask questions. I may have a couple of questions.
Thank you.
I can't believe she has a couple of questions after that. This is ridiculous. I'm sorry.
Good afternoon, Dr. Lope-Sada.
Good afternoon.
If we could start with dog bites.
Yes.
Did you have any specific training in wound pattern recognition regarding dog bites?
Yes, it's in our literature standard textbook. It's standard information that is needed to be a forensic pathologist.
When did you receive training regarding pattern recognition of dog bites?
Beginning when I took my board, started in 1983.
And what did that entail?
It entailed reading literature. It entailed reading the standard forensic pathology and medicine textbooks. And it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites early
Yes,
on?
yes,
And
I've had many cases where there have been dog bite injuries.
When you were studying for your boards, were you doing that, or after you
Well,
completed your boards?
I'm telling you that that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many cases since then.
Did you receive any education past reading literature for the boards, where you took classes, seminars, where it taught specifically wound pattern recognition regarding dog bites?
It's all part of wound pattern recognition. It's usually included in literature. If there are lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like baseball bat injuries. There's a huge number of types of patterned injuries that are part and parcel of what a medical examiner has to understand and diagnose.
Do you remember taking any specific classes or any specific training about wound pattern recognition relative to specifically dog bites?
Yes, it's in all the literature that I keep up with.
Did you take any training or did you attend any classes that involved wound pattern recognition of dog bites?
Yes, it's often included in our seminars and case reports.
Do you list any of those classes or seminars on your resume?
That I took? No.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was, regarding wound pattern recognition relative to dog bites?
I can't give you a specific time and date.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition relative to dog bites?
I can't recall.
Is there anything in your report that identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
I will ask you about the CV, but Dr. Lope-Sada, I just wanted to ask you about your report first. Is there anything in your report that points to any specific training
In the report that I wrote on
in your
this
report
case?
relative to wound pattern recognition as to dog bites? Is there anything in your report that identifies that for us?
In my report, I put together the case of what happened to Mr. O'Keefe.
Okay. As far as your experience, though, do you ever make any note in your report about your specific experience and training about wound pattern recognition for dog bites in your report?
No, it's not appropriate.
In your CV, is there any way you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically, no.
Do you have anything on your CV that specifically talks about wound pattern recognition for animals?
Those are usually classified within other pattern recognition.
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other than I've passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound pattern recognition of dog bites?
I don't know if I have given a list. I don't keep those kinds of lists.
You mentioned one case about law enforcement dogs in federal court. When was that case?
Several years ago.
How long would you say, if you had a guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about an individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this person.
And this was in Boston federal court?
Springfield, yeah, Boston, right.
Is there a difference between law enforcement dog bites and domestic dog bites?
They have the same kind of dog jaw.
So you would say
They're
that-
taught differently, obviously.
Would the wound pattern recognition be the same or different if you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Do you have any other cases that you've testified about wound pattern recognition relative to dog bites?
I've testified in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
I'll ask you about accident reconstruction experience. And I mean this respectfully, you don't have a biomechanical or a medical engineering type background, do you?
No, I'm not a mechanical engineer.
You're not certified by ACTAR or any of those type of organizations, are you, doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene firsthand?
Yes.
And when you've done that, do you have a chance to look at all of the physical materials, the properties?
Well, when I go to a scene of a motor vehicle fatality, I look at the pieces that are scattered around, I look at the body, I look at blood stain patterns, I look at damage to the car, and then the body would go back for the examination at the medical examiner's office, and there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries to the vehicle.
You've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand. In this case, what materials did you look at? Because I don't think in your report it mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Well, so you would like for me to tell you everything I studied in this case?
Yes.
I have my list here. Should I read
That's fine
from
by
that?
me.
Okay. I studied the autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuropathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing, blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear. I studied photographs of the outside of Ms. Reed's SUV as it was parked at the police garage. I studied the Canton Police incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened to Mr. O'Keefe.
Were you involved in a case, Commonwealth versus Daniel Tompkins?
Remind me about that. I've been involved in hundreds of cases.
Yes, you have. This case was in Franklin County Superior Court. It was a case where
This
you
is
had
not
an
voir dire for them to
opportunity
see whether she's qualified to
present,
testify about a motor vehicle
testimony
accident or not. By the way, this is
and
cross-examination here, just so you
regarding
know.
blood spatter, which you have been
Oh, yes,
qualified
so-
expert for. And that, I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
No, I'm not an accident reconstructionist.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
I have no idea. I'm not an accident reconstructionist.
Okay. Do you have anything on your CV specifically that offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
All right, thank you, Dr. Lope-Sada.
No, you're welcome.
So can I just ask Dr.
Yes.
Lope-Sada about, you said you've been involved in autopsies with dog bites.
Yes.
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
When was the last one?
Let's see, probably 2 years ago.
Okay. Any questions based on my questions?
She wants to know when the last one was.
All
Are you
right,
kidding
you
me?
are all set on that. You step down, Dr. Lope-Sada. We'll get to you sometime this afternoon.
Thank you, Your Honor.
I do want to give everybody a break, including counsel. Can we do less than 5-minute arguments on this?
What is there to argue? What is there to argue? You're the one who asked for the voir dire, Your Honor. What is there to argue? If she had one dog bite case, she's the medical examiner. She's a forensic pathologist. Oh, look at this. She's trying to figure out a way to exclude some of her testimony.
Your Honor, I'll make this very brief.
Okay.
Dr. Lope-Sada is eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this voir dire for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds
By the way,
and the source of wounds, i.e.,
dog bird
was
many
it a
times
dog,
does not
was it
apply to forensic
another animal, was it
pathologists.
another
Just so you
source,
know, we'll talk about
was it
that.
lacerations versus abrasions, things of that nature. She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies that she's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally somewhere close to, I thought it was probably 5 autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attendant to the injuries that led to a different cause of death. But she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites, she's seen dog wounds, she engages in pattern recognition. She also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent or inconsistent with dog bites, and I expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously,
This should not even be
many more
issue. This shouldn't even
autopsies
be
dealing
an
with that
issue.
because
She's
it's more
raised this
common.
as
She
an
also
issue.
engaged in the exact
This
same
is so
differential
ridiculous.
diagnosis. She has training, the sub
And now she
field
wants
of-
AJ to
or
rush.
the sub issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on, going all the way back to the 1980s, dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about the 2 subjects that she's been called to talk, well, she's called to talk about several other subjects, but these 2 subjects that's before the bench right now, than somebody with Dr. Lope-Sada's qualifications. I will submit on the voir dire that we just completed.
All
Your
right,
Honor.
thank you. Mr. Brennan.
I do not think that Dr. Lope-Sada has articulated the experience the way it's been summarized. She could not provide any specific training other than her boards and her references to literature. She could not articulate one single class or seminar that she took that pertained to differential diagnosis of dog bite injuries. She has no specific memory of having any type of experience in differential diagnosis as far as being in a training, seminar, or advanced education. She has the experience of a medical examiner who has seen what she
I will
believes
remind
to
you,
be
the
dog
only
bites
one
in
in the
past.
state that can talk
She
about
has
a
no
cause of manner
publications
of death is a
or
usually
references
the medical
that she has
examiner,
studied the
who's a
issue
forensic
of
pathologist,
differential
usually board
diagnosis
certified,
or
like Dr. Lope-Sada.
pattern wound recognition relative to dog bites.
Now,
If we
I'm
look
done.
at the
You're
standard
right.
Dr. Russell employed, Dr. Lope-Sada does not have any of the merit to be an expert in dog bites. While she has taught, we did not hear about anything in particular that she has taught about specific pattern wound recognition analysis regarding dog bites. She is an experienced medical examiner, has a wealth of experience, past experience in autopsies, but she has no experience that is a basis for her as an expert in being a dog bite expert. Particularly, she mentions one case that she's testified in federal court that we've heard of today, and she has nothing whatsoever in her report or resume to establish that she has used, studied, and knows this methodology. In fact, her CV and her report don't have any basis for one to look at and see that she has any specific experience
Which
in
is
dog
why
bites.
you had a problem. You
And
could
so
have asked for a
Dr.
dog bite
Lope-Sada,
hearing
from the
before.
Commonwealth's perspective,
Hank,
should not
this is
be able
called-
to give an
this is
opinion
called bullshit.
regarding or
This is
about
called
whether or
trying
not the
to
wounds on
wait
Mr.
on your
O'Keefe
concerns
were caused
and
by
do
a
this
dog.
when you
She
shouldn't
simply
be
does
doing
not
this.
have the training and experience and education and methodology to make her a so-called dog bite expert. Regarding accident reconstruction, she said it best. She is not an accident reconstructionist. She saw some of the materials in this case, but it is a fraction of the materials in this case. She is not in a position to give an opinion whether or not the wounds are consistent with broken taillight. There is nothing we see on her CV. There's nothing we see in her report. There's nothing we heard on direct examination that she has any experience in breaking glass, breaking plastics, and the causation of wounds. It
On
also
that
overlooks
basis,
the
Michael
fact
Bryant
that
should be the
the
expert,
opinion
because
that
he's
would be
broken
offered
glass
would
and
extend
plastic
beyond
in this
just the
case.
wounds on the arm. It would extend to a general opinion that he was not involved in a collision, and that's improper. There's no predicate or basis for it. And so based on her testimony and absence of being able to provide any education or experience, she should not be able to testify about either of these two matters.
Okay, thank you.
Briefly respond.
Okay.
She was, Mr. Brennan suggests that, well, she's only been qualified in one court.
Microphone.
Court, but federal government,
Microphone.
federal judge
Microphone, AJ.
handling that case qualified her as a dog bite expert in that case. That is not a small thing. That, as a matter of fact, it's a very big thing
Thank you.
for Dr. Lope-Sada
We'll get to your
and
super
her
chats when he
credentials.
finishes.
In addition, she indicated, contrary to what Mr. Brennan just suggested, she indicated that she has been training on wound pattern recognition as it pertains to dog bites for her entire career. Not just when she was studying for her boards, since she's been studying for her boards. And it's been constant and consistent throughout her entire career. She's made these differential diagnoses. She's seen the autopsies. She's seen the wounds during autopsies firsthand, probably 50 or more. She's supervised another 75 or more autopsies dealing with known dog bite wounds. She has the credentials. The court will recall that, for instance, Dr. Isaac Wolfe was called to testify by the Commonwealth. He had absolutely nothing, no credentials whatsoever to talk about wound pattern recognition. He was a neurosurgeon, and yet he was allowed, over Mr. Alessi's objection, to talk about and to discuss his opinions and conclusions as to the wound pattern on the back of John O'Keefe's head. Certainly, Dr. Lope-Sada brings much, much, much more to the table than Dr. Isaac Wolfe. I'm not comparing them. They're apples and oranges. Dr. Lope-Sada is she doesn't have to be a sole dog bite expert to be expert in dog bites. She doesn't have to be Dr. Russell. She just has to have that level of knowledge, that level of skill, that level of expertise that's beyond that of the average layperson in order to opine as an expert on a particular issue. She certainly brings that to the table as it pertains to dog bites, and I think her skill and her education, training, and background certainly speaks to the fact that she has that in spades with regard to motor vehicle pedestrian incidents.
All right.
I'll submit.
Thank you. All right, I'll get your ruling as soon as I can. So we're going to stop back up.
I'll get
20
you a
past 2,
ruling
and I
as
expect to
soon
go
as I
straight through the
can.
rest of the afternoon.
All rise for the court, please.
I'll get you a ruling as soon as I can. Are you kidding me? Are you kidding me? That should have been right from the bench right there. Let me go, Jersey girl. You've been so while Michael Bryant's getting dressed. You have 3 questions on this. Let's answer them. I told you I would. There aren't specific classes, seminars, or journal articles about every radiological procedure finding, as I'm sure is true for all the scientific fields. You're right. I mean, there's, as I told you, if you look up the case in Canada that calls a whole commission with 600 pages as a result of trying to find whether this Dr. Smith, a forensic pathologist, had given the right diagnosis. And it started with the concern over a woman who was in jail because he said there were stab wounds and when they were dog bites. And every forensic pathologist knows that case and has information and has seen cases about dog bites. Hi, Michael Bryant. I'm just going to get through these three things. Jersey Girl again. Thank you for your donation. 1 of 3. Yes, Brennan has repeatedly questioned Dr. Wolfe and other defense expert witnesses about specific classes, seminars, or journal articles about specific reasons for findings. I'm a forensic pathologist. 3 of 3. Determination is based on training and experience. I'm concerned about jurors who don't have any type of background. Yes, it is. In forensic pathology, there's not the Dalbert hearings because it's based on your training. That's why you're allowed to call it a cause of death or manner of death. Cause and experience is very important. You have books that are written, but there's not every single article on it. You think you're going to challenge my husband, who's had between 20,000 autopsies and maybe 30,000 if you have supervised autopsies in his career, over whether he's seen a dog bite or not? Are you effing kidding me here, people? And Judge Bev, who just had Hank Brennan lie to her, is going to consider what she says? This is absolutely ridiculous. Angel, also, is it normal for a judge to ask questions during a voir dire? Could this be considered bias? No, it's normal. They can ask questions. But is this bias? Michael Bryant, you got to interject on this because I think Jersey Girl and Angel have this all right from what we're seeing. This is, excuse me, this is a legal term. Bullshit.
Don't steal my lines. Anyway, yeah, the easy part for me is that I no longer get flustered, frustrated. I expect it. It's a joke. And it's so refreshing when I work on my own stuff, which have real people, real law, real facts, real decisions, real justice. Then I have to stick my head in this pile of shit. I just decided not to get exercised about it anymore.
I'm sorry. I'm still exercised.
It ain't worth it. It just ain't worth it. So having said that, obviously, none of the things that could have gone wrong for the prosecution did, including that there was never going to be a mistrial with prejudice. We know that. But to hear Hank Brennan say, oops, looks like I did it again, as my friend Britney Spears would say, I made a mistake. I mean, it just becomes laughable if it wasn't for the fact that somebody's life is on the line, right? Right. And they're kind of counting on a smidge of justice coming their way. Every time something like this happens, it amazes me. I guess it shouldn't. I don't know how far you'd have to go. And I think at this point, with this latest mistake by Mr. Brennan, that Judge Bev really has her tit caught in a ringer on this one, because this is not something that she can really divorce herself from. This is not something that she can even claim that was somehow misinterpreted and was in an innocent mistake. It was very well laid out by Mr. Alessi, who gets fired up. He gets fired up.
Like me. Sometimes I'm like, I'm in the courtroom. I'm like, I'm fired up like he is.
He and he's just, he's so smart. He's so succinct. And even though she tries to step on him at every turn to take him off his game, he is not moved, and he makes his points. And he knew that wasn't going to be granted. He knew that. He knew the mistrial was not going to be granted. But he also made it very clear, and the jury has to, at least if they're going to infer anything, infer that Brennan lied to them. Obviously the judge's curative instruction was not going to use that phrase. Basically she's saying, "Oops, something happened. You were told something that wasn't true, right. And now here's the truth. This was done by the lab when they were sampling." I wanted to get a better look at those holes because I don't remember them that well. But it seems to me, weren't they kind of geometric? Weren't they?
Right. Yeah, they're cutting.
They're like a square or a rectangle or
triangle.
Yeah. I mean, not something that you would see happen in nature, so to speak, whether by an animal or the ground or anything else. So anyway, it's sad. It's unfortunate. It shouldn't be, and it's frustrating that there's nothing that we can do about it, that nobody watching this unfold can do about it. That if it's going to be fixed, if there is a conviction, it's going to be at the appellate level. I start thinking about things like, because I am concerned for the defense now after Friday, less so after today, because I think Dr. Wolfe did a decent job of thrusting and parrying away the cross-examination of Brennan. But I do still think it left enough in the jury's minds to consider how this taillight got broken, how therefore John O'Keefe ultimately died. I think there's enough there. If they want to find it, it's there. So I start thinking about, okay, how does this get fixed on appeal? And I start thinking, well, Karen Reed is out on bail now during trial, pending trial. Would they revoke that bail pending appeal? I mean, those are the kinds of things I'm starting to think about now that I would never have thought about before.
Right.
I think those are real issues. And I don't know. I don't know the answer to that. My gut tells me no, they would revoke her and they'd put her in jail pending the appeal.
Yeah, that's what I think
So-
too. But even her charge, I think Alessi tried there because she started to say, well, you're not to draw any inferences. Well, you're supposed to draw any inference from it.
You don't
And
have
then
to draw
here's
any
the
inference.
story. And then
Here's what happened. He lied.
He lied, right? And then the other thing I just thought was it didn't go far enough. He should have said. And you heard these questions in light of Dr. Wolfe's cross-examination. If you took any impugnation of his bias, any of his testimony, or you shouldn't do that. You shouldn't impute anything wrong to him at all, or something like that. So, that's not really good, but there should have been a chance for the defense to submit a curative instruction. Not then when they try to object to her when she's giving it. I say, I just read it to you, and I'm going to read it to you.
You
again.
heard it, so that's what I'm going to use.
Right.
Yeah. I hope the record's clean on all of that, because sometimes the printed transcript doesn't really relay very well what happened. I think that'd be tough to disguise the way she, if the transcription is accurate, it's going to look just as bad as it sounded.
Well, it was pretty. I mean, I was dying here. And when he tries to make the argument that this is on top of the motion for mistrial last week, in other words, so let's make two mistrial motions. Now I'm going to make the motion for a mistrial because of the joint prejudice. She just cut him off at the kneecaps, or as someone would say, further up.
Yes, that's true. Yeah, no, he couldn't even get into that. And you can sense that she feels this kind of pressure, and she's wrestling with how bad it makes her look versus her agenda. And she has an agenda, and that is got to get a conviction in this case.
Right.
I'm going to do whatever Mr. Morrissey wants, and that's what we need. But
At
I
this
can
point,
tell.
I believe that. I didn't come into that believing it, but
Well, I didn't
believe
either.
that.
But after first trial, I was halfway there, and a few weeks into this one, I was all the way there, and now I'm over the line. But I feel she's struggling now because she knows that ultimately she has to justify what she does.
This was a big deal today.
Yeah.
This was a big deal what just happened with all this. This was and she knew it. She knew this was a big deal. How about the fact that she didn't have any grave concerns with Mr. Brennan? How about that?
No, not a flat ass lie. No grave concerns. But again, why does that surprise us? It does not surprise us.
I know, but it just
it would surprise us if she did.
I'm just, Michael, just as being a practicing lawyer for all of these years and trying to do the right thing and working on wrongful convictions and all, and working in the criminal defense system where people hate your clients, everyone presumes they're guilty, right? When they're not guilty, they're not guilty of the top crime. It's sickening to have a judge, because I say it all the time. Judges usually come off the bench and sit with the prosecutor. The only time we didn't see that is obviously in the ASAP Rocky case, and when Judge Page Whitaker, after almost 2 years, took over the YSL case. By the way, the last defendant, Effinger, pleaded today. I don't know what he pleaded to. I hadn't had time to look, but the YSL case is officially over. And all. So but this is all the trials we've been covering for the last 5 years, Michael Bryant. What do you think? I mean, I just can't. We're supposed to be telling these people about how good the justice system is, and we can't do that.
That's embarrassing. Yeah, it's embarrassing for the profession. It's embarrassing for those of us who are trying to uphold the profession, be a good example of the profession, explain how it works, explain how it's good for everybody. And then we have, case after case, some worse than others, that make it look like it's a railroading of people who maybe have some guilt, but we'll never really know because the process is not really pursued to the degree that it should be. And speaking of that, can we talk about the Baden defense here?
Absolutely. Go ahead.
Since the third-party culprit defense has really been abandoned, right? We aren't seeing that. And I think they learned from the first trial and maybe they modified during the second, that the jury just got kind of confused about how that all worked and who had to prove what, and that ended up with him shifting the burden to the defense to prove this third party culprit or conspiracy. So I think they abandoned that from 1 to 2, and then even more so when they got into 2, and they stopped. They weren't calling people. I mentioned it earlier today, and we should do this if we have a chance, Linda, and that is look back at the opening statements.
I agree.
And I mean for both defense and prosecution.
Right, I agree.
Because I think the defense has not yet fulfilled some of the promises they made in their opening statement. And that could be a problem, so it's always educational to go back and look at those at this point in the process and go, oh, I wonder why they didn't do that. They were so adamant about that, and yet they didn't. There will be, what did Alan Jackson say? There will be no doubt that John.
He said John Keith entered the house. Entered the house, right?
I know. I'm not sure. I mean, maybe this PI, if he is allowed to testify really in detail, will get you there. But there are some interesting things.
Put in a picture of the garage that the prosecution took.
Apparently, what they did was they agreed on the pictures, but there was going to be some sort of adjustment or labeling or redaction or something to the photo that was immediately put up, and that's what got her all upset and said, "Let's take lunch." And then she said, as the jury after they left, she said, "Mr. Yannetti, can we get that fixed? When we come back." So there was something, we don't know what it was, we may never know, but something, at least according to Judge Kenney, was not appropriate about that photo, even though approved in general. So we'll see. But this guy, I guess he replaced
Somebody
P,
got
right?
sick.
Private Eye Pauly. And so we got this guy instead. I don't know if what he's got to say is consequential enough, but
you know what I love? I love the fact, here's what I loved about his testimony so far. That he went and he said, I was met by the homeowner, an older gentleman, and did he let you? Yes. See, so this was prepared. The homeowner was happy to have the defense come in. Obviously, the homeowner thinks there's something in that garage that's important. To me, that's what it sounded like to me. The homeowner is interesting, because it's clear to me by the way that Jackson used the word garage so many different times through this trial, that there's something in that garage that Dr. Lope-Sada is going to testify to is made like that J imprint and makes this an impact injury.
That'd be interesting.
That's what I think they're going to say, and I think
that would be
important.
new. That would be new stuff. That was.
That's
we
what I
know
think.
that the prior, suggestion was that something happened in the basement. They ultimately replaced the whole basement floor, soon after this incident, which leads you to believe something made a mess down there. But the garage was never the focus of anything.
Yeah, but it's the focus now of something. When we got an email from somebody who told us, and we never got back because we don't have any ability to correct that there's blood on a table in the kitchen, but that was just. That was neither here nor there. It was not something that we could investigate. So I never got back to the person because how are we going to do that? The defense knows this case inside out. And if there was blood in the house, I think they would have found it.
Probably would have.
You never know. Sometimes there could be somebody who's an informant, somebody who's been there and decides that we're fair and talk to us. And I probably should respond back, and maybe I will later today. But this is pretty. Somebody who has this question, and I'm going to kind of answer it, because the judge ruled today when she already ruling through Lope-Sada's opinion before she even got for the voir dire. She can't testify to this. She can't testify to that. She can't testify to this.
Yeah, she had already whittled away at it, and even the things she said she would allow, she was going to make subject to the voir dire.
Yeah, right, and that's what her rule is. She's got to make a ruling.
Let me think this over.
Had no frostbite. It also proved that he wasn't outside. She won't allow to say that the Wisniewski spots were misidentified. I guess that was one of the rules. But I pointed out to you once before that the whole idea of the frostbite came from the body temperature. And if you recall, the medical examiner, Dr. Scordi-Bello, said she wouldn't rule frostbite as a cause of death if she didn't have the impact. She wasn't going to rule frostbite as a cause of death. She just said it was contributing. But here's what's interesting about that. When you die, your body descends in temperature. your body goes down. It doesn't stay at 98. As you die, after you die, it doesn't matter whether you're in the cold or not. You're gonna get cold. You're gonna be cold to the touch. Right? You're cold. So I mean, a lot of that whole issue of how many degrees he was, that could be due because of a lot of it due that he died. He just died. He was dead.
That's true. I mean, he was down to like 81 degrees or something like that. But on the frostbite issue, doctor, let me ask you this, Dr. Baden.
Well, since we're doctors here, we're as good as anything, because she's not letting. She thinks that a forensic pathologist can't testify as to a car impact because they're not a biomechanical engineer. Okay,
it's a joke, and you
It's a
should
joke.
put all that in your CV. I mean,
and you put that on. Who puts that on their CV?
every little teeny thing you've done. Went to lunch with, and we talked about this. Anyway,
Actually, you're the biomechanical engineer. You could take that car that we have and do the hammer.
I can do that, yeah.
Because you can do it according to the way she is.
Here's how much force it took to break this.
Yeah. Oh, you're doing it. Okay. El
I
Diablo.
didn't get to that today. I was going to do the diffusers. I was going to,
Yeah.
I was going to break
get to it.
I didn't get to it because they got busy today.
El Diablo says had to break out edibles after Brennan caught lying. So F made.
Yeah. Okay. So frostbite.
Very good. You should have shared them with us.
I don't want to leave the frostbite.
I'm sorry.
Frostbite, I imagine, only occurs to living flesh. Is that true or not true?
I don't know the answer to that. I assume it has to be living. I assume you have to be living.
Dr. Michael Baden. Yeah. I have a question for you. Yeah.
I know. But I have to call him and maybe ask him that question. Or we can Google. We can ask Alexa.
You could, Dr. Baden, Alexa, whatever. Yeah. But
well, that's who she thinks should testify.
My point is, if he's alive when he first hits the lawn, and I think most people believe he was, and then at some point after he died as a result of a number of things, hypothermia, back injury to the back of his head, all of that, would he have been alive long enough for frostbite to take effect? And if so, how does that?
Be alive, right? You have to be
alive. That would be my estimation. So if he was only there from, let's say, 3 in the morning to 5 in the morning, or 5:30 when they found him, 5:30 or so, would it have formed at that period of time, or would he have needed to have been there at 12:30 when it's alleged by the Commonwealth that he was hit and went to the ground? Is that time period enough significantly different to suggest one version of the story or the other? I've heard nothing on that, but I'm curious about it.
Yeah, no, I know. Speaking about the Baden defense, I think what they're doing is they're incorporating. I mean, they kind of misled the prosecution a little bit and the judge, because she probably wasn't going to allow, by the way, the third party culprit. But they can say, as a result of the Baden defense, we don't know what happened in there. There could be anything happened in there between. You saw the waterfall, you saw what was going on, but we don't know, and we can't point to anything because all we can do is point to the evidence we do have, which is the dog wounds and Chloe being rehomed, and then some dog okay, let's see. Okay. Let me see. This just in. Let me see. Thank you, Pat. Okay.
This from our crack research department?
Yeah.
Okay.
Okay, first of all, the criminalist uses a scalpel to remove the cloth specimen. This may have been a little older. Thanks, Pat. Usually making a sharp box-like perforation. The prosecution expert should immediately know that the holes he asked about to look at were made in the lab. It was not a tearing hole. All right, this is a while back, but this is Pat. Thank you, Pat. Appreciate it.
So it confirms what I suspected, which is how could you hold
now you know what? I need Pat to research. I've got to research back. Pat, I need you to tell me if frostbite has to occur in a living person or not. I know you're watching this. Can you please tell me whether frostbite occurs in a living person or not, and bring that into me? Okay.
We're getting a lot weighing in on the whole frostbite thing, and I'm not wondering about when would it set in. I'm wondering about like the extent of frostbite. Obviously, if
the extent of frostbite, quickly,
over time, it gets worse, right? So over a really long period of time, arguably your whole arm could have it versus a finger. I just think, to me, that would be helpful to know that information.
So how long, if you're alive, how much frostbite do you get? Because we see people that what they're
how long to get frostbite.
The toes have to be amputated, right? And you usually hear about them, or their hands or
And the
fingers.
longer it happens, the further up the extremity it goes. And I just want the time sequence there.
I think we need a real doctor on this one.
We might.
I got it. Pat's
We
going to
might.
be Pat's going to be researching. I know
Dr.
you're
Pat.
on Google on this. I really need something called a husband to ask.
So that.
No, I asked Pat to give me. Pat's my assistant. I asked her to give me blessed in Texas. Because she's around. My husband is not around for me right now.
So when that sweatshirt was held up for Dr. Wolfe, I would have thought Dr. Wolfe, might have noted that they were geometrically cut holes and not road rash, and commented on it, but he just kind of said no. I mean, it was, it didn't help. Let's put it that way. It didn't help. If I saw those, I'd say, well, I don't think of the road or a dog or anything caused those. They look like somebody cut it out.
Yeah.
Which is what happened.
Yeah. So, but I don't, it was, I kind of missed him holding it and taking everything and holding it for him quite a bit. And Hank, he could hold the holes with the thing. Come on. I mean, the whole idea that, first of all, I've been in the courtrooms when you have that. When they put the Hernandez, where we had that whole slit in the back, right? And they put it into the plexiglass. Okay, here they were. I guess they were cheaper. Ours was a plexiglass. This was like plastic. All right. Maybe they have a budget problem, right? Okay.
Did you see that note there?
No,
somebody did some research for us and said that frostbite can occur in dead tissue as well. So.
Okay, well, that I'm going to have to ask the doctor about. All right, I have to ask the doctor. But really, I think I assume the dead tissue would still maybe have some blood flowing to it, that you're dying, so you still got some blood activity.
I think the extent of that frostbite should be helpful, but we don't know that.
Yeah, the encased shirt looks scrunched, and the reason the defense asked to take it out. Yeah, I think it was kind of scrunched. It wasn't like when they did it in Hernandez, they really spent a lot of money to encase this stuff. I mean, you weren't taking it out.
Like a sports jersey, they put it like in a
case.
Right.
You weren't taking out anything. You had to go get the special. Here it was just like cheap, and it was kind of like behind him, but it was a cheap move, and it was a wrong move, and it was a lying move.
It was a mistake. I did not know. I am sorry.
How could you not know the cuttings? The cuttings that you're trying this case. You don't know the cuttings that your lab person made. You are the gosh darn lead prosecutor in this.
Yeah. No, obviously he knew, and obviously he lied, and obviously he was trying to take advantage of Dr. Wolfe and make him look bad, and he kind of did.
It kind of did. And I don't think the instruction helped, because the instruction didn't say, and Dr. Wolfe was asked questions about it. You're to ignore that. They're trying to make Dr. Wolfe look bad. It turns out that Dr. Wolfe had no basis to answer those, because Mr. Brennan was wrong. Those were not. Those.
The jury is left, and I don't know that this is a leap for the jury to assume, to infer, to figure out that Brennan knew and lied about it.
Right.
Because they see him in action. They've seen him for weeks. They've seen how snarky he is. They see how mean he can be to witnesses. I don't think it's outside the realm of possibility. They went, I wonder if he probably knew that and lied.
Right. Well, maybe if they get an idea, but we know that he's been mistaken at least 3 times in very serious matters. He was mistaken when he started the whole thing with the defense didn't turn over the ARCCA information, which they had, and then he said, "Oops, I'm mistaken." And that was that first grave concern, because he had told the Judge Beverly Cannoni that they hadn't turned over the ARCCA information about the feds and the payments, and they had in discovery. And he, I was mistaken, but all the damage was done, and then he about Yannetti, about giving an interview to Court TV. That was a mistake. And Yannetti just came after him and said, I must have been mistaken. And now we have a third mistake. And last week we had the
DNA.
To it, the DNA.
He didn't say that was a mistake. That was, he blamed them he blamed the defense.
Right.
For that. So, and they knew all of this. It was all out there. This is not a surprise. This is not inappropriate. Yeah.
Yeah, I have some timestamps. Actually, we have some timestamps. Somebody wants to know if we have some timestamps. I have some timestamps about Yannetti. I'm sorry, the argument that one passed, and when Alessi first got on, it was at 3:26:09 to talk about the sweatshirt, okay? And then there was when Alessi made the full argument, which we're going to run tonight, I think, on our show, was at 3:36:27. So just before that would have been the whole idea about the mistake, you know. So can the defense in the closing calls about that deception, Michael?
Can they? Should they? Will they? What would happen if they do? They've got to be careful how they do it. You know, you can't be outright about it, but I think you can do a lot to infer that it was more than a mistake.
They showed you, ladies and gentlemen, a shirt. They showed our expert trying to make him look bad about the cuttings that were in the shirt. And guess what? As Mr. Brennan stood here, he obviously was at least mistaken, because those were cuttings made by their criminalist.
Yeah, no, I think it just cements what I think a lot of them are already thinking. But yeah, but you really can't say he lied to you, ladies and gentlemen.
But you could just do what I did.
That might be a problem. Yeah.
Obviously, he was mistaken and put them in quotes.
Oh yeah.
So,
yeah.
like that.
Yep. So what about something else I was thinking about? It's been buried now by all of the other stuff that's come along since. But earlier today, we were talking about making the point of this whole weight of the arm issue and how it affects the speed of the vehicle during the testing. And, you know, luckily Alan Jackson was able to swoop in there and clear up a big issue, which was, where'd you get that 11.8 pounds, you know? And Dr. Wolfe didn't know, immediately didn't come to him. He almost suggested maybe Brennan came up with it, which he did. But as a result of his own expert, Welcher, using that as an average, a 50% figure, right?
Right. He finally got to it at redirect or whatever.
Yes.
Well. Yeah. Maybe he heard us screaming to say, "You're here to rebut Welcher." And what did Welcher used the 50% median? He used the average as the.
Yeah. So to answer that question, Dr. Wolfe, where did you get it? Wasn't it from Welcher? Objection. You know, where did you get that information? Well, it was from Dr. Welcher. Okay.
There's an objection about everything, and he knows. He knows. I thought Hank Brennan actually, for the first time today, when he realized that he was either caught or maybe was mistaken with regard, you know, let's give him the benefit of the doubt for the moment, because I think it's just as bad. All right, he got worried. You could see at the table he was looking. He has to see. He was looking at the things. He either didn't know or forgot, but he got worried. I mean, I thought that was a big moment, and it wasn't in front of the jury, but I thought it would tamp him down a little bit, but it didn't.
No, it gave him, you know, the argument went on for a period of time and got him, you know, he was able to get centered again, come up with his, you know, and for him, the mea culpa was, I made a mistake. I mean, that was as far as he was going to go.
Yeah.
Constance Landers says there are no such thing as dumb questions, of course. During closing arguments, can opposition object? Sure. If it misstates anything that took place during the trial, you can argue, but you have to do it based on actual evidence that came in at the trial, not things you wish had come in or that you had excluded during the course of the trial. Now, but within that, you don't see objections as often in closing. But if you do, it's because somebody is misstating or lying about the evidence that was admitted.
Yeah, right. That's true. That's true. But I have a feeling we're going to see objections here.
Oh yeah, of course.
I mean, we went over and under how many objections. It was like with Lewin. Remember with Lewin, we were like, "Oh, he's not going to object on that." No, I have 17 times. You know.
I can't believe you did that. Yeah.
Oh my goodness gracious. Somebody asked, I saw it go past really quickly, about the feds. Do you think the feds are watching? I absolutely think they're watching the expert's testimony and how he was treated. I do think that. Remember, this is a really strange circumstance, because you have somebody who was assigned to represent Whitey Bulger, one of the most vicious people in the mob that the mob has ever seen, more vicious than anything in The Godfather could ever represent, right? And he did it for 8 years. And now I always wondered about this. He comes into the DA's office here, the Commonwealth office here, the prosecutor's office here, and he's got to work with all these people, right, who knows that he's really a defense attorney for the worst of the worst. And the feds know it because he went at her. He went at the feds, right, for all those years. So I don't think the feds, no matter what administration is up there, is going to pull back on watching ARCCA who they relied on as being the best of the best.
Yeah, no, I think you're right. And what's most interesting, of course, is so what? Are they going to do something with it? Is there going to be some sort of follow-up after the fact? I don't know, but I'm right. I'm confident you're right that they are keenly interested in what's going on there in Norfolk County.
Well, they have this. They had the Birchmore case. Remember, that hasn't gone away, and
Yep.
he's got a hearing in July, and that hearing has been put off 3 times. To me, that says cooperation. Okay, that's what it sounds like to me. Now, I don't know. I don't have any inside information. I just know as a lawyer, when your hearing is put off 3 times and you're the main defendant in a case in the federal court, doesn't usually happen.
They like to stick to the schedule. Yeah.
Yeah.
Well, hopefully, maybe something will go right in that case, however it happens.
Let's hope.
That'd be nice.
Wouldn't that be nice? Wouldn't that be?
Well, we have seen in the federal courts on the civil side some things sort of go right, you know, in some of these First Amendment cases that are brought in the federal court. So, you know, maybe the same thing will happen in the Birchmore case there.
Well, usually, and then there's some federal courts that are different, but usually, you know, somebody said that Hank Brennan got bailed out yet again. That's right. Not only bailed out, she was looking. We were talking about it when Leslie's making the motion. She's already looking because she's already looking for a way out. You know, she knew this was this was a big problem.
Oh yeah.
And I can't explain to people how big an issue this was this morning. Okay, with that misrepresentation. And then she tries to slam them down when they're trying to talk about what the wording should be for a charge. But I didn't hear them objecting to the charge. That's the problem. They had to object and say, Your Honor, we want to submit to you a jury instruction. We want to submit that to you. They didn't do that, so therefore they waived it.
Yeah, yeah, and maybe they did it at some sidebar at some point. Who knows?
Maybe.
But if it's not on the record, it's gone.
Oh,
Yeah.
Michael, it's exhausting. I said to somebody this weekend, because I took the day off on Saturday and spent it with my girlfriend. And by the way, I wore the Justice Serve TV leggings in white. I got so many compliments. I put it on Instagram. People thought I was wearing couture leggings.
Ooh,
Okay.
wow.
Yeah, I had so many compliments. So, you know, a little plug for our merch store. Those white Justice Serve TV yoga pants, those yoga leggings, they are just great. Okay. But so I took the day off just to try to, have some fun, relax. And I said to my girlfriend and then people I talked to, I said, I'm more tired. Maybe because we'll have to also, you too, we have to do our own work, which has been very difficult. This morning you subbed for me as I had to get some comments and something out. We have to do our own work, but I'm more tired commenting on this than I am if I were in the case and my adrenaline is flowing. Maybe because you're right. I expect all this, the judge to come out and bench and sit with the prosecution, and you know you're going to be in a fight. But here, it's not our fight. And so I'm exhausted fighting not our fight, right?
Yeah.
All right.
Yeah.
Oh, Candace ordered. Right. Thank you for your order, Candace. Legal-minded friends. Yes. Oh, I bought I gave a birthday present, the green ones, and my girlfriend loved those too. But the white ones are just, yeah, I know, Michael, this fashion, it's not Fashion Friday. It's only Monday.
Yeah, that's all right.
Yeah.
Lisa was wearing the T-shirt. I got one of our T-shirts. She was wearing that.
Ooh, that's great. Thank you very much. Thank you. But I'm more exhausted because I feel like we can't do anything, or maybe we're doing something.
It's very frustrating, and I think that's how you get. You know, the passion is obviously it's great. It's that's why we do what we do. Otherwise, why would we be sitting here talking about it? It's not like we're getting hundreds and hundreds of dollars per hour.
Now, by the way, I just want to inform you. This is breaking news right off the bat. Tonight at 6:15, Priya Banerjee is going to come back. She is a pathologist we had on 2 weeks ago, and she said she'd come back 15 minutes. She can give us because she's testifying at some court martial way away. So it's wonderful that she's going to talk to us the same day that Dr. Lope-Sada is going to be on the stand, and kind of got disrespected even by the judge by making her do a voir dire and now saying,
just ridiculous. And she hasn't decided yet.
Yeah, I'll have a ruling for you later whether she can talk about things. All right. El Diablo during the closing, can defendants say that Hank Brennan purposely didn't put 3 documents from crime list in? No, can't do that. I don't think so. Although because they don't have in some cases, in some courts, you have defense marked documents and plaintiff's marked documents, but they all go into the same mix. That's where you get the ZZZ from.
Yeah.
They all go into the same mix. Okay. But maybe they can say, we didn't show it, they didn't show it to you, we had to show it to you, or something like that. I mean, they're going to be trying to work their way around it, but they can't say that they purposely weren't put in. But they can say the prosecution purposely hid a lot of things from you, purposely hid a lot of things from you.
Yeah, and
right?
then and especially if it's something that the defense then brought out, because then it's very easy to say, look, they didn't show you that, we had to show you.
Yeah.
Speaking of tonight, I don't have the details on it yet, but I think I told you there's somebody who reached out who had some issues with the Albert family and trying to intimidate them.
Right.
And so I'm following up on that. We may have some video and that guest to talk about that tonight. Something happened just last week in Dedham and Canton, I guess. And Canton, of course, is run by the McAlberts. And this person had a run-in, could have gotten ugly. And some of it was videotaped. So
wow. Well, Priya could only say 15 minutes, 6:15, 6:30. So
I remember she was on Law and Crime when we were doing our thing there. She would appear. Yeah.
And she worked at the same Rhode Island office, not with Dr. Lope-Sada, but she worked at that Rhode Island office after Dr. Lope-Sada had left. So interesting. This whole idea that a forensic pathologist has to have, there's no Dahlberg here. They didn't ask, Hanke didn't ask for a Dahlberg hearing beforehand. Now he wants a Dahlberg, basically a Dahlberg
mini Dahlberg hearing.
And then, but the judge is the one who says, I'm going to need a voir dire. I mean, so what is she going to do? Not let her testify? A forensic pathologist about whether or not
that's right. She'll limit her testimony. We already know she said she can talk about the lack of bruising, but she can't say that in her experience a motor vehicle bumper would have caused bruising. She can't make that connection. She can only talk about the lack of the injury, not that if somebody were hit by a car bumper, they would have those injuries.
Right.
I mean, that's a distinction that is frightening. And then she's got, her ultimate opinion that the defense wants in is that these injuries are caused by a dog bite. I mean, that's the guts.
Right.
And she could very easily say, nope, I don't see enough. I don't see enough methodology. That's what they like to rely on. I don't see enough methodology here. And her last case was 2 years ago on that subject, et cetera, et cetera.
So what? That's the whole point. You take all the forensic pathologists see everything all over for years, and you take their experience and their training, and that becomes important. I mean,
he's really no different than Dr. Russell, who treats living people with dog bite issues, or has in her thousands of cases. Here's somebody who does autopsies on thousands of people, and sometimes dog bites are part of that process.
Right.
What's the big deal?
I don't know what the big deal is, but she's going to find something that, and what's really bad is that she is a highly, as someone points out, highly regarded judge in Massachusetts. She ran the committee to change the rules on evidence for discovery. She's probably going to go to what their top court is. Okay. She's really regarded, and that's why she has these cases. And that's why she teaches at Harvard in the same course that I teach at. She's in the third week. I'm in the first week. She's in the big judges week, with the judges come, and not the lowly lawyers who have to do all the work in a courtroom to tell you. Okay. I'm embarrassed for the state of Massachusetts. I'm embarrassed for the law. I'm embarrassed for the justice system here.
Yep.
Now, that doesn't mean I don't know whether Karen Reed did it or didn't do it, but all I know is that the prosecution has the burden of proving it.
Yep. And they shouldn't get help from the court. That's the bottom line. It shouldn't be 2 against 1. So anyway, and Harvard's had a tough year. So I don't know that her connection to Harvard, yours is great, but I don't know if her connection to Harvard is helping their cause.
Yeah, I think I did the report that I was freezing, and we put it on just for members. We never released a public report about the first case at Harvard dealing with the dentist a dentist identification of dental teeth, that somebody was burned in a furnace, and that was the original case of forensic science in the United States. And I was so cold when I was trying to do the report outside. I think we limited remember that for 20 seconds.
I do remember that.
I couldn't even talk because it was like minus 20 below. I mean, I'm exaggerating how cold it was, but it was so cold that I couldn't even talk to get the words out that you could understand what I was saying. you know, but maybe I'll have more. Maybe I'll do a separate one. on
Next
that.
time, find some indoor signage. I know you wanted the sign.
I couldn't. They
right
wouldn't let
behind
you do it inside.
Oh, they wouldn't let you
couldn't-
do
yeah,
it
Yeah, you
inside?
can't do it inside.
Why?
'cause
What are they trying to hide? What are they hiding
yeah.
there at Harvard?
I
What's the
probably
deal?
could have done. I probably could have done it in the ladies' room. All right, I probably could have done it in the ladies' room.
How
you
is the
know?
ladies' room at Harvard, by the way?
Oh, they're
Are
beautiful.
they nice?
They're
They good?
green. I don't mean green in color. They're green. They're beautiful. I mean, especially in the hall we were in, you know, the Wasserman Hall was. They're beautiful. I mean,
I wonder if
you
they're
know.
going to be so nice next year. They're losing a lot of funding. So
Yeah, but they have.
something's gotta go.
They don't want to spend their endowment. All these places.
Well, yeah,
these
they have 54
huge-
billion in endowments. Why
all these-
spend that
right.
money when they're taking tax dollars?
All these
That's a whole
places have
different
huge,
story.
you know, all these places, not just them,
Oh, yeah.
all these.
All of the
these
Ivy
Ivy
League
school-
high level
right,
institutions have
right.
a ton of money that they don't want to take.
Right. So my ladies' room was great, you know. And I think actually this building was built on a donation, a private donation. This wasn't federally funded.
It had a name on it.
Yeah, I forget, but it was built on a private donation. And you know, I went to Rutgers Law School, which was the people's law school. Let me tell you, our bathrooms weren't good. We were the people's school, you know, at that time. That's what it was known as. And so for me to come and see students that have fireplaces and beautiful lounge chairs and different, I mean, it was like, oh, this is. You go to school now. This is what you get. Yeah, but by the trade-off is I'm a sassy trial attorney and can try cases. That's a trade-off, and I get to teach people who aren't going to be trying cases but want to get the skills in case they ever have to be in a courtroom. So that's the trade-off.
Yep. And if they're smart, you know, they'll listen, and someday it'll come in handy for them.
Yeah, no, I think that the students they do listen. You'd be surprised how quickly they can pick it up and how quickly if you teach them well, how quickly they can learn and to do a good job. It's very hard. Imagine coming into a course where you're going to spend 3 weeks. The first day, you're going to learn about, you know, opening statements. You're going to learn about how you do a direct examination, how you do a cross examination. You're going to get the fundamentals of, you know, if you're a criminal defense attorney, how you break down the wall of the prosecutors. Like if you look at, you know, when for instance, if someone came to you, Michael Bryant, and said, would you represent Aaron Hernandez on this double homicide case where he's already been convicted of a murder? You'd say, oh, no, right? But then you look at the evidence and you start breaking down those walls and you break down that brick wall and you rebuild it to your story. And that's basically what we teach them.
Yep. Good for them. Yeah. And people don't realize, you know, when you go to law school, you can take a class in trial practice. I did take one just to get your toes in the water, but it's not very practical. I mean, you're not going to walk out the door ready to try a case. So to have that kind of intense education is critical. And I'm assuming those who take it plan to be, you know, litigators, trial attorneys.
No, not necessarily. A lot of them are going to, they already have offers.
They want to be transactional people?
And they're transactional, but they know that they're not going to ever learn the procedures of how to try a case, and they want to learn. And some of them are going into public service, but most of them already have commitments, even at the second year where they're going.
Yeah. Interesting. So I guess they're doing it just for the hell of it, which is
They
great.
They want to become good lawyers.
Well, transactional stuff puts me right to sleep. So that's what they would call solicitors over in the UK, in England.
Really? Is that what it is? It's UK
solicitors, yeah, barristers if you're a trial attorney over there, and then wherever my wig is. Where's my barrister's wig? It's over there.
Do you have
anyway, yeah.
So you have a barrister's wig?
Yeah, I told you that. I've shown you that before. I think.
Oh, that's
I
right. I did. I did
That
see that.
wig.
Okay.
They have the one shop in London where they make those wigs for all of the barristers. And solicitors have to use them occasionally, but barristers primarily, made out of horsehair. The store's been there 400 years. 400 years. And so I went in there and got one. And I was talking to the woman who made it, right? She said that I actually just came back to work a few months ago. I took 18 years off. She had a baby. As soon as the kid left to go to college, she went back to work at the same exact wig place. So
that's great. That's
dedicated
great.
to a very special craft there. But
okay.
Yeah.
So Michael, on scheduling, so it's 2:21. They're going to finish at 4. They still have to do the private eye, and then she said to Dr. Lope-Sada, "I'm going to get you some time today." We have Dr. Lope-Sada. We know what the cross examination is going to be like. Then we have the PI. We still have Rentschler. Okay, so I don't. So and then the prosecution has 2 rebuttal witnesses, which she's allowing them to call the dog bite person. Okay, and Dr. Crosby and Dr. Welcher back.
Yeah.
I don't see how this case closes Thursday.
And
I just don't.
I'm actually giddy with the prospect of it not happening on Thursday. I got a lot happening. I'd love to have this full week to finish out, and then if they get into it on Monday, it'd be perfect. So if I can send an email to the court, see if they can work that into their schedule. I was waiting for the answer that she had asked the jury about when they left Friday, which was Thursday was going to be a half day, but now we're moving along. So can you just think about whether you can be here all day Thursday or not? Because if the jury can't be there all day Thursday because they were planning based on what they were told before, then that's going to be another extension to the process. So,
Yeah.
and I
mean,
can't
clearly this
imagine
place should
closings.
close. Yeah.
Can you imagine closings on Friday and they give them the case on
She
Friday?
could because I
That
got a
would
jury
be
here
a
and
mistake.
you know, she's got an hour each one, 9 o'clock, 10 o'clock. She takes their break and then she charges them and then they go to lunch and she gets a half day deliberation. She could do that.
I know that'd be a mistake in my opinion.
Yeah, but I just don't see how if Hank Brennan continues on this everything cross-examination has to be until you want to like say you want to almost like say, okay, I'll see you, I'll be back when they're closings, you know, because you can't listen anymore. I wonder how the jury's feeling about that.
Probably a little of that. Yep. I'm sure they are over Brennan, over it.
Well, if they're over it though, but are they over it and saying this is bullshit? Okay.
Yeah,
You know,
I
they
think
saying no. You know, we know what happened.
As I've said before, even when Brennan makes a point, a legitimate, fair point, it's tinged with his assholery. You know, he's just
What was that word again?
Assholery. Assholery.
Okay,
Yeah.
this is it. This is Michael Bryant's rant. When Brennan makes a point, it's tinged with its
Assholery. Yeah.
There we go.
Yeah. I mean, that's so.
That
And I'm
should be a
serious.
clip.
When somebody is, I normally would say unlikable, because as I say, never underestimate the power of likability. And the opposite's true. Never underestimate the power of unlikability. He's just an unlikable dude. So he may say the best, smartest, most correct thing ever. And still it's like, kind of a jerk still.
I want Oasis Cat just to get that on and put it on Twitter. I just want X Twitter. I just want that. I didn't take a timestamp of it.
Yeah.
You know, somebody cut just that and send it to us so we could put it on our Twitter account.
Yeah.
You all can do it. Flip it, Micah.
Get a mark, get a black mark for that.
No.
So anyway, that I think is you can't discount that. You can't discount that this guy's unlikable, and then it's going to affect the jury's receptiveness to his argument.
Yeah. Yeah. So yeah, you started the day for us. I mean, you know, and I thought Alan Jackson did a good thing. The first thing he said, why did you use that? Like you said, the 50% median, because that's what Welcher used, right? Finally, we got that out. Yep. You know, Wolfe is such a gentleman. He doesn't want to denigrate or derogate. It seems like we had Stephen Plort on. He said, look, when Welcher was on, he didn't go far enough. You know, he didn't do all the tests. He was talking about doing the tests that Wolfe is doing. He needed to do those tests. Right. And then but he didn't denigrate him. He said, look, he did some good things, but he didn't go far enough. And to me, it's not guilty because of everything else. I mean, Stephen Plort has said that 3 times on our show, every time he's been on. And then the other thing was these dummies. Today, Hank Brennan started to castigate him about. I was listening to the crash dummies at this really mannequin. And Stephen Plort explained that those cost $100,000.
Yeah.
No one uses those except when you need to have the sensors in there. They use Randy. Everybody uses Randy.
Yep. And they can get the information they need with their own exterior sensors without, you know, trashing $100,000, $150,000 piece of equipment.
Which is, I'm sure, why Welcher didn't go out and charge. He already charged $430,000.
He probably tried to. I wanted one.
Let me do it. If you want sensors, give me 3 or 4 of them. I can charge $850. He wouldn't even buy a tail light for $200. Remember? So
and look how many they went through with ARCCA. They had to go through a dozen of those.
Right. They went through a lot with them, and
they're not cheap. Even I would assume they bought operable lights just because they don't want to be criticized. Right. Isn't it true the lights you bought they don't work like that one Michael Bryant has? You know, so I'm sure they got real lights, and those are like $300 or $400 a shot.
But they said they did them, and they only charged for their testing. They only charged $50,000, so that was in their testing. And they used the lights, the tail lights there Welcher wouldn't even use the taillights. He said it was too expensive, and yet he still charged $435,000, I think it was, for the total, including the car, which he expects to make money on when they sell it, and give it back to the Commonwealth. All right.
Yeah, good for him. Yeah.
Yeah, good for him. Right. So
it's got paint on it.
They're going to have to buy a new taillight because it has paint on it. Well, so do you have to report that car has been in a collision now to what's a car? What is it? Car,
Oh, to CarMax? Get the car. Yeah.
The CarMax or Carfax or whatever it is. Yeah. Oh, I hear things. I
sound
know you have to
something,
go and do some work.
I think, I'll join you later. I think no would be my short answer to that. No,
Okay,
I would not.
so I'm going to take your last hour and a half since you sub for me.
I'll be listening as I'm working, and
we'll see you at 6. We want to run.
personnel
Oops, here we go.
waiting
We
so
do
that
want
we
to
could
run
have
the
that
clip of
voir
Alessi
dire.
making the motion.
Was
The mistrial
helpful.
early on,
All right,
then go to
so
Dr. Priya Banerjee, and then
my
your person.
rulings
Here we
are
go. Here's the rulings.
very similar that they were this morning. So first of all, on the Darbert analysis regarding Dr. Lope-Sada being able to testify as to the dog bite wounds, I find that she is not qualified. I'm not satisfied that the Darbert requirements have been made.
Oh, bullshit.
Specifically, not just the experience, but the reliability of the methodology she used.
There it is.
And how it was applied. So based on that, she cannot testify to the dog wounds. And I want to take a minute to differentiate this testimony with Dr. Russell's. I found that Dr. Russell was an expert, qualified to testify as to dog bite wounds, mainly from her experience in the ER, coupled with her being an ME. Dr. Lope-Sada does not have that experience. I found that Dr. Russell's methodology was reasonable and was sufficient, and I found that it was appropriately applied. Remember that Dr. Russell was published in the area here. So regarding pages 10 and 11,
this is
all of
ridiculous.
the text on Dr. Lope-Sada's report on pages 10 and 11 that start with the injuries on Mr. O'Keefe's right arm are excluded. Now, moving
And you're allowing
on
a dog person who trains dogs?
Testimony regarding not being consistent with a motor vehicle strike. I find that Dr. Lope-Sada's opinion on these not being the result of a motor vehicle collision exceed what is within her scope of expertise in some regards, not in all. In some regards, significantly, like I said this morning. So on page 17, the first sentence is in. The second sentence, tail lights are typically made of durable polycarbonate or acrylic plastic. That is out. I know the Commonwealth objected to, but I'm letting in. Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting the arm. She cannot say tail light, but she can say that based on her experience. His arm had no tissue bruising from impact. That also comes in. And the next sentence, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. That's within her realm of expertise as a medical examiner. The next page, though, I may have said this morning that first sentence, importantly, in review of that and review of the Tompkins case, that first sentence stays out because to me it seems like that sentence depends on a biomechanical analysis, factors such as speed and force and the position of Mr. O'Keefe. So that's, oh, I'm sorry, page 18, the next page regarding the same subject matter. And portion of the next sentence is also out. This results in bruising or bleeding under the skin. That's out. But Dr. Lope-Sada can testify that Mr. O'Keefe had no bruising on his arms or torso. And that's it for that sentence. In particular, Mr. O'Keefe did not have bruises on his legs as shown by dissection of leg tissue and muscle at autopsy. That's it for that. And the conclusions are problematic to the extent that is
Oh my
consistent with
God.
this ruling and what we
What
discussed
a
on
bullshit
Friday.
ruling.
So that's it. That was just the text of her report. I have not begun to go through all of the, there's no PowerPoint with this, Mr. Jackson, right?
There is no PowerPoint.
All right. Do you intend on displaying any of these photographs?
I'm sorry.
Do you intend on displaying any of the photographs that are in her report?
Yes, I have to go through it now with Procedural and
All right, so you likely not get to that today. We've done important work, but we've
We've
wasted
wasted?
an awful lot of the jurors' time today. So I want to bring them in. And,
my suggestion, we have to finish it anyways.
right, we're going to do that now. So that'll give you an opportunity to pull your thoughts together.
Right, and I expect what I would do is to address the
You know what they should have? This is not a real dabber here because they should have had somebody come in to say, my husband, let's say, for instance, come in to say, this is the methodology that is used, because she didn't have any contradictory methodology from saying this is not an appropriate methodology. She had no expert saying that this was inappropriate methodology.
Okay, so
she had none.
let me know what you
She did it off the
intend
cuff
to
of
put
her.
in.
Let me.
All right, and there's a lot of
arm the
text
defense.
describing the photos that is out, right? It's just hearsay.
We've had Dr. Welch's PowerPoint.
That was not objected to. There's a big difference. So we'll deal with this tomorrow. With the photographs tomorrow. Okay, thank you. And we're bringing the jurors in. Did the Commonwealth want to respond in any way?
Like say thank you.
And there's a motion on Dr. Rentschler. We will give that, I haven't read it yet. We'll give that no more than 5 minutes tomorrow morning each side.
She wants to close
This
on
jury, you
Thursday,
can tell just by looking at this jury, they're fed up.
Well, they're fed up because
You-
of you and because of Hank Brennan, okay? I'm going to have a rant that's going to go up here pretty soon. By the way, we will be posting it.
The defense objection.
Sure.
And I just want to make for the record a quick comment. The Commonwealth waited until June 5th to even bring this up, to file a motion regarding Dr. Lope-Sada. They had a report, and all reciprocal discovery was done in March.
She even testified in a dog bite case in a federal court, okay?
Yeah.
And the Commonwealth was ordered to file whatever motions they wanted to, whatever motions in limine they thought were appropriate by March 7th, and they did not do that. They were supposed to be heard on March 18th.
Okay, so the jurors are coming in. We're going to mark the report and the CV for identification.
I just need to know when I can make it.
You just made it.
I made it-ish. I wasn't
Okay.
sure if it was going to be recorded.
Okay.
But the point is,
Go ahead, real quick.
the point is, the Commonwealth has not explained the delay
So-
in making this motion. They haven't, and we're playing by the same rules, Judge.
So the basis of my ruling was not late disclosure. Okay? Late disclosure. Commonwealth says they're part.
That's not the court's missing the point. It's the opposite.
Wait, the basis of her ruling is late disclosure?
They were objecting. They've had since March to object. They blew the motion in limited time, and then they come in just before Dr.
All right.
Dr. Lope-Sada testifies, and now they're sort of sandbagging this and getting the court moves against this. So I want to make sure that the record is imminently clear.
Very clear. Mr. Brennan, do you want to respond real quickly?
Your Honor, we can always
Late disclosure? Are you?
No, she said it was not.
Oh, I thought she said it was.
And that's consistent with what my
No, 'cause she
rulings
says-
were when
she
I
says that
allowed other
the
witnesses to testify that
he
the
then
defense
said-
could object if the foundation weren't properly laid. So bring
She
them in,
said
please.
that there was an objection, she said that it was late disclosure, the Commonwealth objected, and that's why I gave him a hearing, because he said they had months to ask for a hearing. They didn't ask for a hearing because if this was a true Daubert hearing, you bring in other forensic pathologists to say, this is how we do it in the forensic pathology field. This is what's done. She didn't have anybody to do that. There was no one but Hank Brennan saying, yay,
Yeah, well, she also said that the defense did not object because they made the point, well, this is no different than what the Commonwealth did. But the defense didn't object.
Defense did
And
object.
Jackson said, we did object. And then she just blew right past it.
Right.
So,
They objected
yeah,
all the time. They objected
it's
to the stuff.
railroading. There's no way to explain it or justify it.
Yeah.
It is what we expect. Okay.
And this is where it comes down to, you don't even care whether Commonwealth Reed is guilty or not at this point, because this is unfair. It's unfair to everybody.
Okay.
And then she blames them. I know you have to go.
Okay, they go straight. I just wanted to hear what she's saying.
You can go.
Sorry.
Okay, they're going straight through to 4.
As long as we did today. All right, Ms. Giannetti, is your witness
Okay.
ready?
Check you later.
All right, everybody, you know how I feel about this. We're going to put my rant up on YouTube, and it will be on Twitter. Hopefully, if you see it, you can go to YouTube and get it. And Michael Bryant's assholery, I think that applies to more than one person in the courtroom at this point, but I won't say who. That was outrageous, outrageous, outrageous ruling.
All right, Mr. Tedman, whenever you're ready, sir.
Thank you.
Thank you, Your Honor. Sir, before the lunch break, you had identified 3 entrances to the front of 34 Fairview, leaving aside the 2 garage car doors. Do you recall that?
Yes.
May I have that last exhibit displayed, please? Not that one, the one that we discussed right before. There it is. Maybe zoom in on that a little. Okay. What do you see on the screen at this point, sir?
I see the 2 rightmost entrances to the house, excluding the main front door.
Okay, which would be obviously to the left
To the
of this
left.
photo, particularly with regard to the 3rd entrance, the one in red. Could you describe that?
Yes, so it's if you're facing the house from the street, you're looking towards the west. So that door goes directly into the garage facing north.
Okay, so basically from the street, you don't have to enter the house, you can go into the garage directly.
That is directly into the garage, yes.
All right, and as we're looking at the house from this point, are we looking at it from the vantage point of Fairview Road?
Yes.
And that is a westerly direction toward the house, sir?
Correct.
In the course of doing your further work that you were asked to do in this case, did you peer inside the garage?
Yes, I did.
Did you see concrete steps and a ridge there and a hard concrete floor?
Yes.
Sustained. Jurors disregard that answer.
You mentioned that you were asked to do some measurements. Can you describe what you were asked to do for the jury?
Yes, I was asked to measure from basically the mailbox area of the driveway to the various entrances to the house.
Did you take those measurements?
I did.
Okay, if I'd like to take them one at a time. First, did you measure from the end of the driveway next to the mailbox all the way to the main front door, which is not depicted on this photo?
Yes, I did.
How did you measure it?
I used my wheeled measuring device, and I walked directly across the lawn to the front door, well, to the bottom of the front steps, and then used it to go up the front steps straight to the door.
And what was the measurement, if you recall, from the mailbox area near the end of the driveway to the main front door on the left?
I believe it was 65 feet 9 inches, but I have notes if I
I think you got it right, sir.
Okay.
Next, did you measure from that same location near the street, the end of the driveway next to the mailbox, to the second front door, which is actually depicted in the exhibit that's on the screen?
I did.
And how did you measure that?
I walked along the edge of the driveway on the asphalt, right next to the grass, towards the house from the mailbox and the edge of the street, towards the house. I took a left onto the brick walkway, proceeded along that walkway, then took a right to the walkway that you can see right there, heading directly to the door, and went up onto the little decking area, and then those 2 steps directly to the doorstep.
Okay, so you walked essentially almost the whole length of the driveway?
Yes.
Before you took the left to get to where the steps start, going to that second front door?
Yes.
And then went up to the door itself?
Yes.
Do you recall from your memory what the measurement was?
I believe it was 70 feet 1 inch.
And finally, did you measure from that same end of the driveway near the street next to the mailbox to the red side door, which is the pedestrian entrance into the garage directly?
I did.
How did you measure that?
I did the same thing walking directly from where the mailbox and the driveway intersect, basically, all the way up the driveway, took the same left onto the red brick pathway, took a right to go towards the front door, went up the one step that you can see, and then instead of going up the next 2 steps, I took a right directly towards the garage entry door.
So essentially the same path of travel, it's just you didn't go straight into the second front door. You took a right to go into the pedestrian entrance to the garage.
Correct.
And what was the measurement that you discovered having done that?
I believe it was 78 feet 3 inches.
Now, finally, could we have displayed the map of Cedar Crest, Fairview, and Chapman? There it is. Sir, are you able to see the street names from where you are? And if
Yes.
not, could we have the top street magnified so that the witness can see it? Okay, you see that?
I do.
What do you see that to be?
Cedar Crest Road.
Okay, if we could have the connecting street where the, that's it.
Fairview Road.
All right, and finally, the one down the bottom?
Chapman Street.
Okay, if we can get the whole map back up. Having seen those 3 street names, does that orient you as to the map of?
It does.
And what is that?
This is the surrounding area of 34 Fairview Road, the neighborhood, basically.
Okay, and it includes the 2 connecting streets on either end?
Correct.
Does the red dot symbolize anything for you?
It looks to be where 34 Fairview Road is located.
Okay, and if you're on Fairview Road to the right of that red dot as it exists on that exhibit, and you're looking toward Fairview Road, what direction would you be facing?
I'd be facing west.
If I may have a moment, please.
Okay.
Further questions? Thank you very much, sir.
Thank you.
Questions?
Yes. Good afternoon, sir.
Good afternoon.
You had a wheel to measure,
Correct.
and so there's like a tape measure, and when you wheel it out, it gives a straight line?
No, it's two wheels with a meter in between them, and you roll it out in front of you.
I see. Your first measurement was from the driveway to the front door,
To the main front door to the far left, yes.
and that was about 63 feet?
I believe it was 65 feet, something like that. I have
65?
my notes, yes.
So suffice to say, if you were to leave the front door and come back to that spot, it would be an additional 65 feet back, right?
Yes,
The second measurement was from the bottom of the driveway to the middle door on the side?
yeah, the second front door, yes.
Did you say that was about 70 feet?
It was, yes.
Okay. And again, if you were to come back, that would be an additional 70 feet?
It would.
And the last one was the door near the garage. Did you say that was further, around 80 feet?
78 feet, 3 inches, I believe.
Except one way,
Correct,
and back is another 78 feet.
correct.
When you measured these, was it from the asphalt of the driveway or to the left of the mailbox as you're looking at Fairview?
It was to the right of the mailbox on the asphalt, as close to the mailbox as I could get.
Did you happen to take any measurements from the flagpole to the front door as far as distance?
I did.
And what was that?
I do not have the exact measurements. I'm not sure.
Do you have it in a report that you
I
could look
don't.
at?
I don't. No, not with me.
How about the flagpole to the middle door on the side? Did you take any measurements of that?
I'm not sure I took that one.
How about the flagpole to the furthest away door, which would be the door next to the garage? Did you take any measurements of that?
I think I took a direct measurement to that, yes.
Right. And what was that number?
I don't know.
Do you have a report you can share with us?
I don't. No, I'm sorry.
It's okay. Did you ever measure if you were at the flagpole area, how long it would take to walk up the street? Or how far it would be to walk up the street, up the driveway for any of those doors? Did you ever measure it that way?
I did.
And what was the distance if you were going to start at the flagpole, walk up the street, up the driveway, down the walkway to the front door?
I'm not sure that distance. Not positive the distance.
Was it over 80 feet?
It was.
And if you did the same route up the street, up the driveway, to the middle door, would you agree that would be well over 80 feet as well?
Can you repeat the question? How?
Sure, from the measure from the flagpole, up the street, up the driveway, to the middle door, that would be well over 80 feet?
Yes.
Same to the door next to the garage?
Yes.
Thank you for your time.
Thank you.
All right, you are all set, sir. Thank you very much. Okay, Mr. Jackson.
Thank you, Your Honor. We would ask the court to ask Dr. Elizabeth Lope-Sada to join us.
Okay.
Step up, face the clerk, and raise your right hand, please.
You tell me, sir, the evidence you give to the court and jury in the case now and here, and the truth, the whole truth, and nothing but the truth, so help me God.
I do.
Good afternoon, Doctor.
Good afternoon, Your Honor.
May I inquire?
Yes,
And Dr. Lope-Sada, please speak right into that microphone,
I
okay?
will.
Thank you.
Doctor, can you please state your full name and spell your last name for the jurors?
Yes, Dr. Elizabeth Lope-Sada, spelled L-A-P-O-S-A-T-A.
I'm going to ask you, you have a softer voice. I'm going to ask you to pull that microphone right under your chin, if you don't mind. It's pretty adjustable.
Better?
That's better.
Okay.
That's better. Doctor, can you tell the jurors what you do
Before we
for a
start
living?
on that,
Yes, I'm
remember,
a
with
medical
the private
doctor and I
eye,
subspecialize
Judge
in
Beverly
forensic
wouldn't allow
pathology.
him to talk about the steps.
Can you
and the hit on the
summarize
steps.
your
So,
medical, your
obviously,
professional
that's
background?
what the defense wanted.
Certainly, I graduated in 1975 from Bucknell
try to cut the
University
defense off
with
at
a Bachelor
the
of Science in
proverbial
Biology. I went to University of Maryland School of Medicine, where I graduated
Slow
in
down.
1979
Slow down.
with a
Slow
doctorate in
down.
medicine.
Slow down,
I did
Dr.
my
Lope-Sada.
internship and fellowship at Johns Hopkins Hospital in Baltimore, where I studied anatomic pathology, which is the study of the diseases of the body. I then did my subspecialty fellowship in St. Louis in forensic pathology, which is understanding causes of death and injuries to the body.
Currently, are you a professor?
Yes, I am.
And tell us where you work.
I own my own independent consulting practice, and I'm also an associate professor at Brown University School of Medicine.
How long have you taught at Brown University School of Medicine?
Since 1993.
And how long have you been a clinical associate professor of pathology either at Brown or before that?
Oh, gee, then that would have been since at least in the late 80s. I've been associate professors at the universities and medical schools where I've worked.
Doctor, at Brown University, let's take Brown first. What do you teach there?
I teach the second year medical students. I teach a lecture in diseases of the heart, cardiomyopathy and myocarditis. And I've been asked to give some specialized lectures in toxicology and forensic pathology.
Are you responsible for training medical students in the field of forensic pathology?
When I was a chief medical examiner, yes, we would have medical students, residents, come into the office so they could learn about what we do to understand cause and circumstances of death.
When you first got your medical license, did you then undertake to get certain board certifications and the like?
Yes.
Before we get to those board certifications, did you begin a practice in forensic pathology in some way or another?
After I finished my medical school and my anatomic fellowships and forensic pathology fellowships, then I was working in medical examiners' offices where I was examining deceased people to understand how they died.
When you get a medical license, is that statewide or is it nationwide?
Usually you get a state medical license.
And do you hold a state medical license?
Yes.
How many?
I have an active medical license in Rhode Island where I have my consulting practice, and I have inactive license in Maryland, Delaware, Missouri, Pennsylvania.
And you've been previously, at least before they were inactive, you were licensed in all 5 of those states?
Yes.
You already told us a little bit about your college. Did you mention Bucknell University? Your Bachelor of Science degree?
I think I did, yes.
At some point after you graduated from the University of Maryland School of Medicine, did you complete any residencies?
Yes, I did my residency at, excuse me, at Johns Hopkins Hospital in Baltimore in anatomic pathology.
Forensic pathology is different from anatomic pathology, correct?
Yes.
Did you also do any kind of residency in forensic pathology?
Yes, I did a fellowship in forensic pathology.
And what is the difference between, if you can sort of take us through that little by little, what is the difference between forensic pathology and anatomic pathology?
Anatomic pathology is sort of hospital-based pathology where we understand diseases of patients who are in the hospital and try to make clinical pathologic correlations to see if their diagnoses were correct, if the laboratory tests actually showed what we find at postmortem. And then forensic pathology deals more with understanding why the body stops functioning at a particular time. So that would be cause of death, and that can be sudden unexpected death or death due to violence.
And in forensic pathology, is that often associated with testimony in court cases that may deal with either on the civil side or the criminal side, coming in and testifying about things like cause of death and manner of death?
Yes.
What types of cases did you work on during your forensic pathology residency?
Oh, sudden unexpected natural death, gunshot wounds, knife wounds, sudden infant deaths, blunt force trauma, skeletonized remains, decomposed bodies, strangulation, gamut of ways people can die unnaturally.
And what type, to contrast that, what types of cases did you work on during your anatomic pathology residency?
There you're mainly dealing with natural diseases and understanding heart disease or how somebody gets pneumonia, or looking at the brain to understand if a stroke was present. And that's especially important then to the doctors who are treating those patients, that they can see if the diagnostic tests were appropriate or if their treatments worked.
You mentioned fellowship a little earlier in your testimony. What is a fellowship?
A fellowship is after you've done your internship and residency. A fellowship is more specialized training, and I did that in forensic pathology.
So that answers my next question. You do hold a postgraduate fellowship position, correct?
Yes, yes.
And that was in forensic pathology specifically?
I'm board certified in anatomic and forensic pathology.
Were you a research associate at the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Law?
Yes.
I'm sorry, School of Medicine?
Yes.
Old habits.
Yeah.
What about postdoctoral research fellow? Were you ever a postdoctoral research fellow?
Yes, I did. I had an NIH research grant where I worked on, excuse me, how alcohol affects the heart.
Where was that?
That was at St. Louis University, and then when I was on staff at the hospital of the University of Pennsylvania in Philadelphia.
What about postdoctoral research fellow at dealing with the cardiovascular division of the Department of Medicine at Washington University?
Yes, that's where I did research on how alcohol affects the heart.
Was all this in furtherance of your broad education and training as a pathologist?
Yes.
I think you indicated that you have served as a chief medical examiner in answering one of the previous questions. Can you tell me a little bit about that?
Yes, I was appointed chief medical examiner for the state of Rhode Island in 1993, where I was responsible for all unexpected, unnatural deaths or deaths that involve violence in the state of Rhode Island. So I had to supervise the office, made sure I have adequate staff, made sure my forensic pathology staff were doing a good job, made sure I had an adequate scene investigative staff, so running the whole office.
Is that the highest appointment in the OCME's office?
Yes, it is.
In that position, did you oversee every single medical examiner in the state of Rhode Island?
Yes.
Did you also hold a position as the co-chair of Child Fatality Review Committee in the state of Rhode Island?
Yes, as part of being chief medical examiner.
Tell us a little bit about that. What was that appointment?
Well, there's, a big concern about infants who die and children who die. So those are reviewed specifically by a group of doctors from the pediatricians and also then the medical examiner's office. So we look at every child and infant death.
How long did you serve as the chief medical examiner in the state of Rhode Island?
For 12 years.
Starting when and ending when?
Starting in 1993 and ending in 2005.
As the chief medical examiner for Rhode Island, did you ever have the responsibility to work on any mass disaster cases?
Unfortunately, yes.
Okay, tell us a little bit about that. If you could start with the Egypt Air issue.
Yes. Excuse me, I'm so sorry. In 1999, the Egypt Air 990 took off from New York airport, and it crashed off the coast of Massachusetts, and 2,065 passengers died. And because of the force of the airplane going into the water, all the bodies were fragmented. So all the fragments were brought to my medical examiner's office. They actually vacuumed the ocean floor, and we had 2,600 some fragmented remains from that airplane crash, and that involved working with FBI, TSA to identify those individuals and understand exactly why they died.
What was your role and the role of your staff that you supervised in dealing with those other government agencies, the FBI, the NTSA, other entities, in terms of the fatalities that you did review as a medical examiner or the chief medical examiner of Rhode Island?
Well, I dealt with families from around the globe who had relatives on that flight, and then the FBI was looking into what may have caused the crash. The Egyptian government, who owned the airplane, was also there and interested in understanding what happened. And we were also, tasked with identifying everybody who was on the plane and to see if that matched the passenger manifest list. So were there people on the plane who shouldn't have been on the plane? So that sort of thing.
In terms of matching that manifest, were you the head of the department for the medical examiner's office that was responsible for trying to figure out who was on the plane and match those remains with the individuals that were on the manifest?
Yes, we made the positive forensic identifications and returned the fragmented human remains to their families.
Doctor, did you also deal with the tragic Station nightclub fire?
Yes.
In what capacity did you deal with that?
Again, this was a nightclub that burned down. It burned down very rapidly with a very hot fire, and that was in Rhode Island, and there were 100 fatalities from that. So those come to the medical examiner's office. I had my investigator at the scene throughout that time of recovering the bodies, and I was charged with determining the identity and the cause of death.
Were you successful, or your staff successful, in determining the identity of most of those individuals who perished?
Yes, all of them. We worked around the clock for 3 days to get that done.
And you were the head of that task
was.
force. Before you became the chief medical examiner in Rhode Island, did you previously work as a medical examiner under somebody else?
Yes.
Tell me about that. What was your first post as a assistant medical examiner?
My first post was after I did my fellowship training in St. Louis, Missouri. I was an assistant medical examiner for the city of St. Louis.
Were you ever an assistant medical examiner in Philadelphia.
Yeah, so after St. Louis, I moved to Philadelphia, where I was on staff at the hospital of the University of Pennsylvania, and I ran the autopsy service there at the hospital, and I was also an assistant medical examiner for the city of Philadelphia. After that, I was an assistant medical examiner for the state of Delaware, and then I came to Rhode Island as I was chosen to be chief.
Dr. Lope-Sada, can we put dates on that? Assistant medical examiner in St. Louis from when to when? Do you remember?
Oh my, let's see. May I look at my CV?
Sure, with the court's permission.
Yes. Okay. Yes, from 1983 to 85, I was an assistant medical examiner for the city of St. Louis. Then in 87 to 91, I was the assistant medical examiner for the city of Philadelphia. 91 to 93, assistant medical examiner for the state of Delaware. And then 1993 to 2005, I was chief medical examiner for the state of Rhode Island.
Thank you for that. Dr. Lope-Sada, have you held any faculty positions as in the field of forensic pathology that qualify you as an expert in this case?
Yes, every medical examiner's office I worked in, I also had faculty appointments to teach medical students and pathology residents. So I had faculty appointments at Washington University School of Medicine in St. Louis, at the Hospital University of Pennsylvania, in Philadelphia, and in Rhode Island.
Let's talk about those one at a time. Describe your teaching responsibilities at Brown Medical School, if you wouldn't mind. And that, by the way, that's from 1994 to present, correct?
93 to well, as a medical examiner, it was 1993 to 2005. And there I would teach the medical students. We had rotations through the medical examiner's office, and also the pathology residents would rotate through the medical examiner's office, where I would teach them how to do a medical legal autopsy, how to understand the cause and manner of death, especially non-natural and traumatic deaths.
With regard to your teaching responsibilities specifically, are you still teaching?
I'm teaching in the cardiovascular section now, but since I'm not chief of the medical examiner's office, I obviously don't have students rotating through there anymore.
Were you a lecturer in the role of medical examiner? Did you do a seminar in that regard at or associated with Brown University School of Medicine?
Yes.
Did you do some sort of a forensic pathology rotation for pathology residents from 1994 to 1995 in that capacity as well?
Yes, we would have the pathology residents who were at the hospital studying anatomic pathology come to the medical examiner's office so they could understand the discipline of forensic pathology.
What is cardiomyopathy?
Cardiomyopathy is a muscular disease of the muscles of the heart.
And what is myocarditis?
Inflammation of the heart muscle.
Did you ever teach or lecture on those issues?
Yes, I teach every year. I teach the second-year medical students about those heart diseases.
Have you ever taught anatomy and physiology to EMTs?
Yes.
Or in the EMT setting?
Yes.
And what about a class known as the 2-hour primer on forensic pathology?
I've taught a lot. I don't recall that particular.
How about pathology residents morning conference in 2009?
Oh, yes. I give lectures to the pathology residents at the medical school at Brown Medical School in forensic pathology.
You also mentioned that you were an adjunct professor for biomedical forensic sciences and forensic anthropology in the Department of Anatomy and Neurology. Is that a division of the graduate school, Boston University School of Medicine?
Yes, I taught in the master's program in the medical school at Boston University School of Medicine for a master's in forensic science, where I taught a 40-hour course on forensic pathology and another 40-hour course on medical legal death investigation.
Were you actually the course director in that position?
Yes.
And were you also a course director in medical legal death investigation from 2006 to 2013?
Yes.
And what about a course director in forensic toxicology from 2006 to 2012.
Correct.
Did you direct the studies in biomedical forensic sciences, GMS, from 2012 to present?
Yes.
Describe that. What is that?
The graduate medical sciences.
Correct.
Okay, yeah, I would review and be on the board to examine projects that the students were doing to get a master's degree.
Were you also an assistant professor in the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Medicine?
Yes.
Okay. Without going into every single class that you taught, did you teach from 1987 to 1991, attending staff medical pathology?
Yes.
What is that? Just a general outline of what that teaching course was.
That's when I was at the hospital, the University of Pennsylvania. I ran the autopsy service, so I taught medical students and pathology residents about autopsy practice.
I want to ask you sort of broadly, can you describe your major teaching and clinical responsibilities when you were at University of Pennsylvania School of Medicine in the field of forensic pathology? What were your main clinical and teaching positions?
Well, I ran the autopsy service there, so I taught the medical residents and medical students autopsy pathology, and I was also a assistant medical examiner there, so I taught and started the forensic fellowship in pathology.
Have you ever been qualified as an expert witness in forensic and anatomic pathology in state and federal courts?
Yes.
How many times would you say you've qualified as an expert?
Over 40 years, maybe several hundred.
How about in Massachusetts?
That includes all of them.
Okay. Have you ever qualified? Let me list a couple of states. In Massachusetts?
Yes.
California?
Yes.
Connecticut?
Yes.
Delaware?
Yes.
Florida?
Yes.
Illinois?
Yes.
Maryland?
Yes.
Minnesota?
Yes.
Missouri?
Yes.
New York?
Yes.
Pennsylvania?
Yes.
Rhode Island?
Rhode Island, yes.
Have I left anything out?
Did you say Massachusetts?
I did.
Okay, then
We
you're
started
fine.
with Massachusetts.
Okay, you're fine.
What types of topics have you qualified to testify about as an expert forensic and anatomic pathologist?
Really, anything that has to do with circumstances and cause of death. So it doesn't really matter, what type of injury or a sudden unexpected death. Usually it involves examination, study of information from the scene, information from the autopsy, police and investigation and medical records, and we put that all together and figure out the circumstances as to how someone died and why their body stopped functioning. So that's the basis of forensic pathology.
Dr. Williams, excuse me for just a second. You're on a media approach for one brief.
Okay, he wants to approach for one thing, so that maybe he has a question. Alan has a question about whether he can go into something based on her ruling. By the way, we have put up on my rant about the mistrial ruling. We put up Michael Bryant's new word. Sorry. Okay, 9 letters. All right, it really should be on. What is it? What's the word game? Spin the wheel. What is that word game? I don't ever watch it that you watch. Come on, you can know. Spin the wheel. Was it spin the wheel? All right, to get it. I mean, 9 words, but it's on our X account. So share and share alike. If you like by this channel, please go to our YouTube channel and hit like, share, and notify. And I do have an answer for your question on frostbite. To get frostbite, it's the microscopic changes you're going to see in the tissue. You have to be alive. Your fingers can be frozen after you die, but the changes in the tissue means for frostbite, you have to be alive to get the changes in the tissue that you see under the microscope. Okay, so I just posted that under the Justice Served TV. It's somewheres here. It went past. And also, you do have an answer to your question. Okay, this is absolutely ridiculous that she is not qualified to give an opinion on whether or not something is an impact injury from a bumper or a car or not. This is not this is ridiculous that she can't give an opinion on whether something is from animal activity. This is done all the time by forensic pathologists and forensic anthropologists. They find bones in the woods, right? And there's gnawing marks, or there's clawing marks, and they give an opinion that says that that's animal activity, that's post-mortem animal activity. They give opinions all the time on dead tissue, on dead wounds, all right? Not living wounds, all right? Dr. Marie Russell may see people that are alive. Forensic pathologists see people that are dead. They see the people like the other Dr. Wolfe, from Florida with the gamma ray surgery, who sees live tissue. But the forensic pathologist sees all the people that had brain injuries and then die. The forensic pathologist sees the animal activity. They see it on the bones. They see it on the skin. They see it. And for this medical examiner to rule that she is not qualified after she has seen, what did she say? She had 50 of her own cases, right? She's testified in the federal court in Springfield in one. She had 75 more she supervised. That's exactly what you see. Plus, oh, yes, you've got Michael Bryant's word. I see. Yes, that's what it is. To rule her that she is not qualified is outrageous. To rule that you can't say there's an impact injury, or there's an impact injury consistent with a bumper, especially if you have the measurements, is ridiculous. And the PI can't say that he saw something on the step coming from the garage. That's what the defense wanted. This judge has her hands on the wheels of the scales of justice. I'm saying it right now. I didn't believe it when I first started. I do believe it now. I think she should be sitting with the defense team. It's outrageous. She's more concerned about time. What does she have, a vacation plan that she's got to get to? I don't know, but I'm not really happy about it. And I'm saying this as a journalist, not as a lawyer, because as a lawyer, I can't criticize her. But as a journalist, I can criticize her. So as a journalist, I am criticizing her right now, okay? It's terrible. I mean, it's you've all seen it. And of course, those who want Karen Read convicted think that she is wonderful. Okay, think that she is wonderful. So what is going on right now? So that little "can we see you a second" is ridiculous. And then I did, when we post our rant about the instructions she gave after Hank Brennan again, was mistaken for the third time in something very serious. He knew those cutting wounds are usually, they're not just like a little, they don't do like a stab, like a medical examiner or like a knife does. They cut. And they make little X's, and they make usually the cuttings are in X's, right? Anyone who's seen a cutting for a DNA or some other type of cutting for looking for trace evidence, all right? Hank Brennan knew that. I'm sorry, Hank, you knew that. Come on the air with here and tell me you didn't know your case. You knew every portion of every case, but you didn't know those were cuttings for DNA. Give me a break, especially in light of the fact you talked about DNA and cuttings just last week. Mistakenly, you said, no, not mistakenly, when they hadn't even been introduced by you yet. So you looked at that evidence. There's no doubt in my mind, okay? No doubt in my mind. I think this whole day has been a disaster for the prosecution. I think the defense, quite frankly, is going to try to do as best they can to take advantage of it. And I hope the jury has a wind of this. I really do. For the first time in my life, I just hope this jury has a wind of this, that they see the unfairness that's going on, that the scales of justice are not evil, but Judge Beverly Cannoni and the state of Massachusetts, the Commonwealth, has their whole hand, foot, and body on it. Let's go back into court.
Testified about it as an expert in several different states, several different courtrooms. Have you been qualified as an expert by those courts in those topics about which you just discussed?
Yes.
Do you hold any specialty certifications in the field of forensic pathology?
Well, I'm board certified in forensic pathology.
What about the American Board of Pathology?
That's a big deal. There's only about
the American
500
Board of Pathology,
pathologists board certified in the whole United States.
Puts forth examinations that are a 2-day examination in the various disciplines of pathology. And if you successfully complete those examinations, then you become a diplomat of the American Board of Pathology in whichever subspecialty you're in. And I became a diplomat in the subspecialty of anatomic and forensic pathology.
What about a certification in basic bloodstain pattern analysis, the International Association of Identification?
Yes, I had a week-long course in understanding blood pattern analysis.
Can you tell us a little bit about the National Registry Emergency Medical Technician certification that you hold?
Yes, I took training to become an EMT.
Have you received a number of honors and awards in the field of forensic pathology?
I have.
What do those awards include?
May I look at my CV again?
While she's looking, you know, see this shirt? This is the cropped piece, justice served. I'm thinking on this trial, I should say, Karen Reed, justice denied. I mean, I should make it one special T-shirt, justice served or justice denied, because, you know, the point is that the prosecution has to prove the case beyond a reasonable doubt
teaching
with good
awards
evidence, not with
from
what we're seeing today.
Brown
That's
University
the
School of
important lesson.
Medicine. I was featured in a book by Faces of Public Health as having run a good medical examiner's office. I was nominated for Woman of the Year in Rhode Island for my work as chief medical examiner in improving the office and handling those two mass disasters. I was honored by Victims' Rights and Services Awards because I've always been aware of the fact that as a forensic pathologist, I am the last doctor this person is going to have, so I try to help the family understand what happened. I was honored for my work in the mass disaster in Egypt Air 990 plane crash. Let's see. I was Outstanding Woman in Public Service for Providence, Rhode Island. I've gotten teaching awards from Brown University School of Medicine. I was elected to the Board of Trustees in the Delaware SIDS Foundation and the Philadelphia SIDS Foundation. And then we're back to my medical school.
If you could pull the microphone a little closer to your chin.
It's very hard because the chair doesn't push it.
Oh, the chair doesn't move. Okay.
Oh, I got it. I moved.
We'll make do.
Okay.
Thank you, Dr. Lope-Sada. What is the American Academy of Forensic Sciences?
That's one of our
I'm a member of that. I'm a diplomat of that also.
medical associations that is specific to forensic sciences.
Have you ever held a chaired position there?
Yes.
What position was that?
I was voted into a fellowship position.
Were
I'm
you
a
the chairman
diplomat
of
of that
Forensic
in the
Science
legal
Research,
section.
the Forensic Science Research Committee?
Yes.
What's the National Association of Medical Examiners?
It's also called NAME. It's another international association of forensic pathologists.
Were you a member of that organization?
Yes.
And at some point, did you get elected to the board of directors for that organization?
Yes,
And ultimately, did you become a fellow for that organization?
I did.
What is the American Society of Clinical Pathologists?
That's a society that is for people who practice anatomic pathology and understand how to interpret laboratory results and biopsies.
Did you become a fellow in 1991 until present for that organization?
Yes.
What's the difference between a member and a fellow?
A member is a lower level, and then you can be promoted to fellow if the board of directors feels that you've contributed in your field.
And were you associated with the College of American Pathologists?
Yes.
Are you a fellow there as well?
Yes.
What about the World Association for Medical Law?
Yes.
What about the American Association for Clinical Chemistry?
Yes, I'm a member.
Rhode Island Medical Women's Association, what is that?
Well, it's basically what it says. It's women doctors in Rhode Island.
Were you elected to the board of directors for that organization?
Yes,
Ultimately, were you elected as the president of that organization?
I was.
Rhode Island Medical Society, what is that?
It's an organization of doctors who practice in Rhode Island.
Are you a council member there?
Yes.
And what about the Massachusetts Medical Legal Society?
Yes, I was a member there. They have disbanded since.
It doesn't exist anymore?
No.
When it was up and running, you were a member in good standing?
Yes.
Good, good. Pennsylvania Association of Pathologists, what about that?
Yes, when I practiced in Pennsylvania, I was a member of that organization.
Did you, in addition to be a member there, did you also hold a chaired position? Were you the chairman for the Committee on Forensic Pathology?
Yes.
Have you served on any editorial boards of any scholarly journals or
Yes.
publications? Tell me about that.
I've reviewed articles submitted for the Journal of Forensic Sciences and the National Association of Medical Examiner Journals.
Did you also hold an editorial position for the American Journal of Forensic Medicine and Pathology?
Yes.
Is that one of the medical journals that is used throughout the country by other medical professionals, other medical examiners?
Yes.
It's a resource?
Yes.
And a text?
Correct.
Have you authored any peer-reviewed publications in the field of forensic pathology?
Yes, I have.
Can you tell us about some of those publications?
Let's see if I go here. Yeah, I've written chapters in textbooks about medical legal death investigation and forensic pathology. I've published articles involving alcohol metabolism, some drugs, cocaine, let's see, alcohol metabolism in the heart I mentioned. Let's see. And so I published 22 papers, and I've written several chapters.
You already said that you're board certified, double board certified in anatomic and forensic pathology. Is that correct?
Yes.
Now that you've gone through your education, training, background, publications, teaching positions, and chairs that you've held, I want to ask you a really simple question. What does a forensic pathologist do?
Yeah. We are the last doctor that the dead person has, and we figure out what happened to the body to cause their death. And we sign the death certificate that says how the body came to die and also indicates the circumstances under which the death occurred.
Are medical examiners also tasked with determining both manner and cause, not just one or the other?
Both, yes.
What is the manner of death and how is it distinguished from the cause of death?
The cause of death is what happens to the body to cause it to stop functioning. And the manner of death refers to circumstances under which the death occurred. So there's hundreds of thousands of causes of death or why the body stops functioning, but there's only a few manners of death, which would be natural, accident, suicide, homicide, or undetermined.
Those 5 main categories of manner of death, is that the responsibility or one of the responsibilities of a forensic medical examiner to determine that the death fits into one of those 5 categories?
Correct.
What does it mean when the death is deemed undetermined?
Now, when the manner of death is undetermined, that means at the time the death certificate was signed, there was not enough information to put it into either accident, natural suicide, or homicide. So at the time the death certificate was signed, there was not enough information to put it into one of those other categories. It doesn't mean that if more investigation takes place, then you might be able to put it in one of those other categories.
If a manner of death is deemed at a particular time undetermined, at that time, it's because it lacks sufficient additional information. Is that correct?
Sustained.
What types of information does a medical examiner, a forensic pathologist consider in making these determinations between natural, accident, homicide, suicide, undetermined?
Well, first you have the findings from the examination of the body. So that's sort of a starting place to see what happened to the body. Then you need to also look at the scene investigation. You need to look at any police reports and witness statements, and also medical history of the deceased. And using those 4 sources of information, and using your training and experience, you can either say this is a natural death, this is a self-inflicted death, it's a suicide, it's an accidental death, it's a homicide, or if all that information doesn't allow you to put to a reasonable degree of medical certainty into any one of those categories, then you have to leave the manner undetermined. And if more information becomes available later, then you can change that death certificate.
What if no more information comes available later?
It just stays as undetermined. There are cases where there's just not enough information to put it in one of those other categories.
Without getting into what they may be, did you reach any opinions and conclusions in connection with this case?
Yes.
What materials and information did you consider in reaching your opinions and conclusions in this particular case?
Yes. I have my list of materials I reviewed. I reviewed Mr. O'Keefe's autopsy report, the report of the examination of his brain, the toxicology report, and the entire medical examiner file. I studied 100 and some autopsy photos, including photographs of the brain, and then there were 70 other photographs at autopsy taken by a state trooper who was at the examination. I reviewed Mr. O'Keefe's medical records from Good Samaritan Medical Center and the EMS run sheet. I reviewed photographs of Mr. O'Keefe's clothes that were taken at the crime lab. I reviewed photographs of pieces of tail light, hard plastic, clear, black, red. I reviewed photographs of the outside of Karen Reed's SUV. I reviewed the Canton Police Department incident report on the death. I reviewed 100 and some photographs taken by Canton Police of the outside of the house at 34 Fairview Road in Canton. I reviewed some photographs taken by the real estate agent who was going to sell the house of the inside.
In total, putting them in categories, did you review the forensic autopsy?
Yes.
Did you review all of the files associated with the medical examiner's office in this particular case related to the autopsy of John O'Keefe?
Yes.
Did you review the scene investigation through police reports and other things?
Yes.
Photographs as well?
Yes.
Did you review the police reports that were associated with the initial investigation in this case as well as follow-ups?
Yes.
Did you review witness statements and things of that sort?
Yes, if they were included in the police report.
That was my next question. Those witness statements would be included in the police reports that you otherwise reviewed, correct?
Yes.
What about Mr. O'Keefe's medical history as much as you had of it?
Yes, I reviewed his medical history.
And what about hospital records?
His medical history was in the hospital records.
Understood. What method did you use or methodology did you use in forming the opinion that we'll get to in just a few minutes?
Well, in order to arrive at a conclusion of how somebody dies and what the cause of death is, we have to put all our facts out, and then we say, how could these facts have come to be? So it's called like a differential diagnosis. So like if you go to your doctor and you have a white blood cell count, then the doctor would say, well, how many ways do you get this white blood cell count? So that's a differential diagnosis, and then you go from that list and pare it down by getting more data till you come to one final diagnosis. So that's the process of determining how somebody dies and the circumstance around it.
Is it fair to say that you have a pretty significant background, training, and experience regarding coming to the conclusion of cause and manner of death?
40 plus years.
And how many autopsies in total?
Well, myself, I've probably done over 3,000, and then I have observed and reviewed maybe 7,000 more.
So that's in total over 10,000 autopsies if you were to estimate over 40 years?
Probably.
In addition to just autopsies, how many death investigations, separate and apart from autopsies, have you been involved with?
Well, the autopsy usually has a corresponding death investigation with it.
Do you have experience in examining, identifying wounds, not necessarily the cause and manner of death, but wounds that are associated with someone on whom you're performing an autopsy or you're supervising an autopsy?
Yes, so looking at the injuries on the body and understanding what caused them is a huge part of forensic pathology.
Have you ever conducted or overseen any autopsies of individuals involved in vehicle-pedestrian collisions?
Yes,
How many times, if you had to estimate?
no, hundreds.
100 or hundreds?
Hundreds.
When was it that you first started training on the issue of wound pattern recognition that helps assist you with coming to your conclusions, whether it be auto pedestrian incidents or otherwise?
Yeah, well, understanding wound patterns and injuries is a big part of forensic pathology because we want to identify what caused a particular pattern. So understanding that whole complex bag of injuries begins when you start your forensic pathology training, which was when I started back in '81.
In addition to the cause of death, which might be whatever, a gunshot, something, does the pathologist also undertake an examination of the rest of the body that's not so obvious, other wounds, etc., that might tell a more defined story?
Yes, we look at the entire body, we look at the clothing, we look at the outside of the body, then we do the internal examination in order to understand not only why the body stopped functioning, which is the cause of death, but also things that could have contributed to it or helped to understand the circumstances around how that death occurred.
When you say the body, you mentioned the clothing. Why is the clothing important? Is that part of the body for a forensic medical examiner?
Oh, yes, it is. You always have to look at the clothing because it has materials on it that may be important as to how injuries occurred. So it's every time you do an autopsy, you have to always make sure you have the clothing. Many times it would have been taken off at the hospital, but then I would always ask my staff, tell the police, we've got to get the clothes, have to look at the clothes.
What is a gross examination?
A gross examination is not actually like grotesque, but it means like without microscopes. It means just looking with your naked eye.
Is it important to look at a body, a deceased person, when you're conducting an autopsy from head to toe for outside obvious wounds that you can see on the gross anatomy outside?
Oh, yes, and also to collect any trace evidence that may be present on the body.
Are forensic medical examiners trained to do that?
Oh, yes.
Are you trained to do that?
Absolutely.
In addition to a gross examination on the outside of the body, is it also important to look on the inside of the body?
Yes.
Are there wounds and injuries that might be hidden by the dermis, for instance, the skin, that might not be so obvious on a gross examination of a body?
Yes, you have to look inside the body.
And what's the mechanism of doing that?
Excuse me. We make surgical incisions in the body so we can examine the brain, the neck, all the organs in the chest, all the organs in the abdomen, and depending on the case, we may make incisions in the arms and legs to look for evidence of injuries.
What about x-rays? Are x-rays an important part of an examination in an autopsy?
Yes, they're usually done before the autopsy is started, and we look for changes in the bones or any foreign material that might be present in the body, like a bullet.
Dr. Lope-Sada, have you ever exercised wound pattern recognition in your position as a forensic pathologist? Or do you do it every time?
Oh, all the time.
Have you ever taught any courses or given lectures on wound identification and wound pattern recognition?
Yes, it's part of understanding blunt force trauma, sharp force trauma, gunshot wounds. They all make injury patterns on the body that the pathologist can then relate to what caused that injury.
With regard to the case that's before us, what injuries did you observe with regard to Mr. O'Keefe's head, specifically?
I observed that he had evidence of blunt force trauma to the back of his head.
Are those injuries consistent with a particular type or pattern of patterned injury?
Yes.
Describe that for us, please.
They're in the back of his head, a little bit to the right-hand side, was a horizontal tearing of the scalp, and that's called a laceration. And surrounding that were linear scrapes that were vertical in orientation. So that is an injury pattern. And then you have to think, well, what could cause that injury pattern? And so then you go from there.
Did you also, in addition to looking at, by the way, how did you make that assessment about the injury? Was it photographs?
Yes.
Is that a normal way for forensic pathologists to make an assessment? Is that an acceptable methodology to make an assessment of a wound pattern by the use of anatomical photographs?
Oh, absolutely.
Have you done it before?
Oh, hundreds of times.
What is a coup, contra coup injury?
Oh, it's a very interesting, peculiar injury to the head. When you have a blow to the head, the blow can either be the stationary head and there's a blow to it, or you can have the head that's moving and gets the blow. So looking at a pattern of coup, contra coup helps the forensic pathologist differentiate that. A coup, contra coup injury examines the coup, which is where the impact occurred, and then we look at what's 180 degrees opposite that impact, and that's called the contra coup, or like opposite the coup. And that injury pattern helps us determine whether a person was just having a fixed head and somebody hit it, or whether the head was just standing and went down to the ground. The coup, contra coup of a falling or being pushed backward has injury patterns where the impact occurred, but then there's also injury patterns 180 degrees opposite from that. And that happens because the brain is floating in cerebral spinal fluid, and when the head comes down, the brain is a little bit behind, so you get the bang on the back of the head, but then because the brain is floating, it hits the inside of the opposite side of the head. And so that makes the contra coup pattern, and that tells us that there's been a fall backwards and hitting the head.
Is that consistent, a coup contra, just in general, a coup contra coup injury, consistent with a linear acceleration of the head by a fall, an unbroken fall straight back?
Correct. There's also some angular force in that as well.
Understood. In order to determine whether or not Mr. O'Keefe suffered from a coup contra coup injury, can that be done by a gross examination, or does it have to be surgical?
We would look at, well, first we look at the outside, but then we have to look at injuries to the scalp, and we look at the skull, see where the skull fractures are, and in particular to look at the brain and see where the damage is to the brain. And there should, in a fall backwards, you have damage to the brain at the site of impact, but you also have damage to the brain 180 degrees opposite from that. And that tells you it's a fall backwards.
In the case before us, dealing with John O'Keefe, were you able to look at the scalp and the injuries associated with the scalp from a gross perspective?
Yes.
Were you also able to look at the skull and possible fractures that Mr. O'Keefe suffered on his skull?
Yes.
And what about the brain? Did you have evidence of a dissection such that you could see the brain and determine whether or not there was a coup contra coup injury associated with the brain?
Yes, I had a full examination of the brain available.
Were Mr. O'Keefe's head injuries consistent with a coup contra coup injury?
Yes.
Could you describe that, specifically his head injuries, to the jurors, please?
Well, as we say, he has a pattern head injury on the back of his scalp, where there is a tearing of the scalp, and then vertically above that, there is some little areas of scraping to the skin. So that tells me that Mr. O'Keefe went backwards onto something that had a little ridge, but it also had some irregularity to it to cause the different scrapes before you get to the tearing of the scalp. Then when we look at the skull, he had a massive skull fractures that started in the back of his head. They came around to the front. They went under the base of his brain, under the skull, under the base of the brain, and it came into the front of the skull at the orbital plates and fractured that. and that caused some bleeding in his upper eyelids. When the brain was examined inside the brain, I could see that the brain had become swollen and parts of it had herniated or moved down the area where the spinal cord is, and that's called brainstem herniation, and that is why the brain stops functioning and why your body stops functioning when you have a severe head injury.
You indicated that the wound pattern suggested a ridge or ledged surface.
Yes.
Could you explain that in more detail, please?
Yes. So if I were looking at it, I would see the break in the scalp. Then I would see several sort of irregularly placed scrapes of the skin that kind of look like pencil marks. And so that means that something with granularity he hit first, then it moved up a little, broke the scalp, and then moved on a little bit above that.
Would you expect to see that if Mr. O'Keefe had fallen backward onto a perfectly flat surface?
No, it has to be a surface that has some small ridges in it to make those little vertical patterns.
Dr. Lope-Sada, what is ecchymosis?
Ecchymosis is a medical term for bruise.
Did you see any ecchymosis on Mr. O'Keefe that he suffered as a result of the Coup contra Coup injury to the back of his head?
He had a bruise on his brain at the back of the brain and at the front of the brain.
What would the outer let me rephrase that.
Yeah.
What would you see around his eyes regarding ecchymosis?
Yes, when you have when the brain slaps forcefully against the base of the skull, the delicate bones above the eye break, and that's again the coup contra coup, where the brain slaps forward, and when those delicate bones are broken, there's bleeding, and that bleeding then goes right down into the upper eyelids, so it kind of looks like you have black eyes, but there's not been any punch to the face. It's only come from the skull fracture. That's sometimes called raccoon eyes because you look like a little raccoon.
Did you see any skin injury to either one of Mr. O'Keefe's upper eyelids?
Yes, he had a small kind of slit-like defect horizontal on his right upper eyelid.
Would the ecchymosis on its own produce that type of injury, that laceration over his right eye?
No, the blood seeping down into his upper eyelids was from the skull fractures.
Was the laceration above his eyelid on the right side a separate injury altogether?
Yes, it was.
Based on your training experience, do you have an opinion as to whether or not what that eyelid laceration might be consistent with?
Some application of force which broke the skin.
Could that be from an object?
Possible.
Could it be from a fist?
Possible.
Sustain us to the floor, Mr. Jackson.
Give me some possibilities of what might cause that laceration above his right eyelid.
So it's not possibilities.
Give me, in your opinion, what you believe could have caused or produced the injury to the upper right eyelid.
So I'm going to see you at Sidebahhh here.
Well, hold on a second. Let me get you. I think I'm on. I must have taken myself. No, I'm on the stage. Apparently I'm not on your screen. Can you hear me even though I'm not on your screen? They hear me. Okay, so you hear me. So I'm going to talk whether you see me or not. I mean, I don't know how many times in different ways Alan Jackson could ask that question. He's trying to go through, normally preliminaries, you can give the doctor something, but then he says, give me some examples of what may have caused the injury on the eyelid. And when he does that, there's an objection. You can't give possibilities. You can't give probabilities. You can't suggest things to the medical examiner. How is she supposed to testify by Mind meld? I mean, I can't do it here. Mind meld? Is that how she's supposed to testify? Oh, I'm on. Isn't that interesting? I don't see me. But is she supposed to do mind meld here? Is that what's supposed to be happening? I mean, this is again ridiculous. All right. Can the defense file another motion for recusal? Don't you believe me? Don't you wish they could? Yes, though they can't. Well, they could, but they're not. It's not going to win. She already doesn't like them because they filed one motion for recusal. She already doesn't like them because she wants to say they lied to him. She already doesn't like them because they went to the Supreme Court of Massachusetts. They went to the United States Supreme Court on the issue of double jeopardy. She already doesn't like them. She wants, in my opinion, a conviction to show she was right on all these other things, okay? And it's wrong. She is acting wrong. I mean, this is unfair. I think Judge Paige Whitaker, the judge that we had in ASAP Rocky, they should come and try this case. They should come and be the judges on this case. Maybe she needs to take lessons from how you are a fair judge, all right? You want a conviction on Karen Reed, Commonwealth? Well, I'll tell you what, I understand what's gone wrong here now. As we told you, we came into this case thinking that we were objective, which we were, prove it beyond a reasonable doubt. But now we're like, we don't care. This is so unfair, so unfair. All right, let's go back into court and let's listen. I'm going to bring the Tubi avatar back up.
May I inquire?
After that,
Thank you. Dr.
we'll be
Lope-Sada,
okay.
you just mentioned that the laceration above the right eyelid was consistent with the application of force, correct?
Correct.
You said it could come from some object, is that right?
Correct. It was fairly small. It's some sort of object.
Is it also consistent with a fist?
Sure, a fist is an object.
Okay. Your Honor, at this point, I hate to do this again. May we approach?
AJ got in what he wanted to get in.
This is probably a good time. We talked about it at Sidebahhh.
Can you do anything to fill up the jury's time for the next 10 minutes and then we can do this?
Not without what we discussed at Sidebahhh.
The jury's time for the next 10 minutes. I mean, you wasted all time wanting a voir dire.
Both of you, come on up quickly.
You wasted, Judge, all the time wanting a voir dire. You are the one who wanted the voir dire on Dr. Lope-Sada this morning. I'm going to need a voir dire. She only did 50 cases, all right, or 5 cases. You wanted a voir dire. As Alan Jackson said, there was no notice here. They've had her on the witness list for months. They never asked for a Daubert hearing in Lanigan. And all of a sudden, Judge wants a Daubert hearing, and not just an in limine. She makes it a whole Daubert Lanigan without the ability of the defense to bring in other forensic pathologists to talk about methodology, without any notice. It's wrong. It's a whole. Let's hear what she says now.
You show up a half hour later than you normally do because I expect to have 10 minutes with the lawyers, but we see sometimes with 10 minutes naturally in the course of any.
You know what she should have done? She had the attorney show up a half an hour earlier. That's what we did in Aaron Hernandez. If we came, we showed up earlier, not later. If you don't want to work an extra half an hour earlier, I guess that goes to the overtime if they don't want to pay.
Tomorrow morning. Tomorrow will be a full day, and we will make every effort that it's filled with as much time here in court for you without Sidebahhh conferences, without delays for us to have hearings. So tomorrow, plan on a full day. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you have.
That's right. That's exactly what she's implying, LCB, that this is not important. The defense needs to hurry up, right? All the time. How long are you going to be? Never to Brennan. They need to object again to say that she's doing this in front of every time she says how long you're going to be, that this is in front of the jury and this is in bad faith and this puts their client in a bad look to the jury. And it's cumulative and it's been constant and it's been outrageous. I mean, everybody should take the transcripts on that team and go through how many times she's asked, how long are you going to be, how much time this is going to take, when the defense is up. She never asked when the prosecutor's up. Now, for me, I'm missing again, by the way, but apparently you can all see me, right? We're having a little wonky stuff going on here, even with the feed and with StreamYard and all. But I know that I'm talking to you. Now, let's hear what they're going to talk about here.
All right. So can you argue the Commonwealth's motion that I received this morning regarding Dr. Rentschler? Can we just do that now? Okay.
The motion of Dr. Rentschler is they want to remove a lot of the PowerPoints.
First thing at 9 o'clock tomorrow morning. The basis of the Commonwealth's, I've read the motion. I think the motion is clear. I'll hear you both tomorrow on it. All right. And you'll take care of the photographs whatever photographs in her report you intend to put in.
Is the court hasn't made an order yet, but it seemed like the court was leaning toward not allowing any text on the photographs.
See, this is what's wrong. She's blaming the defense on this.
I had not.
The prosecution has had this, right?
Content.
Today
the
they
text
object?
part for the arguments for today, the arguments that were brought up today. I wasn't anticipating everything that we heard today on this, so it took a while. I did not
that's
get
because
to look at
you-
specifically those.
you were the one
but
that
to the
caused it.
extent that it's hearsay, whether it considers anything about dogs, clearly the dog, things that have been excluded have to come out of the photographs. All right.
The other photos deal with Patrick because
I think those have been shown, and I know the Wisniewski spots one is in evidence.
I think the defense has to go
brain
back and a medical
photographs
examiner-
are not coming in. The brain photographs that are different than what's already, the brain photographs in this, in her report.
What? What are we talking about?
They're-
the stomach lining is a bigger issue than some.
In other words, if the state didn't put them in, they don't come in, even if they're the forensic pathologist, medical examiner's photos? You know, you can crop
so
it
tell
out
me
and
what you
see
think
an
is more of an
area.
issue, more of what you want. So I don't think the photographs on pages 4 or 5 come in. They don't add anything, and they are extremely inflammatory.
I'm not looking to enter
You know, normally it's the defense that argues things are
All right, the
inflammatory, not
photos
the
on page
prosecutor, not the
6, I
judge
believe,
on her
are
own.
already in evidence.
And inflammatory goes to prejudice for the defense, not the judge.
So this is,
that's a Lucas machine.
right, just a textbook photo of a Lucas machine.
Correct.
Is there an objection to that, Mr. Brennan?
No, thank you.
Okay. So do you want all of that in, or just the photograph that's got color to it?
I'd actually like all of it. She will explain what effect it has on the pancreas and stomach lining, send it to the Wisniewski spots for lack thereof.
Okay.
Page 14, I think these are all in evidence otherwise, but I would like this particular, it's all in one spot.
Hold on 1 second. Okay, so 1 is in. Point number 1, that was in evidence, and those 2 photographs. This is all for number 1. What was?
These are all close-ups of the same photo that is already in evidence.
Okay.
The right sleeve. So I'd like to use this because it speaks to her evaluation of these particular.
All right. How does she know it's blood staining on the fabric around the puncture? I'm just curious.
The blood stain on fabric around the puncture.
Yes.
I'm assuming she's getting that from the lab. They tested it.
Okay. I don't recall testimony regarding. Doesn't mean it didn't happen. I just don't recall it. So I just need to know
Oh, I'm sorry.
the source.
If
All right.
she's relying on the report she got, but now there has to be lab testimony, that didn't apply for Hank Brennan, did it, on
Okay.
DNA?
13A and 13B? Yep, so 13B's out because of the dog bite. Let me see. All right. So if we
It's
keep out the
outrageous
blood
that she
staining,
can't testify as
Mr.
to
Brennan, is there an
animal activity
objection?
on the body. Because
Oh,
forensic
puncture. What's the objection for the
pathologists
Commonwealth on
and,
13A?
Forensic anthropologists do that all the time. And yet she's going to allow some guy who got a certification as an animal behavioralist testify in rebuttal for the prosecution? Are you kidding me?
Okay, so we're going to have to see if she's qualified to do that, to testify to that. All right. What's the next page?
Well, you know the answer. Whatever she says that, you know the answer is she's going to rule her unqualified to testify about the staining on the fabric being blood from the lab, which reported it as blood.
What page?
Page 5.
Page 5. It shows the cross-section of the brainstem.
That's what I was saying. I didn't see how that was coming in.
I certainly don't want the one in that is sculpted. This is no more graphic than the second one.
I think they're appointed in Massachusetts, so I don't know the
disagree,
answer to that.
but,
If they're elected, you can, but I don't
Why
know
does
the
she have
answer
to
in
use this
Massachusetts.
photograph?
It furthers
Yeah,
her
Tuesday, Google it. Let us know.
imagery and supports that. I didn't put it in during that conversation.
Okay. There's no contention that coup contra coup is the cause of the brain injury, correct?
There is contention that the coup contra coup is, yes, that is the contention. I don't think there's any controversy. That's what the.
I thought that's what Dr. Wolfe testified to, no?
Oh, so you, wait a second. If Dr. Wolfe testified, we can't now dispute it?
So I don't know why we need this photograph.
Because this shows, at least for her, this shows a bleeding of the brainstem, which talks about whether or not he's immediately incapacitated or not immediately incapacitated. which is
Okay.
an issue that Dr.
No, I understand that's an issue. Okay,
It is an issue.
yeah.
I guess if Hank says it's an issue, it's an issue. Now she doesn't want the, you know, you can crop the photographs down, make them black and white, and just crop them to a specific area so you don't
What
see
else,
the whole
Mr.
thing.
Jackson?
I think you've seen this, Your Honor, and I'm looking at
What? Wait a second. Court TV is best New Yorker? Wait a second. No, we're best.
Yeah, I
We're
think
best.
that's already in evidence, isn't it?
It is, but not the, Mr. Leslie's saying it's only.
It's hard to hear because they're not on their mics.
I recall it was up, and I usually don't put up chalks, but okay. Excuse me?
Mr. Lessie. Can you say it again? Thanks.
There's only one person who can talk at a time. I'm told it's Exhibit 164.
Yes, Your Honor, and my understanding is it's marked as an exhibit only. It was used as chalk, but not in evidence.
Okay, so if it's marked as an exhibit, it means it's in evidence.
Sorry, marked for identification.
I'm told I think it's an exhibit. We can find out. If it's an exhibit, everybody's fine with it. It's in. 164, I think.
It's hard
We'll
to hear
know.
what they're complaining about because we don't have the report, so we don't know what the exhibit is, and
What
they're
are
not on the
those?
mic, so we can't hear them. That's why I've been answering questions.
All right, so we'll have to see what's in and what's not. I'm just trying to make the best use of the time here.
I'm sure you are. Who regulates the judges? It depends on the states. I don't know in Massachusetts if there's a judicial commission or not. In New Jersey, there'd be a judicial ethics commission who regulates.
So you're saying 9 in evidence or 9 on the form?
People that there is a commission too.
9A and B.
That regulates local
Is there an
judges,
objection
and
to
then
these,
other judges are voted in or
Mr.
voted
Brennan?
out. So you'd have to look to see. in
Going to the
Massachusetts,
Lucas
I don't know.
compression device. On someone who's not John O'Keefe, and then this is on Mr. O'Keefe.
No objection.
Okay, so those will come in.
That's it.
Okay. All right. How much longer, and I'm not curbing you in any way, how much
Oh,
longer
sure
do
you
you
are.
think? It seems like after the very lengthy qualifications, we're now moving along quicker with Dr. Lope-Sada.
I would guess I probably even finish.
Yeah, since you've taken away everything she's going to
Any
testify
idea,
to.
Mr. Brennan?
I guess it'll probably be about a half hour.
Okay.
That's all?
So
Is
we
that
should
quicker than a half
finish with
hour?
Dr. Lope-Sada's testimony either by the morning break or shortly thereafter. So we'll discuss Dr. Rentschler's testimony, the objections to it. Why don't you just tell me briefly, Mr. Brennan, what the objections are?
There are a number of slides that attempt to frame what the contested issues are in the case to improper opinions that assumes facts, not evidence, and improperly summarizes the Commonwealth position. There are a number of slides that provide credibility determinations about Dr. Welcher, and there are a number of slides that summarize opinions by this expert. So the improper summaries, the credibility determinations, trying to frame issues to the jury, none of that should be admissible as part of the PowerPoint. So we've articulated each slide and what our objections are to each slide that we have any objections to. There's quite a few.
All right, so I'll look through that tonight, but the same restrictions will be, you don't criticize the person, it's the data, what you saw, what you didn't see. So if it's different than that in the slides, it's going to have to come out.
Understood. I'll take a closer look at it. I just haven't had a chance.
Yeah, no, I understand. I haven't read it either.
If we're done.
Okay.
4 documents. These are documents that are intended to Dr. Lope-Sada's opinion and conclusions concerning the dog bites.
Okay, so,
I'd like to have those identified for the record.
yes. So we'll make that part of the record. I need a clean copy of Dr. Lope-Sada's report and her resume for the same purpose.
And the resume.
Yes.
have those two by me.
Okay.
Just finally, the redacted version of the 3430 post is not marked. Could I have that marked as an exhibit now?
Okay. There was no objection, Mr. Brennan?
This was never marked as an exhibit. That's all.
Why don't we do that right now?
Exhibit 224.
So I would like us to be as efficient for these jurors as possible tomorrow. I'm not suggesting that today was a waste of time. Everything we did was important, but it's very difficult for the jurors to spend so much time back there. It seems that they're just about ready to get this case, and everything that we hear now is very important. So I don't think anybody wants the jurors to tune out at this point. So let's try and keep things moving along. Mr. Jackson, how long do you expect to be with Dr. Rentschler?
Hour and a half? 2 hours? I'm being corrected. 3 hours. 4? She has a better pace than I do. I don't watch my watch when I'm directing, but maybe it's going to be a whole thing. I mean, between us and cross examination.
So the judge is steaming towards a Thursday closings. That's what she's
So I
steaming
told you all the other day, I thought I might be in a position to regret giving you last Thursday off. And that's where we're at. So let's be as efficient as we can possibly be.
I promise you we are. It's a murder trial, Judge.
I understand.
Maybe not.
All right.
All right.
Okay. So, Mr. Jackson, do you expect that Dr. Rentschler will be the last witness that you call? Okay. On rebuttal, any idea how long that will be, Mr. Brennan?
I'd like to keep it to 2 hours.
Okay. All right, that would be for everything, including Dr. Wrench,
Sorry.
Dr. Welcher?
Dr. Welcher, and then the DNA, all those witnesses. I think it should be done in less than an hour.
All right, so will Dr. Welcher be called after the DNA people?
Trying to schedule that. I expect to call him last, but it all depends on when we can get the DNA people. And Dr. Welcher will be here tomorrow or tonight, so he'll be here. So whoever's, if they're available, I'd like to get the DNA people in first. But we haven't had confirmation on the flight.
All right, because I told Mr. Lessie that he could excuse himself from this testimony if there were other witnesses first, so that he can prepare once he gets the discovery from Dr. Welcher.
Thank you, Your Honor. Could we understand from the Commonwealth the name of the rebuttal witnesses we're talking about?
They were in the motion, right?
Well, we heard some different things at Sidebahhh. If something happened with Dr. Lope-Sada, they were going to be different. We heard that at Sidebahhh.
Oh, okay, so the motion that I allowed was Ms. Kuhn. I believe Dr. Gillespie's name was in there.
Hartnett.
And Ms. Hartnett. Okay.
So that's the excessive scope of Dr. Welcher, or the scope of the rebuttal witnesses for the Commonwealth.
Yes, I allowed the motion. Mr. Brennan says he's not calling Dr. Gillespie. Mr. Gillespie, right? Okay.
And nor Dr. Crosby. So I understand.
Or Dr. Crosby. Right.
That's what I,
Yeah.
I think there's.
Sorry, I know.
Well, it's important to know.
You're not calling their dog expert or your own, correct?
Not calling Dr. Crosby.
Okay.
The other item, Your Honor,
Commonwealth is not calling Dr. Crosby.
With a suggestion with regard to the curative instruction that was given to the court today.
Thank you.
We're going to come tomorrow with an ask to be heard on that. And we can,
Remember, I told you that curative instruction today wasn't good enough unless he's picking it up.
Before, I'm not so sure.
You asked me to change it, was my recollection, Mr. Lessie.
We looked at it at lunch, Your Honor, and appreciate the opportunity to confer with you on that. Don't want to keep the staff later today. But
And I don't want to keep the jury waiting, so file something with me and I'll take a look at it. All right. All right, so that's it. We expect to be ready to go when the jury's here tomorrow morning, probably no later than 9:15, 9:20, right?
Yes.
Okay, and we'll use a full day, as much of it as we can.
Yes.
Maybe a
Yes.
Thursday closing?
Okay, all right, thank you.
All rise for the court, please.
Okay, let me just tell you what just happened right there. All right, she wanted to know with scheduling. I have two questions though with regard to, I want to put them up here. What can be done about the obviously travesty of justice in this case? Well, let's see if the jury figures it out. What can be done? People of Massachusetts have to write to their legislatures, they have to write to the governor, they have to write to the attorney general. That's really what happens. I mean, we're seeing this absolute travesty. We're seeing these rulings, and you know, and she tries to cure them, which she probably does in terms of a court issue by saying, "Oh, I wasn't pressuring you. I wasn't. I just want to try to, you know, make good use of the jury's time," right? That's what she says. All right. So we know that the defense has finished Dr. Lope-Sada. Hank Brennan said he's only going to be 30 minutes with her. I anticipate he's not going to go towards her findings. He's going to go to some of the problems she had as a medical examiner in the state of Rhode Island, and a criticism by the feds and regarding a report of the fire at the nightclub, and some other criticisms in a case, because he kind of asked her about a case, if she remembers it, on voir dire. So I think that all that with regard to him, with regard to her, where Hank Brennan is going to go is he's going to try to impugn her and her qualifications and her expertise, especially since he's gotten all her stuff out of it. She can't say that she fell on that back concrete, which is where they were clearly going at the garage, on those steps, because that's why the photographs were disallowed by the PI. So she can't say that. That's when she talked about there being those irregular patterns that she saw. So you can't say that. She can't talk about dog bites. So basically 90% of what she was going to talk, and she can't say that that there's no wounds on John O'Keefe's lower legs consistent with the bumper. Okay, so she can't say any of that. Okay, she can't say any of that. So that's why her testimony is so short. So I assume, and since he's got all that out there, he's just going to go after her personally, and that's what we're going to see. Then the defense is bringing on Dr. Rentschler. He is Dr. ARCCA, the co-companion of Dr. Wolfe and ARCCA. Dr. Rentschler is the biomechanical engineer. He's going to talk about the wounds. The prosecution did file a motion. I was reading it I didn't read the whole thing. They want a lot of his PowerPoints out, including his discussion about Welcher. Well, that's why he's there, is to refute Welcher, right? This is the whole point of ARCCA testifying, not only what they said for the feds, but how they've been hired and said about Welcher. So she wants the jury to come in half an hour later. We're still starting at 9. Why she didn't do that all the time, or why she didn't have the lawyers come in a half an hour earlier, probably has to do with overtime and contracts, I guess, to deal with these issues. And then she blames them for Hank Brennan makes a critical, not a critical error, what I think is one that should have been a mistrial granted, makes that error, apologizes. They have to argue it. And then she says, we basically wasted a lot of time. And she blames the defense for these motions. She's the one who wanted the voir dire of Dr. Lope-Sada when there hadn't been a motion filed for a Dahlberg hearing. And then she basically turns a voir dire for what's called a limiting motion into a voir dire for a Dahlberg hearing, which is wrong. And then we now see that Hank Brennan then has rebuttal witnesses. He's not going to call the dog bite person. I guess that would leave open, I don't know. Well, certainly he should never have been qualified in the first place. But he is going to call Welcher back, and he's going to call 2 DNA people back, including the person who apparently is going to say there was pig DNA on the hoodie, and is going to talk about the lack of other DNA. We'll have to see. Maybe they'll talk about the fact that Hartman made the DNA cuttings on the hoodie that was so outrageously that Hank Brennan said he didn't know about. But he's calling his DNA people. So, I mean, take that for what you're worth if you believe that. You know, use your common sense that he didn't know about it. And then, thank you, Attorney Alessi. He wants to give the judge another a curative instruction, more than what she said today, because that wasn't good enough. It didn't go far enough. I don't know whether they thought of it themselves or they're watching social media. We've all said that what the judge said after Hank Brennan went there again with Dr. Wolfe was outrageous, okay? And that instruction the judge gave in passing, well, you just got to ignore it, ignore it, was not good enough. This was a major moment for a mistrial, and it was not good enough. Okay, it simply wasn't good enough. So I guess the Blue Man Group is coming in. She's steaming towards, she wants a Thursday closing, but you just heard something that she's sorry she gave the attorneys off last week. So I think she may be thinking that she won't get her Thursday closings because we're going to have all these people testify. Really, what should happen? The closing should be Monday with a fresh jury who has the weekend to rest and relax. Okay, so there was a lot happening. All of you were staying with me, all over 2,000 of you. I just tell you, it's so ridiculous. We posted on our @JusticeServed on X account and on my personal account @Kenney Baden, KENNEY our views of the disgrace that happened in this courtroom today here. As you know, Michael Bryant and I started this case. We were all, the prosecution has to prove it beyond a reasonable doubt. We call it like we see it. But today was such a tilting point for us that we've gone over the line. We've gone over the line and says the prosecution didn't prove, not only they didn't prove the case, with all the shenanigans, we only wish the jury could hear them, because they would never say that this would be justice either for John O'Keefe or justice for Karen Reed, because quite frankly, there's nothing but disorder in the court. So tonight, we will, let me see, Joanna, did I see your question about, no, I didn't. So I see, right, you see my questions about Higgins, should they bring him up to testify about the guy who's in the house? I don't think they should at this point, because then Hank Brennan's just going to use him to their witness. They heard that he destroyed his phone. He is, he's like the boogeyman, and they want to argue as a defense right now that the prosecution hid things from them. And I think that's what they want to say. You've seen it. The prosecution could have called the Higgins. The prosecution could have called Albert. The prosecution could have called the lead investigator. They chose not to. They're hiding from you. You've seen the conduct in this courtroom. You've heard it. You even heard the prosecution tell you supposedly mistakenly that that the holes in the back of John O'Keefe's sweatshirt or suggest could have been caused by the car, when they knew that in their files that those holes were caused by the cutting by the DNA specialist. So I think that that's what you have going on here. So I want to, before you all go, would you please go to our YouTube channel, Justice Served TV, hit the like and the subscribe button, please. We're trying to bring you everything we have. We are at 14,900, and let me see, I'll tell you in a second, specifically 922 subscribers. Let's get us to 15,000 overnight tonight. Okay, let's get us to 15,000 overnight tonight, because all of you have followed into this case and are really with us. And I see someone wants their question answered. Sweet New Yorker, Mara, I don't know what your question is, so I can't answer it. So you have to understand, we have questions going by quickly. And I can only grab some of the questions that go by and answer them without interfering with what's happening in the trial. So if you want to come to our show tonight, put a Q in front of your question, and we will then be able to take a look at it. But we just can't. I have two moderators on here working their tails off to bring you this case on very difficult circumstances when the streams go out and all. And so if you, I'll see if we can, so when will the closing be? I thought I just talked about that. We don't know when the closings will be, okay? There's your question. We don't know. The judge seems to indicate that she wants them on Thursday. She asked the jury whether or not they could be there on Thursday, because she had told them she was giving them a half day off. We don't know what the response from the jury was. And we just heard her say that she's upset now that she gave last week a day off on Thursday. And maybe she could have, because the rule, the hearsay was that we were hearing that she wanted the closings on Thursday. We're not sure the jury's available. We're not sure she could reach them. But that's why she's pressuring everybody, is how long you got to go, this jury's done. How long you got to go, this jury's done. How long you got to go, this jury's done. So they could be Thursday, they could be Friday, they could be Monday. Your guess is as good as mine at this point, depending on how long Hank Brennan takes to answer, to cross-examine people, including Dr. Rentschler. I think he said he needed 2 hours for cross-examination. He says he needs 30 minutes for the medical examiner, and God knows how long he needs to present Dr. Welcher again and the DNA evidence. So that was the rumor, that it was Thursday. It certainly looks like that's what she was trying. But apparently, we don't know if she's going to make it. But by Monday, we can be pretty much assured you're going to have closings, whether it be Thursday, Friday, or Monday. All right. So we are, I see Julie Del Rio, Karen the murderer is going to walk. The state has to prove their case beyond a reasonable doubt. If they do not, okay, then the state does not win. All right. It's as simple as that. Everybody wins when we uphold the Constitution. If you don't like how the state's proving their case, well, then go tell them that they didn't do a good job. But that's not our job to prove their case for them. It's not Karen Reed's job to prove their case for them. It's the state's job to prove their case for them. And they've spent a gosh darn load of money to try to do that. And right now they're failing. Why are they failing? Because they're not showing everything. They're not being honest. They would have been better off having Lowley try this case the second time, who has an honest persona and would have brought everything before that jury and let the jury decide. So if they can prove their case beyond a reasonable doubt, so be it. If they can't, both you, I, and everybody in the United States of America benefits from the United States Constitution. So I will say that. I will leave that here. Please go to Justice Served TV, like, share, subscribe our page. Please, back tonight, we'll have Dr. Priya Banerjee on. She's a board-certified forensic pathologist. She was on about a week and a half ago on our show. And we also have some really interesting guests with you. Somebody who's had a, shall we say, a run-in with one of the Alberts, and they're going to talk about their run-in with one of the Alberts tonight. You'll only see it on Justice Served TV, and you only know what about it if you come to the show tonight at 6. The thumbnail is up. We're going to portal into it. So portal away, everybody. Michael Bryant and I will see you at 6. In the meantime, as Michael Bryant would say, try to do the right thing, and I'll see you tonight.